Court officer.
Online appear ಆಗ್ತಿದ್ವಿ ಬಟ್ ನಾವು ಲಾಗಿನ್ ಆಗಕ್ಕೆ
ಹಲೋ ಹೇಳಿ ಮೇಡಮ್. ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ ಆ ಥರದ್ದೆಲ್ಲ ಡೇಟ್ ಹೋಗಿರುತ್ತೆ ಇವ್ರೆ. ನೀವು ಅಲ್ಲಿ ಬರೀರಿ ಲಿಸ್ಟೆಡ್ ನಾಟ್ ನೀವು ಆರ್ ನಾಟ್ ಏಬಲ್ ಟು ಅಪಿಯರ್ ಅಂತ ಬರೀರಿ.
ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೋದಾ?
ಸಬ್ಮಿಷನ್ಸ್ ಎಲ್ಲ ತಗೊಳ್ಳಲ್ಲ. ನಿನ್ನೆ ಲಿಸ್ಟ್ ಆಗಿರೋ ಮ್ಯಾಟ್ರ್ ಯು ಆರ್ ನಾಟ್ ಅಪಿಯರ್ಡ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಅಂಡ್ ನೌ ಯು ಆರ್ ಆಸ್ಕಿಂಗ್ ಅಂತಂದ್ರೆ ಅಂಥದ್ದೆಲ್ಲ ಸಬ್ಮಿಷನ್ಸ್ ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ಮೇಡಮ್, ತಗೊಳ್ಳಲ್ಲ ಇವ್ರೆ ಅಂಥದ್ದು. ನಿಮ್ಗೆ ಆ ಥರ ಇತ್ತು ಅಂದ್ರೆ ನಿಮ್ದು ಏನು ಏನು ಟೆಕ್ನಿಕಲ್ ಪ್ರಾಬ್ಲಮ್ ಆಯಿತು ಅದು ಬರೀರಿ, ಬರ್ದ್ಬಿಟ್ಟು ಕೊಡಿ ನೀಟಾಗಿ. ಫ್ರೆಶ್ ಅಲ್ವಾ ಸರ್? ಓಲ್ಡ್ ಎಲ್ಲ ಫ್ರೆಶ್ ಏನ್ ಬರ್ದಿದ್ದೀರಪ್ಪ? ಆಯ್ತಾಯ್ತು. ಓಕೆ ಓಕೆ, ಅದೆಲ್ಲ ಹೋಗುತ್ತೆ ಚೇಂಬರ್ ಅಲ್ಲಿ. ಆಮೇಲೆ ಯಾವಾಗ ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್ ಗೊತ್ತಿಲ್ಲ, ಯಾಕಂದ್ರೆ 3 ದಿನದೆಲ್ಲ ಬಂದಿದೆ. ನೀವು ಅಲ್ಲಿ ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳಿ, ಬಂದಲ್ಲಿ ಬುಕ್ಕಲ್ಲಿ ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ತೀವಿ ನಾವು.
ಸಬ್ಮಿಷನ್ಸ್ ಅಲೋ ಮಾಡ್ತೀವಿ.
ಏನ್ ನಿಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು?
64 ಇತ್ತು. 23135 of 26. 23135 of 26.
No representation in the month of September ಅಂತ ಹೋಗಿದೆ. ನೀವು ರೆಪ್ರೆಸೆಂಟೇ ಮಾಡಿಲ್ಲ, ಕೇಸ್
ಲಾಗಿನ್ ಆಗಕ್ಕೆ ಆಗಿಲ್ಲ.
ಅಂದ್ರೆ ನಮ್ಗೆ ಅದೆಲ್ಲ ಟೆಕ್ನಿಕಲ್ ಪ್ರಾಬ್ಲಮ್.
ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೋದಾ ಮ್ಯಾಮ್?
ಸಬ್ಮಿಷನ್ಸ್ ತಗೊಳ್ಳಲ್ಲ, ನೀವು ಬರೀರಿ ಮೆಮೊನಲ್ಲಿ. ಇದರ ವಿ ಕುಡಂಟ್ ಲಾಗಿನ್ ಟು ವಿಸಿ, ಹಂಗಾಗಿ ಅರ್ಜೆಂಟ್ ಇನ್ ದಿ ಮಂತ್ ಆಫ್ ಸೆಪ್ಟೆಂಬರ್ ಅಂತ ಹೇಳಿ ಎಲ್ಲ ಡೀಟೇಲ್ ಆಗಿ ಬರೀಬೇಕು.
ಮೆಮೊ ಫಾರ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಮೇಡಮ್.
ಬರ್ಬಿಟ್ಟು ತಗೊಂಡ್ ಬನ್ನಿ ಮೆಮೊ. ಸರ್,
ಮೆಮೊ ಫಾರ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಪ್ರೀವಿಯಸ್ ಅದು ಡಿಸ್ಪೋಸ್ ಆಗಿತ್ತು. ಸೊ ವಿ ಜಸ್ಟ್ ರಿಕ್ವೈರಿಂಗ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ 2 weeks ಅಂತ ಟೈಮ್ ಇದೆ ಫಾರ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಹೇಳಿಲ್ವಾ ಮೇಡಮ್?
ಅವರು 2 ವಾರ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಆಸ್ ಪರ್ ಲಾ ದೇರ್ ಇಸ್ ಟೈಮ್ ಫಾರ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ದ ಸೇಮ್. ಹಾಗಾಗಿ ನಾವು ಫೈಲಿಂಗ್ ಮೆಮೊ ಫಾರ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ನಾವು ಮೆನ್ಷನ್ ಮಾಡಿದೀವಿ ಕ್ಲಿಯರ್ ಆಗಿ.
ಅಲ್ಲ ಇವ್ರೆ, ಈ ಥರದ್ದೆಲ್ಲ ನಮ್ಮ ಮೇಡಮ್ ವಿತಿನ್ 2 weeks ಅಂತ ಕೊಡೋದನ್ನ ನೀವು ಇದು ಗೊತ್ತಿಲ್ಲ ಏನಾಗುತ್ತೆ ಬಂದು.
ಧನ್ಯವಾದಗಳು.
ನಾವು ವಿ ವಿಲ್ ಪ್ಲೇಸ್
ಸ್ಟೇ ವೇಕೇಟಿಂಗ್ ಟೈಮ್ ಬಾಂಡ್ ಇತ್ತು 1 year ಅಲ್ಲ 2 years ಆಯ್ತು.
ಆಯ್ತು ಕೊಡಿ ಸರ್.
ಬಿಫೋರ್ ಡೇಟ್ ಅಲ್ಲಿ ಮೇಡಮ್ ಆಗಸ್ಟ್ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಆಗಿತ್ತು, ಅರ್ಜೆಂಟ್ ಆಗಿತ್ತು.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ತಗೊಳ್ಳಲ್ಲ ಸರ್. ಎಸ್ಒ ಕೊಡಿ, ಎಸ್ಒಗೆ ಡೈರೆಕ್ಷನ್ ಇದೆ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವುದು ತಗೊಳ್ಳೋದಿಲ್ಲ.
ಡೇಟ್ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್ ಮಂತ್ ಆಫ್ ಆಗಸ್ಟ್ ಆಗಿತ್ತು.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅವ್ರಿಗೆ ಹೇಳಿ. ಫ್ರೆಶ್ ಅಂದ್ರೆ ಏನು? ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಏನು ಆಗಿಲ್ವಾ? ಆಗಲೇ
ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್ ಇನ್ ಮಂತ್ ಆಫ್ ಆಗಸ್ಟ್.
ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್
ಅಲ್ಲ, ಪ್ರೆಸೆಂಟ್ ಇದ್ರು ಮೇಡಮ್.
ಪ್ರೆಸೆಂಟ್ ಇದ್ದು ಆಗಸ್ಟ್ ಅಂತ.
ಆಗಸ್ಟ್ ಅಂತ ಆರ್ಡರ್.
ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿರೋದು?
9th June.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಆರ್ಡರ್ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಲ್ಲ
ಮೇಡಮ್.
ಎಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಪೆಂಡಿಂಗ್ June 29 ಬಂದಿತ್ತು, ಅವ್ರು ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ.
ಸರ್ ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡ್ರಿ ಸರ್, ಎಲ್ಲ ಮೆಮೋಸ್ ಇಸ್ಕೊಂಡು
ಸರ್ ಫ್ರೆಶ್ ಕಂಪ್ಲೈ ಆಗಿದೆ.
ಫ್ರೆಶ್ ತಗೊಳ್ಳಲ್ಲ. ಫ್ರೆಶ್ ನ ತಗೋಬೇಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಇದೆ. ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಕೊಡಿ. ಕಂಪ್ಲೈ ಆಗಿದ್ರು ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಕೊಡಿ, ಅವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್ ಇದೆ. ನಾಟ್ ಟು ಹೋಲ್ಡ್ ಈವನ್ ಫಾರ್ ಎ ಸಿಂಗಲ್ ಡೇ. ಆಲ್ ಕಂಪ್ಲೇಂಟ್ ಅಂದ್ರೆ
ಮಾತು ಈ తీసుకుంటారంట ಮೇಡಮ್. ಮೇಡಮ್ ಇದೊಂದು June 29 ಬಂದಿತ್ತು, ಆವತ್ತು ಸಿಟ್ಟಿಂಗ್ ಇರ್ಲಿಲ್ಲ. ಅದು ಡೇಟ್ ಅಸೈನ್ ಆಗಿಲ್ಲ. ಫ್ರೆಶ್ ಅಲ್ಲ, ನೋಟಿಸ್ ಆಗಿದೆ, ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ.
ಇದೊಂದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಂತಪ್ಪ, ಇನ್ ದ ಮಂತ್ ಆಫ್ ಆಗಸ್ಟ್ ಅಂತ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದಾರಂತೆ. ನೋಡಿ ಬರ್ತಾರೆ ಅಲ್ವಾ, ಅದೇನಾಗಿದೆ ಫೈಲ್ ಸ್ಟೇಟ್ ನೋಡಿ ಏನಾಗಿದೆ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಆಗ್ತಲೇ ಇದ್ದ ಆ ಥರದ್ದು
ಎಲ್ಲ ರೆಪ್ಲಿಕೇಶನ್
ಎಲ್ಲಿ ಮೇಡಮ್?
ಕೊಡಿ ಸರ್ ಅಲ್ಲಿ.
ಎಲ್ಲಿ
ಪೆಂಡಿಂಗ್
ಪೆಂಡಿಂಗ್?
ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ನೀವೇ ಹೇಳಿದ್ರಲ್ಲ. ಅಲ್ಲಿ ಎಷ್ಟೋ ಕೊಡಿ, ಎಷ್ಟೋ ಫೋನ್ ಮಾಡಿದ್ದೀನಿ.
ಇದೊಂದು ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿತ್ತು.
ಹಾ.
ಮತ್ತೆ 29 ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು, ಜೂನ್ 29. ಅವತ್ತು ಸಿಟ್ಟಿಂಗ್ ಇರ್ಲಿಲ್ಲ, ಡೇಟ್ ಅಸೈನ್ ಆಗಿ.
ಮೇಡಮ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಾ?
ಮೊದಲು ಕೊಟ್ಟಿದ್ರು, ಅವತ್ತು ಸಿಟ್ಟಿಂಗ್ ಇರ್ಲಿಲ್ಲ. ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅವರು
ಮಾಡ್ರ್ ಆಗಿಲ್ವಾ ಸರ್?
ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಆಗಿಲ್ಲ.
ಮತ್ತೆ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ಸ್ ತಗೊಳಲ್ಲ ಮೇಡಮ್. ಎಂಟ್ರಿ ಆರ್ಡರ್ಸ್ ಇದ್ರೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ವೈ ದೇ ಆರ್ ಅಗೈನ್ ಅಂಡ್ ಅಗೈನ್ ಲಿಸ್ಟಿಂಗ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್.
ಇದು ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆಗಿತ್ತು, ಅದು ಫೈಲ್ ಮಾಡಿದ್ವಿ.
ಸರ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಬಿಡಿ, ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗುತ್ತೆ. ಅವ್ರು ಪೋಸ್ಟ್ ಆಗೋವರೆಗೂ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗುತ್ತೆ. ಗೊತ್ತಾಯ್ತಾ? ಎಂಟ್ರಿ ಅಂತದೆಲ್ಲ ಹೇಳ್ತೀನಿ, ನಾನೇ ಹೇಳ್ತೀನಿ. ಅಥವಾ ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಪ್ರಾಬ್ಲಮ್ ಇದ್ರೆ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಏನಾದ್ರು ಲಿಸ್ಟಿಂಗ್ ಮಾಡ್ಬೇಕು ಅಂತಂದ್ರೆ ಬೇಕಾದ್ರೆ ಮಾಡಿಸ್ತೀನಿ. ಕೇಳ್ಕೊಂಡ್ ಬನ್ನಿ. ಫಸ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಸರ್.
ವಕಾಲತ್ತು ಹಾಕಿದ್ದಾರೆ.
ಅದೇನೆ, ಈಗ ನೀವು ಅಲ್ಲಿ ಫಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಆಗಿದ್ಯಾ, ಏನ್ ನಿಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್, ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ಬಿಟ್ಟು ಬನ್ನಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಎಸ್ಒ ಸರ್, ಎಸ್ಒ ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಆಫ್ ದಿ ಸ್ಕ್ರೂಟನಿ ಬ್ರಾಂಚ್, ಅವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್ ಇದೆ ಮೇಡಮ್ದು. ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಹಾಕಿದ್ರೆ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಹಾಕಿದ್ರೆ ಅವ್ರಿಗೆ SOP ಇದೆ. ಎನಿ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಟು ಬಿ ಪ್ಲೇಸ್ಡ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ವಿತಿನ್ 10 days ಅಂತ ಅವ್ರಿಗೆ ಹೇಳಿ. ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಹೇಳಿ, ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀವಿ ಸರ್, ಪುಟ್ ಅಪ್ ಮಾಡಿ ಅಂತ ಅವ್ರಿಗೆ ಹೇಳಿ.
ನಾಳೆಗೆ ಬೇಕಂದ್ರೆ
ಸರ್
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ನಾಳೆಗೆ ಬೇಕಂದ್ರೆ
ಅದೇನೆ ಸರ್, ನೀವು ಹೋಗಿ ಕಂಪ್ಲೈ ಮಾಡಿ ಸರ್. ಕಂಪ್ಲೈ ಮಾಡ್ಬಿಟ್ಟು ಕಂಪ್ಲೈನ್ಸ್ ಎಲ್ಲ ಆದ್ಮೇಲೆ ಸೆಕ್ಷನ್ ಆಫೀಸರ್ಗೆ ಹೇಳಿ, ನಾಳೆ ಅರ್ಜೆಂಟ್ ನನಗೆ ಬೇಕು, ಅದು ಪ್ಲೇಸ್ ಮಾಡಿ.
ಅವರು ಮೆಮೊಲ್ದೆ ಸ್ಕ್ರೂಟಿನಿನೇ ಮಾಡ್ತಿಲ್ಲ.
ಯಾರು?
ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ
CPC ನಲ್ಲಿ ಹಂಗ್ ಮಾಡಲ್ಲ ಇವ್ರೆ. ನಮ್ಮ ಮೇಡಮ್ ಡೈರೆಕ್ಷನ್ ಇದೆ, ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಡೈರೆಕ್ಷನ್ ಇದೆ, ಅವ್ರಿಗೆ ಹಂಗ್ ಮಾಡಲ್ಲ.
ಇಲ್ಲ ನಿಜವಾಗ್ಲೂ
ನೋಡಪ್ಪ, ಮೆಮೊ ಇಲ್ಲ ಅಂದ್ರೆ ಸ್ಕೂಟಿನೇ ಮಾಡಲ್ಲ. ಯಾರು ನಿಮ್ ಕೇಸ್ ವರ್ಕರ್ಸ್ ಅವ್ರಿಗೆ ಹೇಳಿಯಪ್ಪ, ಮೆಮೊ ತಗೊಂಡೋಗಿ ಕೊಡಿ ಎಷ್ಟೋದೆ. ಅಲ್ಲಿ ನೋಡಿ ಇವ್ರಿಗೇನೋ ಸ್ಕೂಟಿನೇ ಮಾಡಲ್ಲ ಅಂತಾರಂತೆ ಅವರು. ಅದಕ್ಕೆ ಇವಾಗ ಅದು ನೋಡಿ, ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ಪ್ಲೇಸ್ ಮಾಡಿದ್ರು. ಯಾರು ಹೇಳಿದ್ದು ಸರ್ ನಿಮ್ಗೆ ಸ್ಕೂಟಿ ಮಾಡಲ್ಲ ಅಂತ? ಯಾರು ಹೇಳಿದ್ದು? ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಕೊಡಿ.
ಆಯ್ತು, ನಮ್ ಕ್ಲರ್ಕ್ ಫಾಲೋ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅರ್ಜೆನ್ಸಿ ಪ್ಲೀಡ್ ಮಾಡಿ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿದ್ದೆಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ತೀವಿ ಕೊಡಿ.
ಅಲ್ಲಿ ನಾ ಕೊಡ್ತೀನಿ, ನೀವು
ಇವ್ರೆ ನಮ್ಮಲ್ಲಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಮಾಡಕ್ಕೆ ಮೇಡಮ್, ದೇರ್ ಇಸ್ ಎ ಸ್ಟ್ರಿಕ್ಟ್ ಡೈರೆಕ್ಷನ್ ಫಾರ್ ಮೀ ನಾಟ್ ಟು ಟೇಕ್ ಫ್ರೆಶ್ ಮೆಮೋಸ್. ಆಸ್ಕ್ ದ ರಿಜಿಸ್ಟ್ರಿ ಟು ಪೋಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆಸ್ ಸೂನ್ ಆಸ್ ದೇ ಕಂಪ್ಲೀಟ್ ದಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ ಡೈರೆಕ್ಷನ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ನ ನಂಗೆ ತಗೊಳಕ್ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಇಲ್ಲೂ ಹೇಳಿದೀನಿ, ಹೋಗಿ ಕೊಡಿ.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
230 ಮೆನ್ಷನ್ ಸರ್. ಹೇಳಿ, ಮೂವ್ ಮಾಡಿದ್ರೆ ಮೆಮೋಸ್ ಬರುತ್ತೆ ಇದೆ. ಅಲ್ಲ ಸರ್, ಮೆಮೋಸ್ ಎಲ್ಲ ಪ್ಲೇಸ್ ಮಾಡಿದೀವಿ, ಮುಂಚೆ ವೇಟ್ ಮಾಡಿ ಅದೆಲ್ಲ ಬರುತ್ತೆ. ಇದು ಮೆಮೋಸ್ ಮೊನ್ನೆಯಿಂದ ಪ್ಲೇಸ್ ಮಾಡಿರೋದು ಮೇಡಮ್ ಮುಂದೆ. ಅನ್ನೋದಿಲ್ಲ ನೋಡಿ ಸರ್, ನೀವು ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ರಿ ನಿಮ್ ಮೆಮೊ ಏನಾಗಿದೆ ಬುಕ್ಕಲ್ಲಿ ಎಂಟ್ರಿ ಇದೆ ನೋಡಿ, ಅದ್ ನೋಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಕೊಡಿ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದೀರಾ ಸರ್ ಎಲ್ಲ ರೀಸನ್?
ಮೇಡಮ್ ಇದು R1 ತೀರ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲೇ ಸ್ಕೂಟಿ ಮಾಡಿ ಇನ್ನೊಂದ್ಸಲಿ
R1 ತೀರ್ಕೊಂಡಿದ್ದಾರೆ, ವೆಕೇಟಿಂಗ್ ಆಫ್ ಎಂಟ್ರಿ ಮಾಡಿ.
R1 ತೀರ್ಕೊಂಡಿದ್ದಾರೆ, ಅದೇ ಅವರು
ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ವಿ, ಕೋರ್ಟ್ ಮುಂದೆ ಬರ್ತಾ ಇಲ್ಲ.
ಹೇಳಿ, ಏನ್ ಮೆಮೊ ಫ್ರೆಶ್?
ನಾನು ಅದೆಲ್ಲ ಇಡಬೇಕು ಅಂತ ಲೆಟರ್ ಹಾಕ್ತೀನಿ, ಕೊಟ್ಟಿದ್ದೀನಿ.
ಹಿಯರಿಂಗ್ ಆನ್ IA ಫಾರ್ ವಾಟ್?
ಒಂದು ಮೀಟಿಂಗ್ ಮಾಡಿ ನೋಟಿಸ್ ಕೊಟ್ಟು
ಮೇಡಮ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ರೀಚ್ ಆಗ್ಬೋದಾ?
ಹಿಯರಿಂಗ್ ಆನ್ ಇಂಟರ್ಲಾಕ್ಟರಿ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ವಾಟ್? IA ಫಾರ್ ವಾಟ್ ಅಂತ ಬರಿಬೇಕು ಇವ್ರೆ.
ನಾವು ಹೇಳ್ತಾ ಇದ್ದೀವಿ,
ಬರ್ಬಿಟ್ಟು ಕೊಡಿ
ಮೇಡಮ್ ಅವರೇ.
ಕೊಡಿ ಸರ್.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ರೀಚ್ ಆಯ್ತದ?
ತಗೊಳ್ಳಿ, ಅಲ್ಲಿ ಬರ್ದವ್ರ ಅಂತ ನೋಡಿ. ಏನು ಸರ್ ಅದನ್ನೇ ಬರಿಬೇಕು. ಡೆತ್ R2 ಡೆತ್ ಆಗಿದ್ದಾರೆ, ಬರ್ದಿದ್ದೀರಾ? ಮತ್ತೆ ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕಲ್ಲ ನೀವು. ಬರೀರಿ ಅಲ್ಲಿ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅನ್ನ ಏನ್ ಹಾಕಿದ್ದೀರಾ? ಡೆತ್ತಾ? We have reported the death and filed the memo and not posting ಅಂತ ಹೇಳಿ.
ಹಳೇದು ಆಗ್ತಿದೆ.
ಏನ್ ಹೇಳಿ?
ಎರಡೂವರೆ ಬರ್ತಾರೆ.
ಇವ್ರೇ ನಮ್ಮ ಆ ಥರದ್ದೆಲ್ಲ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ ಲಿಸ್ಟ್ ಆಗಿದ್ದು ನೀವು ಬರ್ದಿದ್ದೀರಾ? ನೆನ್ನೆ ಲಿಸ್ಟ್ ಆಗಿತ್ತು
ಅಲ್ಲ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋದು ಇಲ್ಲ ಆದ್ಮೇಲೆ.
ಏನ್ ಬರ್ದಿದ್ದೀರಾ? ರೀಸನ್ ಫಾರ್ ನಾನ್ ಅಪಿಯರೆನ್ಸ್ ಆನ್
ಯಾವುದು ಇಲ್ಲ ನಾಳೆಗಿದೆ ಏನ್ ಮಾಡ್ತಾ ಇಲ್ಲಲ್ಲ. ಆರ್ಡರ್ಸ್ ನೀನು ಆರ್ಮೇಡ್ ಮಾಡು. ಆರ್ಡರ್ಸ್ ಹೋದ್ರೆ ಬರೋದಿಲ್ಲ. ಒಂದು ಏನ್ ಗಂಗಾಧರ್ ಅಂತ ಹೇಳಿ ದಾವಣಗೆರೆ 4-5 ಏನ್ ನೋಟಿಸ್
ಅರ್ಜೆಂಟ್ ಟು ದಿ ಮಂತ್ ಆಫ್ ಸೆಪ್ಟೆಂಬರ್ ಅಂತ
ರಿಮೈಂಡ್ ಮಾಡಿ ಅದನ್ನ ಮಾಡ್ತಾ
ಇನ್ ದ ಮಂತ್ ಆಫ್ ಸೆಪ್ಟೆಂಬರ್ ಅಂತ
ಹೋಗೋರ್ಗಷ್ಟೇ
ಬುಕ್ಕಲ್ಲಿಲ್ವಾ ಅಪ್ಪ ಇದು ಮೆಮೋ? ಯಾವತ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಸರ್ ನೀವು? ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದು ಎಲ್ಲ ರಿಜಿಸ್ಟರ್ ಆಗಿದ್ದು ಬರುತ್ತೆ ಇರಿ ಸರ್. ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದು
ಮನೇಲಿ ಇರಕ್ಕಾಗಲ್ಲ. ಬೆಳಿಗ್ಗೆ ಇದ್ರೆ ಏನ್ ಮಾಡೋದು ಎಂತ
ಸರ್ ತಗೊಳ್ಳಿ ಬರ್ದಿದ್ದೀನಿ.
ಟಿವಿ ನೋಡೋದು ಅದೇ ಕಷ್ಟ. ಟೈಮ್ ಅದು ಬೇರೆ ಏಜ್ ಆಗಿದ್ದಲ್ಲ. ಬಿಜಿ ಅವರು ಮಾತಾಡೋದೇ
ಸರ್
ಮಾಡ್ರಿ ಸರ್ ತಗೊಳಲ್ವಂತೆ. ಅಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿ ಹತ್ರ ಹೋಗಿ ಸ್ಕ್ರೂಟ್ನಿ ಹತ್ರ ರಿಜಿಸ್ಟ್ರಿ ಅಲ್ಲಿ ಕೊಟ್ರೆ ಸೆಕ್ಷನ್ ಆಫೀಸರ್ಗೆ ಅವ್ರು ಅರ್ಜೆನ್ಸಿ ಸ್ಕ್ರೂಟ್ನಿ ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿದ್ರೆ ಅವ್ರು ರಿಪ್ಲೇಸ್ ಮಾಡ್ತಾರೆ.
ಅರ್ಜೆನ್ಸಿ ಬರೀಬೇಕಾ?
ಕೇಳ್ಬಿಡಿ ಇಲ್ಲೇ ಕೊಡಿ.
ಹೌದಾ
ಸರ್ ನೀವು ಎಲ್ಲ ಮೆಮೋಸ್ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ರೆ ಅಲ್ಲಿ ಒಂದ್ಸತಿ ಮೇಡಮ್ ಆಲ್ರೆಡಿ ಎಂಡಾಸ್ಟೆಡ್ ದೇರ್ ಇನ್ ಯುವರ್ ಮೆಮೋಸ್. ಫಸ್ಟ್ ಯು ವೆರಿಫೈ ಇಟ್ ಇನ್ ದ ಪೇಪರ್. ಅಲ್ಲಿ ಬುಕ್ ಅಲ್ಲಿ ವೆರಿಫೈ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಕೊಡಿ. ಡೋಂಟ್ ಗಿವ್ ಅಗೈನ್ ಅಂಡ್ ಅಗೈನ್ ಮೆಮೋಸ್. ಆಮೇಲೆ ಮತ್ತೆ ನಾನು ಮತ್ತೆ ಎಲ್ಲ ವೆರಿಫೈ ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೋಬೇಕಾಗುತ್ತೆ. ಫಸ್ಟ್ ನೀವು ಮೆಮೋಸ್ ಎಲ್ಲ ಫ್ರೆಶ್ ಮೆಮೋಸ್ ಎಲ್ಲ ಎಸ್ಒ ಸರ್ ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಅಲ್ಲ ಸ್ಕ್ರೂಟನಿ
ಮ್ಯಾಮ್ ನಾನು ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ ಸರ್.
ಬಿಡ್ರಿ ಅವ್ರು ಕೂಡ 1,00,000
ಇದು ಪ್ಲೇಸ್ ಮಾಡಿ ಸರ್. ಆ ತರದ್ದೆಲ್ಲ ಪೋಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ. ಅಲ್ಲಿ ಎಲ್ಲ ರಿಜೆಕ್ಟ್ ಆಗ್ತಾ ಇದೆ. ಅಲ್ಲಿ ಮೆಮೋಸ್ ಎಲ್ಲ ರಿಜೆಕ್ಟ್ ಆಗ್ತಾ ಇದೆ. ನೀವು ಕೊಟ್ಟು ರಿಜೆಕ್ಟ್ ಆಗುತ್ತೆ. ನಿಮ್ಗೆ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ನಾಳೆ ಏನೋ ಕೇಸ್ ಜಡ್ಮೆಂಟ್ಗೆ ಎವಿಡೆನ್ಸ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ಅಂದಾಗ ಮಾತ್ರ ಆ ರೀಸನ್ ಮಾತ್ರ ತಗೋತಾ ಇದೆ. ಆ ತರ ಅಂದ್ರೆ ವೆಕೆಟಿಂಗ್ ನಮ್ಗೇನಿಲ್ಲ ಪ್ಲೇಸ್ ಮಾಡ್ತೀವಿ. ಅದು ರಿಜೆಕ್ಟ್ ಆಗ್ತಾ ಇದೆ. ನೋ ಅರ್ಜೆನ್ಸಿ ನೋಡಿ ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದು 25-30 ಮೆಮೋನಲ್ಲಿ 20 ಮೆಮೋ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಬರ್ದಿದ್ದೀರಾ ಸರ್? ಹೇಳಿ ಸರ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದೀರಾ? ಅರ್ಜೆಂಟು 39 ಅಂತ ನೀವು ಅವತ್ತು ಬಂದು ಕೇಳ್ಬೇಕಲ್ವಾ? ಅಲ್ಲ ಸರ್ ಹಂಗಲ್ಲ. ಲಾಸ್ಟ್ ನಿಮ್ಗೆ ಆ ಥರ ಎಲ್ಲ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಸಂಜೆನಲ್ಲಿ ನಾವು ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿನ ಕೇಳಿ ಡೇಟ್ ಕೊಡ್ತೀವಿ. ಅವಾಗ ನೀವು ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತಂದಾಗ ಹೋಗುತ್ತದು ಆಸ್ ಪರ್ ಬೋರ್ಡ್. ಅದೇ ಸರ್ ನಾನು ಹೇಳೋದು ರೀಚ್ ಆಗ್ದಲ್ಲ ಇರೋ ದಿನಕ್ಕೆ ಸಂಜೆಗೆ ನಿಮ್ಗೆ ಆ ತರ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಮಾಡ್ಬೇಕು. ನೀವು ನೀವು ಅಪ್ರೋಚ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಅದು ಆಸ್ ಪರ್ ಬೋರ್ಡ್ ಡೇಟ್ ಹೋಗ್ಬಿಡುತ್ತೆ. ಮತ್ತೆ ಹಿಂಗ್ ಮೆಮೋ ಕೊಡ್ತೀರಾ ಅದು ಮತ್ತೆ ನೋಡಿ ರೀಚ್ ಆಗಿ ಹೇಳಿ. ಫ್ರೆಶ್ ಎಲ್ಲ ಬರ್ತಿದ್ದೀರಾ? ಎಲ್ಲಿ ಬರ್ತಿದ್ದೀರಾ? ಅಲ್ಲಿ ಮೆಮೋ ಫೈಲ್ ಮಾಡ್ಬೇಕು. ನೀವು ರಿಜಿಸ್ಟ್ರೇನಲ್ಲಿ ಮೆಮೋ ಫೈಲ್ ಮಾಡ್ಬೇಕು. ಹಾಕಿದ್ದೀರಾ? ಫ್ರೆಶ್ ಎಲ್ಲ ಎಸ್ಒ ಸೆಕ್ಷನ್ ಆಫೀಸರ್
ಇದೆಯಲ್ಲ
Yes, 2:30.
2:30 ನೋಡಿ sir.
Yes, only urgency matters, all other memos to the court officer. Only 2:30 matters,
Sir,
no
ಎಲ್ಲ
other
memos
matters to be
ಕೊಟ್ಬಿಡಿ.
mentioned.
My leadership, matter for 2:30, my lords. It's a partition suit before the trial court, my lords.
Urgency.
My lords, it's been posted day after tomorrow for arguments, my lords. I am an impleading party in
Does
that.
this order pass?
My lords, this was 2 days ago, my lords. The trial court is taking it on a day-to-day basis, my lords. This is just
Yes.
giving 2 days. Kindly have it 2:30.
Tomorrow.
No, matter is already listed today. It's at serial number 12 and process number 2. So the said petition is rendered infructuous. But one observation has to be made.
That I can't make it now. I have to tell.
5 crores have deposited to take.
That I have to look at the file. No observations now.
My lord,
Yes.
at the Anekal court, my lord, from the past March till now, the orders have not been pronounced for an ION rent, my lord. Whenever I ask, make a submission.
No, you're only mentioning for 2:30. What is the urgency for 2:30?
Yeah, today orders is there, my lord, for one of the cases, and I have 4 cases there in the same court. For all the 4.
When did you file the writ petition?
Today morning I filed a
It will come. There is no urgency for taking a matter at 2:30. Yes.
My lord, vacating stay, my lordship.
Hmm?
Vacating stay, preliminary hearing, my lordship. In trial court ಅಲ್ಲಿ amendment applications ಆರ್ಡರ್ ಆಗಿರೋದು ಸ್ಟೇ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗಾಗಿ
What is that? You can't. Don't take the memo. Yes. Is it a 2:30 or else give it to the court officer?
Policies for the inconvenience. This matter may be had at 2:30 minutes.
Yes, 2:30. Anyhow, I'll take it up at 2:30 and dismiss it because matter is posted for judgment. I'll not do anything. Whatever it is, when it is a pronouncement, take it up at 2:30. Take that matter at 2:30. Yes.
List number 10. List number.
My lords, list number 2, serial number 25, my lords. The suit is of the year 2004, my lords. I'm only seeking your lordship's permission.
We'll see.
If you can
Yes.
have matter heard today, end of list, my lords.
You have to understand the kind of work the court has to, how the board is every day.
No, my lords,
So
bow
anyhow,
down
you're
my
waiting,
head,
please
my
wait
lords,
for
I'm
some
only
more time.
asking your lordship.
Call the list.
List number
My
1.
lord, list
One
number
list number 2, my lord.
execution proceeding. One submission. List number 2, serial number 30. These are those EMI pause matters, my lord, where the developer has not finished the construction. The matter has to be heard, my lord. Regularly, it has been adjourned. The batches are also.
You have an interim order.
Yes.
Then why should it be heard now?
The batches are all fixed on 10/8 by my lord. So this matter may
It is-
also be taken up along on 10.
Yes, post along with the batch, whatever the number.
My lords,
Execution petition.
serial, list 1, serial number 39, my lords.
Execution proceedings, my lords. So we should attachment of mobile property, which is hypothecated to the bank. Account is classified as NPM, lords. Even after providing the relevant documents, my lords, sale and attachment has been issued. Today they are attaching the property, my lords. Therefore, there is urgency. Order was
When did you
passed
file
on
the writ petition?
31st, my lords. Order was passed on 28th.
It's 2:30.
Great.
My lords, list 1, serial number 39, my lords, for
Whoever
settlement.
mentioning online, please wait. Once I complete, then I'll, yes. Huh? That is not an urgency at all. And I'm saying except 2:30, don't mention. Then why are you mentioning? No, give it to the court officer, I'll see. If anybody mentions in spite of me repeatedly telling, then I can't help it.
Sir.
Yes, out of the list matters, any.
For adjournment, my lord, serial number 7, my lord.
Just wait 1 minute.
Please.
Yes. Adjournments at the last I'll call. Yes, any other 2:30 matters? Yes.
Serial number 7 in the second list, my lord. That was after hearing the senior advocates on 6/4/2026. The matter was. That
In
is,
the course of the argument while granting interim order, Lordship, we the corporations, Your Lordship, understood that we are not filing the application for grant of permit till some certain period, Your Lordship. Then, Your Lordship, the coordinate bench, Your Lordship, passed the order to close the matter in month of June, second week. Thereafter, it was not posted, Your Lordship. So we moved the matter, Your Lordship. So the only the notification, Your Lordship, to granting the permit with the KSRTC, that they have challenged it, Your Lordship. A comprehensive area scheme, Your Lordship, provide the opportunity to.
Why am I hearing the argument now?
Your Lordship, kindly this one, because we have engaged a senior, because last date it was updated in the late, this one we could not contact. Your Lordship.
Fortunately, what advocates are not able to understand is about thousands of matters stays are granted.
Please.
Everybody wants the stays to be vacated. That is one challenge.
Please.
The other is every day 60 to 70 fresh matters are filed. Is it practically possible for the court in a GMCPC
We are
to
praying
deal with so many matters?
We are praying time minutes. We are praying for adjournment.
I appear for the impleading applicant in this
Serial
matter.
number?
7 in the second list, my lord.
List this matter on 18th of August.
One
also
submission,
required
Lordship.
that
Serial number.
Huh?
So that it reaches on that particular date can also be listed there.
No urgency for why it deserves the top of the list.
No, my lord, because it has been moved to today.
No.
My lord, list number 1, Your Lordship.
Anyhow,
Yes,
if any adjourned matter, if there is interim order, please extend.
My lord, serial number 66 of first list, Your Lordship. I am for the petitioner, Your Lordship. I inform the other side also, Your Lordship. Kindly 2 weeks time.
Your Lordship.
It is submitted that the land council has, the request of land council responded, list this matter in the month of October. Interim order earlier granted is extended.
Your Ladyship, there is no interim order, Lordship.
If no interim
Please,
order.
Lord. Except in the September, Your Lordship. Please.
Your Ladyship, one submission.
Serial.
List 1,
Serial number 109, my lord.
100.1. I am for the petitioner. My suit was
Serial number?
112.1.
Uh,
I am for the petitioner in this matter. It may be kindly heard, my lords, today because my suit was dismissed and I have to exercise my remedy accordingly once this court decides that matter. 112.1. It's coming under dismissal because.
If not there, it will come under dismissal.
My lords, I am appearing every day in 112.1. 112 is the respondent in my writ petition, my lords. So it is coming, it's tagged under
No, it is
that
on the
case.
maintainability.
Your Lordship.
It's on maintainability.
Yes, Your Honor. Well, I'll address, my senior would come and address the argument. It may be taken up today, my lord.
But the difficulty is I have to complete the other list. If everybody.
Subject to your
starting at
ladyship's
2:30,
convenience.
Whenever it comes, we'll see. Because now it is in the first list. Every day matters are adding. Accordingly, it will come. I can't help it. Yes.
My lords, list number 139, serial number 39, my lords, to report settlement, my lords. It has been amicably settled, my lords. Both the parties will report the settlement, my lords. List 1, serial number 39, my lords.
So what to do now?
Adjourn for 2 weeks, my lords.
This is matter in the month of September.
Please, my lords.
If my lord.
Huh?
Serial number 95 in first list and serial number 27 in the second list. Both are arising out of the same impugned order, my lord, sir. My
Millards, I am for the respondent. Let's kindly matter may be referred to mediation. Millards, we'll settle it out.
It's arising out of the suit arising out of for
it's a rent matter, Millards.
95 is on maintainability.
It is on maintainability. It is the petition filed by me, and the same impugned order challenged by them is at in list
Serial
number 2, serial number 27.
Maintainable.
That it has been maintainable.
Both the matter may be clubbed and Millards, mediation may refer.
Mediation will appear in the High Court itself, my lords, in
High Court mediation set.
Serial number 95 and
List 2, serial number 27.
27. It is submitted that the parties want to settle the matter. Refer it to the hence the matter is referred to the mediation. Party shall appear before the High Court Mediation Center.
Friday, my lords, this Friday.
On 7th.
With 6th. Serial number 109, my lord.
Or 7th, on 7th.
With my lords, my lords, kindly, serial number 93 in the first list, my lords. That's the matter was listed on Saturday, then Monday, then Tuesday, before the trial court.
It will list
before
September, October, November.
No, my lords,
that is not, don't tell those dates.
No, my lords, I'm talking about the matter before the trial court.
Let it be, let it be.
Well,
Now,
on a
when is it
day-to-day
coming?
basis, the matter is being taken up. For that reason,
Everybody comes to the court yesterday, today matter to be heard, tomorrow our interim order, day after tomorrow to be vacated. Is it possible?
well, that's the reason I did not mention it yesterday, my lords.
You
Today, my
can't,
lords,
you can't
since
mention it today also. It will have, whenever it reaches, I'll see.
lords, I may be given one liberty to mention the pendency of this matter before the trial court, my lords, because
Why should I give the liberty?
my lords, because
You are
the
always at
trial is
liberty.
proceeding,
You
my
are
lords.
always at liberty to tell the court. I am, because unless until court order will only speak, there is no other liberty.
The entire writ petition will become
Let it
infructuous, my
become.
lords.
I can't help it. Yes,
The
call the
rights of
Serial number 109, my lord. The regular counsel is not station, ma'am. Kindly have it Monday.
109 will not reach. You don't have to ask for it. Yes.
Your Lordship, serial number 110, my lord. The matter is posted for judgment. I have no objection to allow the writ petition, my lord. I am appealing for respondent number 1.
Matter was listed yesterday before the
No
trial.
prejudice will cause to the respondent if the writ petition is allowed.
Because my lords, if orders are passed today by the trial court,
No,
then the
I will not adjourn it like that. I'll pass the orders on the merits of the matter. Yes, next. No.
Serial number 110, my lord.
Withdrawal, Your Lordship.
Which
Item
one?
75. There's an objection raised by the registry on maintainability of a civil revision petition against a order refusing a 7-Eleven in a commercial.
The office has raised an objection with regard to maintainability. Then counsel the petitioner file a memo taking withdrawal of the writ petition with the liberty to file an appropriate petition accordingly. The writ petition memo is taken on record and dismissed as withdrawn with the liberty, and the appropriate application shall be filed within a period of 2 weeks from the date of receipt of the copy of the order. The registry shall return all the documents by keeping the copy of the same. Yes.
Serial
Your
number
Lordship,
38.
serial number 110, my lord.
Relating to court fee agricultural property situated within Bangalore city limit. We have it next week.
No, if you ask for, you have an interim order.
This is only regarding court fee regarding myself and the court. I am the plaintiff there, my lord.
You have a stay. Why should other side is already appearing?
I know that.
After granting stay, please don't ask. It has come in 38. If you want, I will adjourn it, but not extend the interim order. Yes.
Your Lordship,
Yes.
serial number 110, my lord. It is posted for judgment.
Serial number?
110.
Sir, serial number, your voice is not clear, sir. Please
110,
tell loudly.
110, your Lordship.
110.
What do you want?
I have no objection to allow the writ petition, my lord, because the no prejudice will cause.
Take it up 230. Yes.
List number 1 for being spoken to.
Your
Serial number
Lordship.
1.
Apologize. There's an inadvertent error in paragraph 4. Your Leadership may recall this was a petition filed, writ petition filed impugning an order of an interlocutory
I've
nature.
seen your in the chamber. They've showed me. I couldn't understand what
Your
is
Leadership,
what
I'll
is
just
wrong with the order.
recollect what had happened in court. The petition had been filed under 227, impugning an order on the basis of which an application for recall of a witness
Yes.
had been refused.
Hmm.
When the learned counsel for the petitioner had canvassed the argument on maintainability, because that's the preliminary objection that even the court and I had raised, they said that I had said that unless perversity is shown, 227 jurisdiction cannot be maintained. To which my friend responded that this is an order passed under section 17 and therefore is appealable under section 37 of the Arbitration Act.
Also.
In response to which I said, if you are contending that this is a 37 application, 37 appeal, then it has to go before the division bench of the High Court, which your Leadership recorded. Now what paragraph 4 records, it is submitted that the impugned
I
order
didn't
has...
say who submitted that.
Yes, that it ought to have been recorded that he has submitted that it's a 17 appeal.
Happened with this now.
No, the reason is, your Leadership, they have filed a fresh writ petition, misquoting or misconstruing this petition, this order, and stating that I have said it's a 37, and therefore it has to go before the division bench.
Please come. Matter is placed before this court. And the caption from being spoken to. Then counsel the respondent submits that. At para 4, the court has recorded that the order has been passed under section 17 of the Arbitration Conciliation Act. That appropriate remedy is an appeal under the act before the division bench. In the paragraph, it is not mentioned that it is a submission. Or will he say that?
Can I just suggest, your Leadership?
No, why will he say that the writ petition is not maintainable if it is
No,
a
no, no,
submission?
your Leadership, what it ought to have said, respectfully, it is submitted by the petitioner. that the impugned order has been passed under 17, in response to which respondent submits that the appropriate remedy is 37. That is what had transpired in court.
In paragraph 4.
It was also mentioned that it was before the division bench by the counsel.
Yes, in response to my friend's submission that if you are saying this is a 17 order, 37 lies before the division bench.
So my mentioning was that it is also
Paragraph
with
4,
section 17 minutes.
it is submitted that the submissions of the respective councils were not, it is a case that the first 2 lines in paragraph number 2 are the submissions of the learned counsel for the petitioner, and in response to that, the next 3 lines are the submission of the learned counsel for the respondent. However, there is no clarity in the order, hence they have come before this court. Hence the matter is before this, and they have moved the court. Considering the submission, paragraph number 4 shall be substituted as below. Learned counsel for the petitioner submits that the order has been passed under section 17 of the Arbitration Conciliation Act, and the writ petition is maintainable. In response to that, learned counsel for the respondent submits that the writ petition is not maintainable. The appropriate remedy is an appeal under the Act before the division bench, and the present writ petition is not maintainable. Office is directed to forthwith upload the corrected copy of the order.
I'm obliged.
Bill number
Apologies.
2, the judges for petitioner, Ramesh Gowda.
Ramesh, respondent in this
I'm
case.
for petitioner. My 7 Rule 11 application has been rejected by the trial court, against which I have preferred this revision petition. Your Lordship, kindly say the annexure D, internal page number 35 is my application, which is under order 7 Rule 11A.
What is the suit for?
For eviction. I am for defendant before the trial.
Defendant will only file application under order 7 to 11. Yes.
Your Lordship, there is my application under sections under order 7 Rule 11A for
the
want of
grounds?
cause of action.
Let's see your
Affidavit.
application.
Internal page number 36, which is the affidavit, Your Lordship. In para number 3, I submit that the entire averment of the plaint does not disclose any cause of action to file the suit. Further, the plaint does not contain any cause of action to file the suit and to approach
Let's
this.
come to the
court.
plaint.
Your Lordship, kindly see the plaint annexure B, internal page number 21. That is the plaint. And the 22, 23, 24, 25. Entire this plaint, Your Lordship, there is no class of the cause of action. And no date was mentioned on what date the first sue is occur. Your Lordship, kindly see
The
in the
defendant failed to comply with the demand made in the notice dated 4/3/2023. Cause
That is-
of action, that the entire, it's a bundle, it's a plaint is a bundle of facts.
That is
You can't
true.
look at the last column and say there is no cause of action.
Your Lordship,
It says if the defendant failed to comply with the demand notice and the notice dated 4/3/2023. That is a cause of action for him.
that is there, Your Lordship. Kindly see in internal page number 4 in the same plaint, Your Lordship.
Yes.
On what date the tenancy was commenced between the plaintiff and defendant, it is not mentioned. On what date it is not terminated, it
The
is also
ground,
not.
is it a ground that unless and until plaint is properly drafted, it cannot be there. The court will dismiss this case if
the
it is not
cause-
able to prove. That is not part of order 7 rule 11.
Your Lordship, this is all the data for the cause of action. He is issued the mere notice. That is not my case before this honorable court.
That is not according to the court.
Your Lordship, kindly see on what date he has the tenancy was
Action-
terminated.
Cause of action to file the suit for him arose as per the plaint on 4/3/2023. That is sufficient as far as order 7 rule 11, the provision which you are relying on for cause of action. And remaining other things, the plaint doesn't disclose, whatever other defects are there, that will be taken care of by the court during the course of trial. That you cannot say that there is no cause of action.
Para 12, I have stated, they have not met the demand or neither replied to my notice.
That is
Hence
there,
this
Your
suit.
Lordship.
Para
On
13,
what
I have
date the
detailed.
tenancy was commenced,
Para
there
13,
is
I
no
have
there.
detailed everything for the
That is-
necessary
that is-
On what
ingredients.
date the
Not cause
tenancy
of
is
action.
terminated?
That is not cause of action. What is a legal
He has to
notice?
terminate the tenancy by fixing the date, but there is no date, my lord.
Where is notice? Please, did you file the notice?
Para 11, I have
No,
said.
no, document. Where is the notice?
I have not filed the notice, my lord. but I
Without
will
even
produce-
filing the documents that are filed along with the plaint, how can you say?
Your lordship, in notice also it is not stated on. I'm for
Pass
perusal
on.
of this.
What I'm not able to understand is you can't go into the merits of the matter in an order.
Understand, Your Lordship,
Order
my-
7 to 11.
But
Whether
there is
the
a bare
plaint-
minimum
On
to
the
show the
base
cause.
of it, whether the cause of action is there. According to them, the cause of action is this.
Legal
Whether
notice-
it is a cause of action or not is on the merits of the matter. He has stated so. We will not go into the merits of that. No suit can be, if this is the way, every suit should be dismissed under order 7 to 11. You accept that you are the tenant, he is a landlord. He has issued the note, whether as per the procedure, whether he has issued notice or not, whether it has to be, you should be evicted or not, court will decide. Yes. The presented petition is filed.
I will withdraw this.
Yes. Enjoying the interim order from 2024
And the
onwards.
Honorable Court is not
kind of
interfering.
One aspect I would like to draw to this.
Your lordship
From
kindly.
the time I have filed the suit, they have not paid the rent. 2 years, 3 years.
Your lordship,
This is one more unreasonable request. In his writ petition asking for,
As soon as I filed the suit, they have denied the ownership and they
The
paid me the
memo-
check.
writ petition is dismissed as memo is filed, seeking to withdraw the
I
writ
will
petition. The writ petition
I
dismissed as
request for
withdrawn.
an early disposal in order, maybe time
your
bound.
lordship kindly see it.
When is this suit?
2023.
2023 suit early disposal. Yes. Next.
Till number 3.
Petitioner, my lord.
To
The
the
question is whether the,
office objection with regard
yes,
to maintainability
small
is
causes court
overruled.
has jurisdiction.
Yes, please come to the order.
Yes, your lordship.
What is the order?
Order is, this honorable court directed me to approach the execution court and establish my right, title and interest in the property
Where is
that
the
I am the
impugned order,
tenant.
page number?
That is page number, your lordship may kindly see, turn to. Your lordship may kindly turn to ink page 28.
Link page?
28. Your lordship got it.
Yes.
Para 4. Para 3. In the case of revisional petitioner that sees the legally wedded wife of Sri V. Sumermal, who was the original defendant in SC 295 of 2020. 4. After his death, the landlady, without including the present
What are
petitioner.
you reading? I'm not able to find it at page number 20. Page number 20 is internal page 7 of the
28,
order.
28. Ink page 28 and type the page 3 of the revision petition. Your lordship got it. 28 ink page. CRP 456 of 2022. Ink page 28, ma'am.
Yes. Why are we reading link page 28? That's an order in CRP.
Yes, CRP.
I'm asking the impugned order. Where is
No,
the
no,
impugned order?
I will read and how the court has.
That I'll understand. Please come to the impugned order. I'll
Yes.
read it and understand.
Then the court impugned order, your lordship will kindly turn to page 16. Page 10, type the page 10, para 16. The liberty granted by the Honorable High Court of Karnataka and CRP number 450 of 2022 merely permitted the obstructor to approach the executing court in accordance with the law, and same cannot be construed as declaration or recognition of any independent right in their favor. Gross violation of the order passed by this Honorable Court. The small causes court think they are the Supreme Court. Yes, see, with great respect.
We'll not go into all that. We'll
No,
see on the merits of the matter.
it is not in contempt of court.
I'm not into that. We'll see the merits of the matter.
Yes, The liberty granted by the Honorable High Court of Karnataka in CRP 4.
Court has rightly held. Liberty is
Then-
given to contest.
then-
Not
then-
that
then your lordship will
court
see-
has not directed the trial court to pass an order. Court was right in observing it.
Court, your lordship. The Karnataka Rent Act, Section 2 defines even a lady who is a widow or who is a divorcee, she will be treated as a tenant. Your lordship will say. Section 5 of the Karnataka Rent Act, succession inheritance, wife is the legal and lawful LR to be included on records. Your lordship will kindly see. Karnataka Rent Act.
Let's complete reading the order, Mr. Counsel.
Yes, my lord. Your lordship will kindly.
Not bits and pieces. Come to the reasoning part and read
Yes.
it.
Para 14, your lordship.
Para 7 we will read. From para 7
Yes,
we'll
ma'am.
read.
I will read this para 7. The learned counsel for the obstructor during the course of argument vehemently contended that after the demise of her husband, the obstructor has been continuously paying the rent to the decree holder, and in support of the same, she has produced certain documents reflecting transfer of amount to the bank account and decree holder. It is therefore contended that the acceptance of such rent amount by the decree holder itself probabilized and established an independent tenancy right over the execution scheduled property. This court has carefully gone through the entire material available on the record and considered the said contention. At the outset, it is pertinent to note that the tenancy pertaining to the execution scheduled property had already been terminated by the issuance of legal notice under Section 106 of the Transfer of Property Act, prior to the institution of SC 295 of 2020 itself. Therefore, on the date of filing of the ejectment suit, the dual relationship of landlord and tenant had already come to an end. Admittedly, the present obstructor is none other than the wife and legal representative of the original defendant tenant. In the absence of any independent lease deed, rent agreement, or any legally acceptable document showing creation or recognition of tenancy in an individual capacity, mere transfer of certain amounts to the bank account of the decree holder would not create or confer independent tenancy right upon the obstructor. Para 10. The document produced by the obstructor only disclosed that certain amount were transferred to the bank account of the decree holder. Merely because such amount were being received by the decree holder, it cannot be inferred that the decree holder recognized the obstructor as tenant. The law is well settled that even after termination of tenancy, the landlord may receive amount toward use and occupation charges or mean profit under protest without creating or reviving tenancy right. Para 11. It is also pertinent to observe that alleged payment was admittedly made through the bank transaction. Under such circumstances, there was no occasion or possibility for the decree holder to specifically endorse or mention that the amount was received under protest, unlike the case of issuance of the manual receipt. However, the conduct of the decree holder in prosecuting the ejectment suit, contesting the proceeding, and thereafter filing the present execution petition to recover possession clearly demonstrate that the decree holder never intended to recognize or continue the obstructor as tenant under him. Para 12. Therefore, viewed from any angle, the document relied upon by the obstructor relating to the payment of amount to the decree holder do not establish any independent right.
Yes, I have seen the order. Now you
No,
can make your
no, my
submission.
lord. I have produced the RTGS. My husband died. Who is there to be imputed as the legal heir? Wife. Wife has not been imputed. The landlord's son and my son who are fighting there, we are not in good relation. My son is not, he is living this separately. He is demanding the rights. They have colluded. He has not disclosed before the trial court that my mother is the tenant. My mother is having the legal rights. My mother is continuing the tenancy. RTGS has not been seen by the learned judge. Your lordship will see, is it not the duty of the trial court to record evidence? Section 47 says, in case of dispute, no, your lordship will see. Even suppose in case here, the petitioner or respondent died, and if I dispute that there is a dispute of legal heirs, then this honorable court will have no jurisdiction, direct the trial court to make inquiry under order 25. This honorable court allowed my CRP directing me to establish your right. My right is very independent, that I am the legal and lawful guide of Sumer, my husband. I am continuing the business. I produce the RTGS. And the trial court make mockery. No, no. The trial court never says that, yes, I am the wife, I am doing the business. Your lordship will see, GST, I am registered, I am paying the rent to the landlady. I have not been included as legal heir under Section 5 of the Karnataka Land Act. I am the lawful wedded wife. Even if a divorcee, wife will have the right of tenancy under Section 2N of the Karnataka Land Act. Whether I should be deprived of payment. I have filed the CRB. No, your lordship will say the learned judge make the fun of the Honorable High Court. Your lordship will see the point 2. The obstructed.
I've seen that.
No, I may be permitted to.
I've seen that.
Yes.
I read it.
No, my respectful submission is the trial court without conducting the inquiry. Section 47 say whether I am a legal right. No, this Honorable Court granted the stay. I have told that it was filed against my son and my son is not dependent. It is a collusive decree. And stay was granted by this Honorable Court. And His Lordship Shishananda has allowed my CRP. You prove your right and title interest. It does not mean that I am having full right title, means whether I am the legal and lawful wedded wife of the Subailman, point 1. Whether I am having GST, whether I am running the business, I am having 5 daughters. I have to perform their marriage. My son is claiming the rights. He colluded with the landlady's son. Both are evening. I don't want to disclose. He is claiming a right, a title. He is threatening me that I want right in the property. It does not implicate me as a party. Your lordship will kindly see is I am not entitled. No, I was not implicated as a legal act. And I came to know that after the decree was passed, immediately I filed the CRP, I got the stay. And this Honorable Court allowed me, you prove your rights, whether you are a legally lawful wedded wife. The trial court does not make any inquiry. Order 21, Rule 99, 101, the court duty bound. Court is duty bound to record evidence. Court does not see any documents, no GST. And the learned judge says, no, whether the stay has been granted. The other side was present before the court, no stay has been granted. Immediately you file pay process fee, immediately issues delivery warrant, again you sign the paper, whether any stay has been granted. So it is not your lordship will see, is I am not entitled. If the law, the trial court commits the mistake, does not give finding, the trial court, this Honorable Court, High Court directed the trial court to give finding whether I am in lawful possession, whether I am having right title or interest in the property. No, I have produced the GST certificate. I have produced the balance sheet. And she is reluctant to see the document without making any inquiry whether this order is sustainable. Is it not an erroneous order based upon the assumption and presumptions? What is the protection we give to the poor tenants? A rich person will manipulate if he files any suit.
Restrict your arguments.
No, that's what I am asking.
The court time is also important.
You
only make submissions on the legality of the matter.
Yes, your lordship. The court has not given any finding that I am the legal and lawful wedded wife.
Yes.
I am the LR of the Sumailmal after the death of my husband. Under Section 5 of the Karnataka Land Act, I am entitled serial number 1 spouse.
Yes.
Then Karnataka Land Act Section 5 says, if son or daughter who is not dependent need not be party, they will not be treated as LR. So he has made my son, knowing fully well that we are not in good condition. He is making galata, and they have not made me as a party. So my right way I should be disposed as your lordship. So the trial court was bound to record the evidence. The trial court has not recorded the evidence. And trial court is not aware that who is the legal ex. Your lordship will kindly see the just I will read just 2 sentence paragraph, your lordship.
I have seen the court said.
No, in para 14, in case relating to commercial tenancy, it is not mandatory that every legal representative of the tenant should be brought on the record. He says. Then, in para 18, consequently, the obstructor being only the legal representative of the deceased tenant cannot claim any better right title than the deceased tenant himself.
Was the judgment and decree questioned?
Huh?
Was a judgment and decree questioned?
Yes, my lord.
Judgment passed by the rent controller is questioned.
Question. I have filed the CRP that came to be allowed by His Lordship Shishananda in earlier sheets. What I have read the CRP.
Is
Huh?
that is not allowing your CRP.
No, that directed me to establish my right. The trial court.
Mr. Counsel.
Trial court.
Please, you have to answer my queries and I have to understand.
Yes, Your Lordship. But
to listen to the court.
my mind is disturbed because of the 3
No,
days. Even
don't
all
have
night I
disturb.
could not sleep. That why the poor widow is not getting
Please,
justice.
that's why don't take it to
No,
all the problems of your
I was
client to
completely
you.
disturbed, and even today I am. Yes, Your Lordship. I will give the answer to you.
An eviction suit is decreed.
Yes.
Any
Yes.
any appeal is filed against.
Yes, CRP I have filed. Against that order I have filed CRP. Yes, against
Is
that
it
order.
that order is judgment and the decree is set aside?
That's what I told. The learned judge said, you establish your right in the execution court that you are the legally and lawful wedded wife and continuing the business. I produce the documents. That is, your Lordship will kindly see the order passed by this honorable court. The trial court really, your Lordship will see the horrible situation in Karnataka. Neither they apply their mind. Your Lordship will see this is the order passed by this, His Lordship. Your Lordship got it. Page 26 in CRP 450 of 2022. The CRP is filed under section 18 of the Karnataka against pass in SC 295 of 2020 on the file of the second additional judge. The petition coming on this day on admission, this court made the following observation. The petitioner above name humbly submit that she was not a party in the trial court and no decree is passed against her. Wherefore, the petitioner prays that she may be permitted to contest execution petition, claiming her independent right in the hands of justice and equity. Copy of the memo is furnished to Sri Parasmal Jain, London advocate contesting for respondent. In the case of revisional petitioner, that she is the legally wedded wife of Sri V. Sumelmal, who was the original defendant in SC 295 of 2020. After his death, the landlady, without impleading the present petitioner, impleaded the son of the petitioner and obtained a decree of ejectment only against her son, and therefore her right is to be adjudicated. Para 5, if so, the present revisional petitioner, being the wife of V. Sumelmal, is entitled to file necessary application in the execution proceeding, establishing her independent right in respect of the petition property. With the liberty, the present division petition stands. So, my lord, should I become the victim of the?
Yes, heard reserved.
My respectful submission today, the warrant has been issued. And regarding the.
Pronounce the judgment on tomorrow.
No, I one respect. Regarding the maintainability of this office is
already. I have overruled that objection. Yes.
Yes. No, I want to bring to the honorable court. Order 150 is very clear. It does not give the right to the small cases.
I have already overruled that objection. Why are we wasting time on that? I have overruled the objection. Why do you want to argue on that?
No, one question I want to ask this honorable court. Why the poods are not getting the justice?
Yes,
Poor
next.
And widow,
Call the next matter.
No, with sympathy, your lordship will see.
Next, please call the next matter.
No, what about the warrant has been delivered?
Memo is filed seeking to withdraw the writ petition. Memo is taken on record and dismissed as withdrawn. Yes, 5. What is that?
Appearing for the section.
For the respondent.
He files a memo for disposal. What is it?
He filed a respondent as per 1 week time maybe to verify that.
What is that?
My lord, they had sought for challenging the impugned order dated 9/2, my lords, for issuance of 9/2/2026, my lords. For attaching the property for proclamation and selling of the same in the execution proceedings, my lords. Subsequently, my lord, before obtaining the interim order from this honorable court, my lords, the property has been auctioned and the auction purchasers have bought the property and the possession has been delivered and the execution is satisfied and it is closed, my lords. Hence, I have filed my memo for as the petition is infructuous, my lords.
I need to seek instruction.
Is it pretty? Yes. This is matter on Monday. By the time the will and counsel, the petition shall get instructions. Yes, next. You that letter?
Yes.
They produce the citation.
Please take that. Yes. A letter is addressed dated 25/7/2026 by the Principal City Civil and Session Judge Bangalore to grant 3 more months to dispose of the suit. A coordinate bench of this court has directed to dispose of the matter by order dated 3/8/2023 to dispose of the matter within 1 year, not later than 1 year from the date of receipt of the copy of the order. Citing various reasons, learned judge has sought for time. Considering the reasons stated, 3 months' time is granted for disposal of the case.
Till number 7, Islam Murthy.
For the
Yes.
respondent.
In this case also, the petition is, an order is passed in CRP number 112 of 2021, dated 27/8/2024, to dispose of the matter within 6 months from the date of receipt of the copy of the certified copy of the order. Various reasons are stated why the same could not be complied with and requested another 3 months' time for disposal of the case. Considering the reasons stated, another 3 months' time is granted.
Till number 8, Omkar.
Petitioner. The trial court has written the letter for extension
Yes.
of time.
Saying the petition is disposed of. Order dated 10/2/2025, directing the trial court to dispose of execution 402 of 2021 as expeditiously as possible, not later than 3 months from the date of receipt of the copy of the order. Our letter is addressed stating various reasons to grant 4 months' time to dispose of the case, considering the reasons stated. Another 4 months' time is granted. Yes, next.
Till number 9, Mohan Kumar.
Waiting for the respondent.
This also a letter is received. And the writ petition is disposed, WP number 31479 of 2025, is disposed of by order dated 7/1/2026. Allowed I number 5 and had provided an opportunity to adduce his evidence, and also directed to conclude and dispose the petition within a period of 6 months from the date of receipt of the copy of the order. Various reasons are stated why that could not be disposed, and sought for another 4 months' time. Considering the reasons stated and the request of the learned judge, another 4 months' time is granted. Yes, next.
Till number 10, Hima Kirana.
You for petitioner.
What is this report? Call for the order again, no, another petition proceedings period is the case of the petition in spite of an order. The court is not proceeding with the matter as well as within 1 year. As per the court order, when it has to be disposed of?
My lords, I produced the order, my lords, on 2/4/24. It should have
Timeline
been
is?
1 year, before 1 year,
So that would complete by this,
25. To 2/4/25, it should have been completed, my lords.
when this court is called for a report from the concerned court, a report is placed before the court stating that the first additional senior civil judge has pendency of around 3212 cases. The case file has been received with the first additional senior civil judge court on 25/10/2024. Owing to heavy pendency, repeated filing of the applications and due to the death of the parties and delay in bringing legal representatives of the deceased party on record, non-cooperation of the parties, it was not possible to dispose of the matter within the time limitation directed by the High Court. And all endeavors will be made in disposing the matter as expeditiously as possible. In this entire letter, the court is not able to understand when a time frame is fixed by the court, if for any reasons, if the court is not able to dispose of the matter, it is the duty of the learned judge to seek extension of time, which had expired in the year 2025 itself. Why there is no letter addressed till today, and why the letter is not addressed till today, seeking extension of time, is not known. The Registrar Judicial is directed to call for a report on this from the concern, call for a response from the learned judge on this matter on Monday.
Till number 11, Ravi HK.
Published.
The writ petition is disposed of on 29/7/2025, directing the court to dispose the matter within 9 months from the date of receipt of the copy of the order, and the order was received on 4/9/2025. And sought for, and giving various reasons, it could not be disposed of as stipulated by the court. Hence, requires another 2 months time. Considering the letter of the concerned judge, another 2 months time is granted for disposal of the case.
Cell number 12, preliminary hearing. Anusha L for petitioner.
We are for petitioner, my lords. My lords, the arguing
Notice
counsel is held up in another court.
Notice the respondents.
Notice me on the order.
Yes.
Please.
Cell number, that's come.
Let it go. It's a 25 matter, no urgency.
13, Aditya D.
The petitioner has filed this petition challenging the impugned order at Annexure A passed by the first appellate court, wherein the first appellate court has set aside the order of temporary injunction under Order 39 Rule 1 and 2 passed by the lower court. My lords,
it has come up yesterday.
My lords,
it was heard before.
Heard once before. My lords.
Why it is adjourned?
My lords had given time to take instructions. I had taken instructions regarding the same. My lords, basically the first appellate court has.
What instructions you were asked to take on the last occasion?
My lords, regarding the succession, my lords had made an observation according to para 17 in the Annexure A. The first appellate court had misconstrued our contention, stating that we are not liable for succession because it is a Muslim personal law. There is no concept of succession there. But our primary contention is the Hissa Patra at Annexure C, my lords, wherein the petitioner's mother has allegedly signed on the Hissa Patra. But she is an illiterate. She cannot read or write in English or Kannada. My lords, if my lords may see.
All that at the stage of IA, that can't be decided.
Please, my lords.
Whether she can write.
But my lords, on the prima face of it, my lords, at Annexure C, page number 43, it's not even a signature, my lords. She has written her name, allegedly written her name in capital letters.
A person who cannot, who is not well versed, generally they'll write the signature like Their name like capital letters only.
But it is written in English, my lord. She can't read or write in English. She can't even can barely
And
speak.
how you will establish it about it at this stage?
Please, my lords, with that view, the trial court had granted us a temporary injunction under RA 39 Rule 1, which is overturned, which is set aside.
Please come. Let's read the order at page para 19.
Page number 32, my lords.
Page 32, para 19.
In the instant case, the sale deed executed by the KSFC and the alleged partition deed reflects that the defendant number 1, that is the mother of the plaintiff, and defendant number 7 and 8 were absolute owner of the suit schedule property. Admittedly, the Issa Patra partition deed was executed on 14/11/2003. The said partition deed was not challenged either by the defendant number 1 or defendant number 7. Only in the year 2002, the present suit has been filed challenging the said partition deed. The plaintiff has not produced any document to show that the entire amount to purchase the suit schedule property was given by his father, late Abbas Mohammed Yaqub, and defendant number 1 and 7 were the only lenders. Further, admittedly, the defendant number 9 in the possession of the suit schedule property. It is the contention of defendant number 9 that there is a chowdhury in this suit schedule property, and she has to carry out necessary repairs to maintain the suit schedule property. But my lords, what has to be noted here is the petitioner herein was not born at the time, my lords, to challenge the sale deed. He only attained. He was not born during the time when the Issa Patra was executed. He is 23 years old now. This was executed 23.
What is the injunction sought?
Lords?
What is the injunction sought?
Injunction is sought seeking to restrain the defendant number 9 from alienating the property. Defendant number 9 is the subsequent purchaser. Defendant number 8 has sold the property to defendant number 9. Defendant number 9 is the respondent.
When was the sale?
Sale deed minutes. Uh, 28/8/2020 minutes. Immediately after it was challenged minutes.
28/8?
28/8/2020. It was registered on 19/1/2021.
Who sold the property to defendant number 9?
Defendant number 8, my lords, who we allege to have forced the signature of the defendant number 1 on the Issa Patra.
So admittedly, as per the document, your mother and 2 others are the owners of the property as granted by the executed by the KSFC.
That is also in challenge, my lords, because defendant number 8 has colluded with the KSFC officials and entered his name in the sale deed. Originally, it was meant to be allotted to defendant number 7.
Thing to be challenged, and everything has to be proved.
Please.
Please come. Then counsel for the petitioner submits that. Both the trial court has rightly considered the trial court. What is the order of the trial court? Where is the order of the trial court?
It's at Annexure F, my lords, page number 59.
It is submitted that both the courts have failed to appreciate the case of the defendant, case of the plaintiff. The trial court has rightly considered the facts of the case and rightly granted an order of injunction. However, the appellate court had reversed the order passed by the trial court. Trial court on extraneous considerations on the ground that that the sale deed executed by the KSFC and the alleged partition deed reflects that the defendant number one, that is the mother of the plaintiff, and defendant number 7 and 8 were absolute owners of the property. It is submitted that all those transactions are questioned and the matter is pending adjudication. In those circumstances, if in the meantime, if property is alienated and third party rights are created, it would cause a lot of hardship to the plaintiff considering the submission of the land counsel for the petitioner. There shall be the order of the appellate operation of the order passed by the appellate court is state. Notice to the respondents hand summons. Memo shall be filed by 25th of August, or else the stay granted by this court, the interim order granted by this court stands vacated. Yes.
14, Nay Kirti M. Publication.
Your Lordship, suit is for partition and separate possession with respect to scheduled property, Your Lordship. Initially, defendant number 2 filed the written statement and issues were framed after completion of the when matter is posted for the argument. He was passed away. His legal representatives were appear. Then, Your Lordship, they filed the application for the production of the certain documents, Your Lordship. When the matter is posted for those documents is irrelevant because in the lifetime of the D2, there in the
Come to the impugned order. Where is the impugned order?
Your Lordship, impugned order at page annexure G. There is a, Your Lordship, the issues were framed in the year 2017 itself. No reasons whatsoever assigned for the necessity of the documents. Now, based on those documents, court posted no reasons whatsoever assigned either in the affidavit or that how those documents were relevant in the partition suit. The
What is the document? Where is IA?
Your Lordship, in their application,
Page number?
annexure E, Your Lordship. Police complaint.
What is the document?
Those documents, Your Lordship, certified copy of the bank statement, copy obtained website Ministry Corporate Affairs, website.
Counsel of the petitioner submits that after the matter is posted for arguments, at the time an application is filed to receive certain documents, without even stating why those documents are necessary, why the petitioner wants to place those documents at this stage. And the court also, without recording any reasons, has allowed the application. Hence, the petitioner is before this court. Considering the submission of the land counsel of the petitioner, the operation of the order dated so and so, there shall be stay of operation of the order. Notice to the respondents hand summons, same date.
15, Chandrasekhar Swamy KP.
For petitioners. The petitioners have filed the suit for declaration to declare that the petitioners have prescriptive easementary rights to use the road.
IA?
IA.
What is IA?
IA to remove the bund and pond constructed by the respondents to obstruct the using of the road by the petitioners. That application was rejected by the both lower courts on the ground that during the rainy season, the petitioner cannot use the road. This road is the B part of land, government land. The respondents have no rights to obstruct this road. Even, my lord, the petitioner have referred the writ petition when the concerned taluk surveyor has given a report that the respondent number 1 to 10 have encroached the road, but he has not.
The order, come to the appellate court's order.
Okay.
Page number.
Page number, my lord, 295. Page number, in page number 295, my lord. Para number 28, my lord. May I read? Para number 28, my lord. The plaintiff filed a number 4 seeking to permit them to remove bund constructed by the defendants in the suit schedule C property, being the road, and the same is measuring.
No, we'll understand it. Order notice to the respondent. Because we have to understand what is it, what is your case, and the notice to the respondents, hand summons. If the hand summons are filed by 2nd of September, list the matter on 3rd September.
Achha.
Then number 16. Janardhan Ji.
Sir, 3 orders regarding all relating to appointment of a commissioner. The suit is for declaration and possession.
All the 3 matters?
All the 3 matters relating to appointment of commissioner only, filed at a different dates and subsequently.
So we are looking at the first matter.
First matter, 9th. And here it is relating to G. Lecture G2 is the order.
Page number, where is the order?
Yes, madam, I will not may kindly come to G2 at page 73. But before that, may I request order to kindly annexure it.
We'll just read the order and
Yes.
then we'll go to the other.
Yes. And kindly come to page 76.
76. Yes. Order starts at 75.
It means that it is the operative portion. No, the detailed order is in page 76. Not just one line is a date of hearing was there in the page 74. So I just 70. Yes, yes. Sorry. Yes. Madam, 75. I heard the counsel for the plaintiff and defendants on by year 26. This is an application filed by plaintiff in section 151. CPC requesting the court to recall the order dated 23/8/24 in terms of the earlier order dated 5/10/2018. The counsel for the plaintiff has argued that as per the order dated 5/10/2018, the court commission was appointed. Due to unavoidable circumstances, commission work was not completed. The court, while its order dated.
So you have questioned all these orders, 23/8/2024, 26/11/2025, and 27/1/2020.
Yes.
Now.
Not all the orders here. That did challenge.
No, that's what I'm saying. Because the court said you have not questioned the earlier orders, now you have questioned.
No, madam. I have filed in a single petition. That I filed a single petition. The office raised the objections. There are 3 orders.
No. What are the dates of the orders?
Yes, madam. This was filed in this petition. It was together. It was filed not earlier. Earlier it was not challenged, but only after this.
Saying an order of 24,
Yes,
an order of 25, an
they are
order
all
of 26.
challenged together. Not some. Earlier it was not challenged. Earlier it was not challenged. They are all challenged together, madam, in this writ petition.
So how can you question an order of 24, 25 now? Because there is no limitation.
But what happened is, but kindly
Because you
see.
have proceeded with the matter, having accepted the order of the court.
Not that matter. What happened is, kindly come to, may I request to kindly come to page 40, page 42.
Yes.
What happened is, the matter was, after the evidence was closed from both the sides, the learned judge posted the matter for judgment. And kindly see, at that point of time, the learned judge has come to the conclusion a court commissioner is necessary to take the encroachment portion by appointing a commissioner and to get a report before proceeding with the matter. Then, my lord, he has posted the matter accordingly instead of passing the judgment. But this is the order. Kindly see, the suit is filed by plaintiff for the following relief. Declared that 7 feet east to west, 20 feet north to south to the western portion of plain visual property belongs to the plaintiff by virtue of the absolute sale deed dated so and they are the absolute owner as well as they are entitled the 10 feet road C scheduled property to the western portion of the property scheduled property by virtue of the sale agreement and power of attorney and registered sale deed. To grant decree directing defendant to hand over the vacant portion of land shown in red color.
This is order dated 5/10/2018.
Yes, ma'am. Yes. But this
By that time itself, the case is posted for judgment.
on that day itself, the land, after hearing both the parties, posted the matter for judgment. But on
From 18 to
yes,
26.
ma'am, that is true, ma'am. And on that day, what happened, ma'am? The land judge felt that necessary to get a report from commissioner. Accordingly, he has page 43, he has ordered to appoint a commissioner. But thereafter, unfortunately, we can't blame the court, or we can't find any fault with the court. But fact remains is she was frequently the advocate went on changing some reason we don't know. I'm not able to say the reason. Anyhow, whenever the advocate used to change on 2 to 3 times, lost the track and they filed the application on a misconception. It was only this order, on the basis of this order, they could have requested the court explaining the reason to reconsider and pass with the commission.
This order is passed. After that, what happened?
After this happened, what happened, Brad? IA 6 was filed, Brad, in the same.
Then this order is not acted upon.
It was not, the steps were not taken to appoint a commissioner.
Then what happened?
And then, Brad, kindly come to IA 6 was filed. Brad, may I request order to kindly come to next page 45. This is where by misconception this application is filed. No doubt, Brad, there is a lapse on the part of the plaintiff. By filing. This is another application is filed on 25/10/25, page 45.
Yes.
But this application say court that what they say is the please to appoint a commission for local integration. It is in terms of this sample court, the earlier order, the previous order, Annexure D. That is stated so and so. It is stated
in this application. You don't even say about earlier order.
It is stated, but it is stated that earlier it was.
Where is it stated?
Yes, I state that the.
It is not stated.
I'll just 1 minute. Yes, but it is not refer. It is not refer.
This order passed on this IA.
On this IA, they kindly come to page. It is passed on. On 4/12/2025.
Page number?
Page number 52. 26/11/25.
It clearly shows how the party is pursuing the matter.
That is true, Milad. That's why I said because of the frequent change of counsel, I don't know if they lost the track or some misinformation.
No, the first order is 25/10/2025. Second application order is 26/11/2025.
Yes. Thereafter, Milad, an application. This order has been passed on 26/11/25. That the land judge has said that the detailed order in page reasons at page 54, para A.
He also doesn't look at the earlier order.
Right?
He also doesn't.
He looks at.
Let's see.
Page 54, para 8. It is worth to note here that as per the order, para 8. 5/10/18 itself, court commission was appointed and thereafter matter repeatedly adjourned for nearly 6 years and no proper steps taken. Plaintiff to furnish correct address to the court commissioner. 23/8/21 matter posted for argument. 26/11 application filed by defendant were allowed. PW1 recalled for class examination. Even after sufficient opportunity, PW1 not tender for class examination. It is to be noted that her order as per 38/2018 class of PW1 taken nil, as PW1 not tendered class examination, and already matter has been adjourned by 6 years given sufficient opportunities. Take him to the plaintiff.
I think this is a case where no intervention is.
I only make a request. Not this. No doubt there is a lapse, completely lapse on the part of the plaintiff. But only one reason she could give before this court is that the counsel's earlier appearing not abruptly retired. Reason I could not able say, because I could not
No, very
find out.
strange.
Then,
No. 2018 matter which is
no doubt
reserved for
true.
judgment
That is
till
true.
2026.
I do agree.
So that means the plaintiff has no intention to take this matter to this case to a logical end.
Kindly see, that certainly it gives an impression or you could gather from the orders and other things. But only thing is, I only request is that it's a substantial right is involved. Her property has been encroached and right has been blocked. But keeping in that, if because now the matter is post for argument.
Why did she not subject herself to the cross-examination till now? And why should the court do
the
something?
advice from the what happened, the recalling and the things she should have been present for the tender for further class exam, because earlier the evidence was over at the earlier stage. Thereafter,
No, but now a party who has not subjected
No doubt,
herself
I am
to
not,
cross-examination, why
certainly.
should the other evidence be looked into? Why should the other evidence be looked into when you don't even enter into the witness
That
box?
is true, That is true, I completely agree with the court. But
Not a
one
case,
thing
not
is,
a case for
I
indulgence.
only want one request. Kindly see that when the party substantial rights are there, that court may take a little.
Court, the party substantial right, party should be considered, but should have
just
a mindful of that, not the court.
That is true. That is why now ultimately she is before the court requesting one more opportunity is lost. That any terms you not make any condition.
It's not a case at all for terms.
And I only because this is only because otherwise now it is a stage of argument.
Let
If
it go on,
goes
let
for-
it go on and let it be concluded and let her face the consequences of it. She wasted judicial time of how many years?
No doubt not intentionally, but some the way changing of the council or something, I don't know how it could causing trouble to her. It's may cite one.
Any judgment? Please
Yes.
cite the judgment and I'm going to dismiss it. Yes.
But I only request, I am not finding fault with any court, but I only requesting the court to take
In the
little
facts and
lenient-
circumstances,
Yes.
no
Certainly,
indulgence is
I
required.
am no words to say, I am not
Yes.
finding any.
Yes. Which paragraph?
Para 28 and 29, just two lines.
Para
are-
28 and
28 and 29, page 495.
Yes.
Just all the rules of procedure are handmade of justice. The language employed by the draftsman, so and so and so, stringent. But the fact remains that the object of prescribed procedure is to advance the cause of justice. In the adversarial system, no party should be arbitrarily be denied the opportunity of participating in the course of justice dispensation unless compelled by express specific language. The statute, provision of CPC or any other procedure enactment ought not to be construed as a manner which would leave the court helpless to meet the extraordinary situation in the interest of justice. Not then they rely upon the earlier edition of 1975, the
Yes.
mortality of the justice and hands of law troubles judges conscious and points out an angry interrogation with the law reformer. The procedure law so dominates a certain system as to overpower substantive rights, substantial justice. The humanist rule that procedure should be handmaid, not a mistress of legal justice, compel consideration of vesting residuary power and judges to act ex debitio, that is with natural course, where the tragic sequel otherwise would be wholly inequitable. The next para 29, just two lines already. Procedure law is not to be tyrant but a servant, not an obstruction but an aid to justice. Procedural and prescriptions are the handmaid and not the mistress. A lubricant, not a resistant source. That is why only kindly requesting this court just to kindly show some leniency and one time that I abide by within the time frame with any conditions that I do. But there is lapse on her part. I do completely agree, but I am only as a last chance to substantial right. I am coming.
All the three. All the three.
But not all the three are same.
WP common order 19089, WP 23851 of 2026, WP 23879 of 2026. All the prayers you extract from the respective cases. All these writ petitions or arising out of a suit and an application seeking appointment of commissioner. Hence, all the petitions are disposed of by way of a common order. The petitioner herein has filed a suit seeking a declaration and also recovery of possession and permanent injunction. In the said suit, the when the matter is reserved for judgment, the court had passed an order on 5/10/2018, observing that as a relief of mandatory injunction is claimed, an appointment of a court commissioner is necessary to find out the alleged encroachment, as the plaintiff has sought for the removal of the encroachment by removing the construction and position of the plaintiff B and C scheduled properties, the identification of the properties and the clear proof regarding the extent and nature of the encroachment is necessary to pass an effective decree which can be duly executed. Therefore, the civil engineer has to be appointed to identify the plaintiff A and B scheduled properties and to note the encroachment alleged by the plaintiff. And accordingly, the court commission is ordered to be appointed to suggest the name of the court commissioner and the plaintiff to comply with the order dated 5/10/2018, 5/10/2018. Then that order was not acted upon. Thereafter, after 7 years, another on 25/10/2025, another application is filed under Order 6, Rule 9 and 10 of the CPC for appointment of an advocate commissioner. That came to be dismissed by order dated 26/11/2025, wherein the court felt that PW1 not tendered for cross-examination and already matter has been adjourned for nearly 6 years, giving sufficient opportunity to the plaintiff to furnish correct address of the court commissioner and to take proper steps. Taking into note of these facts, no plaintiffs have not made any good grounds to appoint court commissioner as prayed in the application. Court commissioner report may help the court in appreciating the evidence of the parties on record in better manner. In this case, PW1 himself has not tendered for cross-examination and accordingly dismiss the application. Then, where is the next one?
That is.
Then another application is filed.
Review that annexure.
On 20, application is filed to review the order dated 26/11. Where is this 26/11 order? Page 52 order itself is 26/11.
That is after that, page 62. 27/1/26.
26/11/2025 is this
Yes.
order of
IA 6.
page 52. IA number 6. This is
Yes,
IA number.
This is IA number 7.
IA number 6. Then
IA
IA number 7 is filed.
Yes.
To review the order dated
Annexure.
26/11/2025. That came to be dismissed by order dated 27/1/2026, whereby the court has observed that the IA number 6 is dismissed on 26/11/2025. And according to the petitioner, according to the plaintiff, there is an error apparent on the face of the order. As per order dated 5/10/2018 itself, court commissioner was appointed. Thereafter, matter repeatedly adjourned for 6 years and no proper steps taken by the plaintiff to furnish correct address of the court commissioner. Further, it is observed that even after sufficient opportunity, PW are not tendered for cross-examination. Hence, the court felt that there is no error apparent on the face of the record and accordingly dismissed the petition. Now, 2611 is questioned in one writ petition.
Yes.
Then, what is the other order?
That is annexure G2.
Page number?
Last page 70, your lordship, 75. G2 annexure, page 73.
Then thereafter.
IA 1 of 26.
Then IA number
1 of
26 is filed.
That is annexure
Again,
G.
seeking appointment
page
of the
67.
advocate commissioner. That also came to be dismissed by the court by order dated 2/6/2026.
Yes, 2/6.
By order dated 2/6/2026. Now, these three writ petitions are filed questioning the three orders passed by the court. Dismiss it. Two orders passed by the court, dismiss. And the recall order, where the court has failed to review the order, earlier order. Three writ petitions are filed. Next, Land Council appearing for the petitioner submits that when there is a dispute with regard to the encroachment, and earlier when the court has already appointed an advocate commissioner for various reasons, it could not be taken forward. In the interest of justice, the court ought to have allowed the application. It is submitted that for various reasons, the advocates were changed, and because of that, this case was not taken in a correct manner, and in that process, they could not change the orders passed by could not question the orders passed by the court at an appropriate time. It is submitted that while considering these kind of applications, there should be an approach. The court should have a approach which is in the substantial interest of the parties, and it is submitted that as it is settled law that the procedure is a handmaid of justice, and it would not be used to defeat the interest of the parties. He relied on paragraph number 28 and paragraph number 29 in case of Kailash versus Nanku and others, reported in 2005, 4 SCC 480, extract para 28 and para 29. Relying on these judgments, and counsel submits that there may be an opportunity given to the petitioner, and if the advocate commissioner is appointed, any terms that are going to be imposed by the court, they'll accordingly they'll fulfill the set conditions. Next para, having got the land counsel for the petitioner, produce some material on record. This is a suit of 2014. In the year 2018 itself, everything is concluded, and the matter was posted for judgment. At that stage, advocate commissioner an order was passed for appointment of a commissioner, and that was not complied with, and that order was not acted upon. Thereafter, another application in the year 24, and an order was passed on 26/11/2025. Another IA to review that order. Thereafter, another order is passed rejecting the case of the petitioner, a case of the plaintiff. As submitted by the land counsel, the procedural law is a handmaid of justice, and it is only for advancing the purpose of justice, and it cannot be applied in a very technical manner. In this case, the plaintiff has not even entered into the witness box, and he was not cross-examined.
After recalling. First round she was there. Second round A filed by the defendant for recalling. That was allowed. And at that point.
No, he
has given evidence first time.
That
is the order available in the first
when the earlier orders are passed, The plaintiff
Recalling
has
the
not even
PW.
examined, has not even entered the witness box.
After recall.
From 2018 till 2026, the plaintiff could successfully drag on the matter without, drag on the matter and coming up with successive applications. The entire narration of the events shows that the plaintiff was not vigilant in prosecuting the matter, in particularly in respect of clients, in respect of the parties who are not vigilant. The court shall not come to the rescue of these kind of parties who are only litigating with them for the purpose of litigating the matter. In that view of the matter, this is not a case where any indulgence shall be shown by this court. Hence, this court do not find any reasons. Accordingly, all the petitions are dismissed.
Then number 17, Adinarayanappa.
Petitioner is challenged the order passed by the trial court, refusing to mark the unregistered release deed by passing orders.
Sir?
Unregistered release deed executed by the plaintiff in favor of the defendant is refused to mark the document and posted for the plaintiff executed the unregistered relinquishment deed by receiving her share, and subsequently she filed a suit for partition. We have taken the contention that she's already taken her share by executing a
No, property is transferred in your favor by way of a document. Property can only be transferred by way of only a registered document.
In respect of the family partition, she executed the release deed in favor of the relinquishment deed by receiving her share.
That is not, need not be registered.
This honorable court held that that document can be taken consideration for collateral purpose, and after examining the witnesses, it can be decided on the
No, is it your case that you want it for a collateral purpose?
Purpose of collateral purpose. See,
is it a stamp at least?
It is paid. Stamp duty had been paid. May kindly see the annexure A.
Where is it?
Ink page 25, annexure 26. The dependent number 2 has relied upon the unregistered relinquishment deed dated 15/5/97. The recital of the said document states that one Gangamma, wife of Maregowda, son of Bailappa, has released her rights with respect of the ancestral and self-acquired properties belongs to her family in favor of the children of Chikkanna, namely Rajkumar, Gangappa, and receiving 10 lakhs towards her share. Dependent number 2 is intending to rely upon this document to prove his case, hence tries to exhibit the same through his evidence. Dependent number 2 has paid the duty and penalty to the said document, and the same is endorsed by the district registrar and certify that on 3/2/23. Therefore, the dependent number 2 has paid the duty and penalty to the said unregistered release deed. Now the question is whether the said unregistered document could be.
They wanted to mark an unregistered relinquishment date dated 15/5/1997 for a collateral purpose, which is a duly stamped document. But the court has failed to consider the same. Considering the submission, there shall be a stay of all further proceedings pursuant to so and so. Notice, hand summons, 25th. Yes.
Number 18, Yamini Muniraj, petitioner.
My lord's writ of mandamus, my lord, seeking for speedy disposal. Reason being.
For that you have asked for a memo.
Yes, my lords.
For speedy disposal, a memo.
Yes, my lords.
Where is that memo? Who is granted? There is no urgency for a memo of this nature. Don't move it.
My lord, the reason being.
It's a suit of 2024. Why should it be disposed of?
No, my lord.
In 8 months.
Adenandre, same stage alane ide since for plaintiff's evidence, my lords. And its first date was on
Yes.
1st of January of 2025. Next date, that was.
Whatever it is. If there any IAs are not disposed of, you will ask for it. But we will not ask the court to dispose of 2024 suit.
lords,
And
to
that too, where
close
is it
this-
pending?
Close the stage, my lord. My lords, city court, my
And
lords.
City Civil and Session Judge Bangalore.
Yes, my lords. My lords, it's the same stage from past 1 year, my lords. 9 months. 1 year, 9 months. Same plaintiff's evidence stage only, my
Can
lord.
you ask for that? Will the court grant a mandamus for 24 matter? Please come.
Lords.
The present writ petition is filed seeing the following prayer. Writ petition, the suit is of the year 2024. Pending on the file of the Bangalore, file of the Principal City Civil and Session Judge Bangalore. There are several pending matters on the file of the said court. There cannot be any, this court cannot issue any direction to the court to dispose of a suit within 8 months. Accordingly, dismissed.
My lords, a humble submission. At least let the stage be closed, my lords, within
That
a
is
month.
not the prayer you sought.
Grateful, my lords.
Petitioners in this case, my lords. The petitioners herein have filed a suit for declaration and injunction in the year 1999, my lords. After the respondents herein are being a defendants in the said suit, my lords, they have filed a written statement in the year 2006, my lords. After that, in the year 2008, my lords, they have filed another suit for declaration in respect of very same property without made the petitioners as the parties, my lords. Only they have made the other defendants in my suit, my lords, as a parties. And even till today, my lords, the other defendants have not filed any written statement, my lords. The respondent number 1 to 14 herein wanted to obtain a ex parte decree before the same court, my
Come
lords.
to the point, what is the IA?
My lords, IA is under our 1 Rule 10 plus
Please
2
come to-
CPC.
Please come to that order.
Order, my lords, at page number 18, my lords. Only stated that, my lords, I have filed another suit.
Please read the order.
18, page number 18, para number 5, my lords.
Page number 18.
18, para number 5, my lords. Impugned order, my lords. The finding given by
Read
the
it,
trial court.
Read it.
On perusal of the records and the documents produced by the applicants, it is noticed that admittedly OS number 598 of 99 has been filed by the applicants herein seeking for declaration of title over the item number 2 in the suitable property along with some other properties, and the said suit is pending for consideration. The present suit is also filed seeking for declaration of title over the item number 2 of the suitable property and other properties. It is also noticed that the plaintiffs herein are also parties in the said suit, as the applications have got all opportunity to put forth their grievance against the plaintiffs herein in the OS number 598 of 99. Hence, the applications are applicants are not necessary parties in the present suit. And these circumstances, the following are so and so application came to be rejected.
Please come. Will and counsel the petitioner submit that he has filed a suit for declaration in respect of several properties.
Several properties.
And one of the property against in respect of one of the property, the suit is filed. Another suit is filed, and all the defendants in a suit were made parties to the suit, but the petitioner is not a party. Hence, he has filed an application under Order 1 Rule 10, and the court based on the ground that the other suit is pending, and he can pursue the same, has dismissed the application considering the same. Stay.
Respondent number 15 to 23 may be dispensed with, my lords.
Stay.
They are not.
Notice to the respondents 15 to 23. Memo is filed. Dispensed with. Notice to 1 to 14. Yes, next.
Much obliged.
For the petition of the plaintiff before the court below. They filed a suit for declaration of the compromise decree obtained by defendants, my lord, is null and void, my lord. And during the substance of the suit, my lord, filed application, my lord, under 7 Rule 14 seeking production of certain documents, my lord. That application came to be dismissed.
Come to the order.
Page, my lord, 46th. 11th para 5, my lord. On perusal of the document produced, it appears that the defendant obtained the plaintiff in the year 2015. The defendant agreed to obtain documents 3 to 4 obtained in the year 2019. The further documents like income certificate, original patta book, are all documents. Those documents are available at the public at any point of time. Further, the affidavit of the plaintiff has produced that why she has not furnished all those documents at the earliest stage. Further, the plaintiff has produced RTC either 2020 and also produced one affidavit. On perusal of those documents, appears that the documents have canvassed their argument. Thereafter, the plaintiff has obtained these documents because RTC obtained on 11/7/2026 and the affidavit pertaining to date.
When was this miscellaneous is filed?
I am Malad. I have filed on Malada.
You're saying that the judgment and decree has to be set aside. Something you said no.
Please, this original suit, Malad. It's a original suit for cancellation of the decree obtained.
Yes.
Is null and void like that.
Suit is of which year?
2011, Malad. The decree also 2011, Malad. The documents, Malad, was produced.
What is the present stage?
It is for argument, Malad, for reply of all.
In 2026, now you want to file, you want to place some other documents.
Some more documents, the documents which I intended to relate that, Malad, they disputed the very relationship between the. For that, Malad, I have produced.
Come to para 4.
Para 4. Order, this court has gone through the order sheet case of the plaintiff cultivated the habit of filing of the one or the other application repeatedly. The matter pertaining to 2011. The matter is one of the older case. Further, on perusal of the order sheet, the plaintiff has exhausted all the remedies available for her. The plaintiff has filed this kind of application the third time when the matter was posted for reply argument. The defendants have already advanced their argument on merits. On perusal of the order, it appears that it is statistics of the plaintiff to drag the proceedings.
Let's continue.
On perusal of the document produced by the plaintiff, it appears that the defendant number 1 and 2 obtained by the plaintiff, documents number 1 and 2 are obtained by the plaintiff in the year 2015. The documents 3 and 4 obtained in the year 2019. The further documents like income certificate, old RTC, original patta book are all public documents, and those documents are available for public at any point of time. Further, in the affidavit, the plaintiff has contended the way she has not furnished this kind of documents at the earliest stage of the suit. Further, the plaintiff has produced the RTC for the year 2026 and also produced on one affidavit. On perusal of these documents, it appears that when the defendants have canvassed their argument, thereafter the plaintiff has obtained these documents because RTC was obtained 11/7/2026 and the affidavit pertained for the date 13/7/2026. Thereafter, these documents are arose on afterthought. Those all the documents, was not available with.
Why it is not available? 2015 documents with you.
Those documents were not not available at the hands of them. Subsequently, that those.
How you have got it now? Why it was not there with?
Some were misplaced, Malad. And
while pending of the second appeal, also you will get it. Please come.
Malad, if your lordship fix that time, Malad, 2 days or any date, Malad.
Not a case.
Because
not a case for indulgence.
Because these documents are very much important. All these documents are.
2011 suit posted for after filing, posting it for arguments.
Please.
You have already filed 3 applications as of now. That's what the court.
Not that for recall of the PW4 and other these things. That was.
So this kind of application is the fresh one.
Not this 7 Rule 14 was not filed.
That's what I'm saying.
Please.
So at least these kind of application 2-3 you should file.
No. If some indulgence is.
No indulgence is required.
Because the very purpose of the suit itself, because
that is what was he doing?
These are the document that the death certificate, the main foremost important is the death certificate.
And when the person died?
1969, that
1969 document. Now you will 2011 suit, 2026 you will do it.
That I was no knowledge about the exact date when it was this. For that, it was registered in the office.
After entire evidence is completed,
please.
Basing on to fill up all the latches, now you will not file this application.
Not earlier, I have made an attempt before the authority to get all those documents.
Application and order 18 Rule 17 and order 7 Rule 14. Led with section 151 CPC dated 15. What is the date of the order?
15-6, my lord.
15/6,
15-7, my lord.
15/7.
Please, 15-7.
26, the petitioner, plaintiff is before this court. The suit is filed seeking the suit for injunction.
Seeking, my lord, decree, judgment and decree passed in 2/26/2011 is null and void.
Filed a suit seeking that the judgment and decree dated
6/7/2011.
2011
Please,
is not
pass.
binding on the plaintiff. In the said suit, the application is filed under Order 18, Rule 17, and Order 7. The incident application is filed
3 applications.
seeking to recall PW1 for further chief examination and production of the documents that came to be dismissed by order impugned.
We have filed the documents along with the application also.
The court, while dismissing the application, has observed that the court has gone through the order sheet of the case, and the plaintiff has cultivated the habit of filing one and another applications repeatedly. The matter is pertaining to the year 2011. The matter is one of the oldest cases pending before the court. Further, on perusal of the order sheet, it appears that the plaintiff has exhausted all the remedies available for her. The plaintiff has filed these kind of applications at the third time when the matter posted for reply arguments. The defendants have already advanced their arguments on merits. On perusal of the order sheet, it appears that it is tactics of the plaintiff to drag on the proceedings. The documents, a perusal of the documents shows that all are public documents, and those documents are available for public at any point of time. In the affidavit, it is stated that why she has not furnished this kind of document at the earlier stage. Further, the plaintiff has produced the RTC for the year 2026 and also produced one affidavit. On perusal of the documents, it appears that where the defendants have canvassed their arguments, thereafter the plaintiff has obtained these documents because the RTC was obtained on 10/11/7/2026. The court further observed that as per the law settled with the Honorable Apex Court, the court should not recall the witness and permit to lead further evidence. Further, the court should not allow the parties to fill up the lacuna by recalling the witnesses. The plaintiff has come up with this kind of application when the matter is posted for reply arguments on merits. So it appears that in order to fill up lacuna, the plaintiff has filed these kind of application, and the plaintiff has not took the best use of opportunities which are afforded to her. Therefore, by considering the age of the suit and by considering the conduct of the plaintiff, the court has no hesitation to hold that the application filed by the plaintiff are liable to be dismissed with cause, and accordingly, the court has imposed cost of ₹1,000 each and dismissed the IA. Learned counsel appearing for the petitioner submits that these documents are very crucial to support his case. As he is not aware of these documents, he could not file it at an appropriate point of time unless these documents are taken on record. It would cause a lot of prejudice to the plaintiff. It is submitted that some time frame may be fixed for concluding the proceedings, and applications cannot be dismissed on these kind of technical grounds. Next, having heard the counsel for the petitioner, there is a material on record. This is a suit of the year 2011, and order as the observations of the court reveal that the matter is when the matter is coming up for reply argument. At that time, this application is filed. Even after the matter is posted for the arguments, even at that time, he has filed 3 applications that were considered by the court. The court has rightly observed that for the purpose of filling up the latches or the lacuna in the case of the plaintiff, he cannot be permitted to file these kind of documents at this stage. The court has perfectly dealt with all the aspects and has rightly held that the IA cannot be allowed and dismiss same with cause. This court do not find any reasons dismiss.
Sale number 21, Rangaramu V for petitioner.
Here for the petition, may I request, madam, I pray for 10 days time to get some documents.
Does this matter in the month of September?
Sale number 22, Santosh B.
No representation in the month of October. Case 23.
Sale number 23, Nitin AM.
Yes.
The first one, my lord, if my lord could take up 23.2, my lord. That is wherein I filed an application.
What are this? What is 23?
Lord, three prayers, three interlocutory applications.
That's what 23 is what?
The prayer that I had sought for in 23, my lord, was seeking that to actively monitor and remove the links of all the contents that is published. It is in terms of defamation and damages that I have
What is the IA? IA is for?
IA is for active monitoring and removal of the links.
Active monitoring. Then this 23.1?
In 23.1, my lord, it is to restrain the defendants from making defamatory statements and publishing any defamatory contents.
Next.
That is for temporary removal of the link, my lord, the scheduled links.
All are dismissed? All applications are dismissed?
All applications were dismissed, my lord.
Come to the order.
Not dismissed per se. The interim prayer that I had sought for, if I could just take out 23.2, my lord. 23 is also fine, my lord. All three are the same similar orders.
Yes.
I'll go with 23, my lord.
20?
23, item number 23.
Where is the order?
The interim order would be at page number 87, my lord, annexure G. Annexure G. That would be the last before Wakalat, my lord, just before Wakalat.
Yes.
87. Heard the counsel for plaintiff on IN number 1 to 3. Perused the material on record. FIR is registered against the chairman of plaintiff number 1 against plaintiff number 2 before Bagalgunte police station for crime number 167 of 2026 for the offences punishable under section so and so. So I hold that the law will take its own course and I hold that the plaintiff has not made out prima facie case to grant temporary injunction in this.
What temporary injunction you are seeking?
Not, yes, ma'am. Before I get into that, my lord, if I could just have my lord's attention to page number 44, my lord. Page number 44. That is the order passed in 2662 of 2026.
Yes.
Page number 4. The suit is filed by the plaintiff, the very same plaintiff, my lord, filed by the plaintiff against the defendants for the relief of permanent injunction, restraining the defendant from making defamatory statements against the plaintiff by way of paper publication, articles, emails, etc. in any form of social media like YouTube, Instagram, and for the relief of damages of rupees 25 lakhs. IA number 1 filed by the plaintiff. These are the very same three IAs, my lord, 1, 2, and 3. The next page, my lord. Heard advocate for plaintiff on IA number 1 to 3. Peruse the materials on record and the documents produced by plaintiffs. Defendant number 1 was a student of the plaintiff college. She left the college and defendant number 1 and 2 have uploaded the videos on Instagram stating that the college of the plaintiff is money-making factory. 2, Mount Shepherd ruined my life and shocking truth exposed. Number 3, my lord. MS College, worst college ever seen, real Mount Shepherd College, life hidden scams, so and so, so on. So the defendant number 1 and 2 have uploaded the videos on social media platform as against the plaintiffs and making defamatory statements against the plaintiff college of the plaintiff. As per the letter furnished by the plaintiffs, the defendant number 1 left the college of the plaintiff along with her brother on 11/8/2025 for the purpose of medical treatment. So she left the college of the plaintiffs and it appears that she is making defamatory statements against the plaintiff college. If she has grievances against the administration of the plaintiff, she can follow the due procedure.
Yes.
But she cannot make defamatory statements.
I've seen that.
Yes. What happened, my lord? This order, now, my lord, page number 48, my lord, that is the order in this OS number, my lord. 2662 of 26.
Yes.
This order came to be passed on 17/4.
17/4/26.
Yes. After the order was passed, these links that was uploaded by the defendant was taken down. For a temporary basis, it was taken down. Now what happens on 19/4? That is on the next page, page number 49.
Yes.
19/4, my lord, she files a complaint to Bagalgunte police station stating the complaint against so-and-so Mount Shepherd College chairman so-and-so by for inappropriate and perverted conduct, including making derogatory personal remarks, comparing me to his ex-girlfriend, continuous mental harassment and disrespect, women dignity and ill treatment, threats to life and intimidation and abuse of authority by threatening to fail me in the
Yes, I
examinations.
understand that the complaint is given.
Yes, insofar as this complaint, my lord, there is no allegations of sexual harassment that was raised. Now, my lord, after this complaint was given on 19th, on the very same day, an FIR is also registered. Subsequent to that, my lord, she calls a press conference. Now, on 17/4, the court had passed an order saying that you do not make any comments as against the plaintiff. She files a complaint. In all the previous videos, she never had any allegations of sexual harassment. When the court passed an order stating that you do not make any further statements as against the institution or the person, you have due course of law that has to be taken. She goes and files an FIR. Based on the FIR, now there is an entire, she calls a press release and the media is making continuous allegations as against me. Now my submission before this honorable court, in fact before the trial court, was also that the court had initial statements that she made against me, court stopped her. Then she raised this one stating that sexual harassment allegations, press release. Now the entire media is going on putting news
But
against
this is a different issue. If she gave a complaint and the media asked her what is the complaint, if she is revealing, what is wrong in it?
There is fair point. Now if I could just have my lord's attention to the plaint that I have filed, my lord.
No, for this you have filed another suit.
No. This is the second suit. Subsequent to this 19 complaint that she filed, she calls a press release and the press starts putting up.
That's what I'm saying. For this you
To
filed
that,
another
I filed
suit.
the subsequent suit. If I could just, my lord, page number.
No, she has this, you can't violate her liberties.
Yes, if I could just point out one paragraph, why I have filed. Page number 76, my lord, that's the affidavit.
Yes.
Page number 78, forgive me, my lord, page number 78. I would also like to state that the chairman had placed his hands on my shoulder. The chairman's room is a highly private. Page number 78, my lord, that is the IA interlocutory application affidavit. The same contents 78. This was the statement that she had given in the press release. I would like to state that the chairman had placed his hands on my shoulder. The chairman's room is a highly private room and I understand that only he has access to it and cannot open it. I do not know whether there are cameras installed inside the room. However, in any such cameras are installed, the footage would reveal that what transpired. For that reason, I understand that efforts are being made to secure the camera footage as evidence. Despite this, the police have not taken any steps against the footage. There have been several occasions on which I came out of the chairman's room crying. In fact, during almost every year my studies, I have cried. Now, this is if I could just, these statements that she gave before the press, they are not the contents of the complaint. And if I could just read out her initial videos which were taken down, if I could just point out on that, why I am seeking a remedy before this honorable court. Page number 34, my lord. These were the videos which were temporarily taken down. The third video, if I could just, contents of the video which were put it in the plaint. Page number 34 in OS number 2662.
Yes.
Contents defamation number 3 YouTube video. Submitted that the defendant number 1 has made statements such as the students are treated like accused persons and are made to wait 4 to 6 hours without redressal of grievance, that access to the chairman is controlled through an intermediary named so-and-so, and the chairman pretends to be busy and the chairman's office is closed. Why I am pointing out, why I come before this honorable court is, initially her allegations was that even if I want to meet the chairman, I cannot meet them. This is always closed. He never addresses anything. He is not available to the public at all. So she makes videos to that effect and she publishes it. When the videos were taken down, she goes and files a complaint saying that he has made comments as against me. That is her complaint. Whereas when it comes to the news that she gets it published in the press release, she says that he inappropriately touched me, he called me into the chamber and all of this.
Correct. That why, how can we stop? You can't call it as a defamatory statement. That's our case.
What I am seeking is, when she has filed a complaint before the honorable, before the appropriate jurisdictional police, they are supposed to investigate into the matter, and whether it is true or not has to be identified. That is the stage of investigation. At this stage, making comments as against that in the public forum, and an institution is also involved, what happens to my life and liberty, my lord? If it is true, I agree that I am supposed to be prosecuted for it. What if it doesn't turn out to be
What
true?
is the law on that? What is the law on that?
On the law in terms of this, but no statements can be made as against me which is defamatory. As against me which is defamatory. A complaint that she has filed, if at all, she would have been only.
No, even if took it from the other way, according to the complainant, it's her grievance. Those statements of her grievance might affect your reputation.
Yes, ma'am.
So can we stop her from saying it?
I am only stating why I have come before these links. If out of the 3 prayers that I have sought for, what?
No, earlier other things, that's different.
Okay. The statements, what is the statement that I'm putting before this honorable court, my lord, is that the contents in the complaint, if she would have stated that these are the complaints, I have
We
filed.
will not be entering into the merits of it, like veracity of her statement before earlier, now what it is.
Here, I'm all speaking, my lord, before this honorable court. When a complaint is filed before the police has to investigate into the matter. Her calling a press release to that effect, making the media repeatedly, now what happens, my lord, the media is repeatedly pushing these contents, addressing me and portraying as though I'm already guilty of it. What is creating a damage?
You are not seeking any order against the media.
I am. That is what.
You know, you're seeking a gag order.
Yes, ma'am. Not complete, my lord, but if I could, 23.2, my lord.
Use the tradition.
Number 23027.
Yes.
The defendant number 7 and 8 would be Meta and Google, my lord. And I have given a schedule link. Those links are temporarily taken down, my lord. The interlocutory application that I have filed.
We'll see the law on this.
Forgive me, my lord.
We'll see the law on this. Please place before the court.
Stating that whether the news media can
What is
publish.
the scope of this? In these kind of cases?
Yes.
What is the scope of these gag orders?
Indeed.
When do you want?
Monday, my lord.
Yes. We'll have it on Tuesday in the first list.
Tuesday, I have an appearance in Kerala High Court, my lord. If it can be taken up on Wednesday.
Wednesday first list.
Grateful.
Cell number 24. Muduraj, petitioner.
The suit is for declaration and permanent injunction. Your Honor. In the said suit, the petitioner, who is the plaintiff in the said case, has filed an application under Order 6 through 17, seeking an amendment in para 11 of the plaint, the relief portion, Your Honor, where just I would like to take Your Honor kind attention to the para 11 of the plaint. Para 11 of the plaint, relief portion D, Your Honor, where relief of permanent injunction was sought in respect of permanent injunction restraining the defendant and his agents, his police henchmen from either interfering or trespassing or putting any fence in A and B schedule property, which is.
Where is the impugned order?
The impugned order is at page number 36, Annexure F. Annexure F is the impugned order. In this case, is the plaintiff wanted to delete the relief portion of A shadow property because in respect of the assured property is an encroached portion of the, by the defendant, that is the respondent. So in respect of the encroached portion, the plaintiff petitioner has already sought for a relief of declaration and.
We'll see para number 2, your case is there, and read that at page number 38.
Yes, madam. The averments in the affidavit are false only with intention, the impugn order para number 2. The defendant has filed an objection stating that the application is not maintained by under law facts and the circumstances of the case. The averments made in the affidavit are all false. Only with an intention to misconceive the court, the plaintiff by way amendment is trying to insert a new relief which amounts to a change the nature of the suit and introduce a new pleadings. When the new pleading is introduced in such a circumstances, amendment cannot be allowed. This is the stand taken by the defendant. Here in this case, the plaintiff is not sought for any new relief, Your Honor. Already a relief of permanent injunction was sought in respect of remaining portion for entire property, that is A and B pseudo property. So in respect of A pseudo property, since
We'll read the reasoning of the court.
Pardon?
We'll read the reasoning given by the court. Then I'll hear you.
Yes, ma'am. Admittedly, in the since from the para 8, 9, and 10 of the 10 and 12 of the plaintiff, where the court observed like this, Your Honor. The instant suit is filed seeking relief of declaration, mandatory injunction, and permanent injunction with respect to the suit's properties. When the case is posted for arguments and both the sides' arguments have been concluded, the applicant has filed this application by stating that proposed amendment is necessary for effective adjudication in the matter in dispute. It is a specific contention of the plaintiff that due to a typographical error, it was wrongly mentioned in the relief column, and therefore he has sought for an amendment. Per contra, the defendants have strongly opposed to the application.
What are you doing from 3rd June to 3rd June? This order is passed.
Yes, my lord.
You filed it on 37. That too, when where is the matter is at the verge or at the fag end of the trial.
Pardon? Yes, my lord.
The order is passed on
3/6.
3rd July, June.
Yes, ma'am.
You filed this writ petition on 30 July.
Yes, ma'am. Because the case is still posted for arguments, Your Honor. It is for posted for reply argument because getting the copies and
1.5 month.
The trial court advocate because no matter because there is inconsistency, Your Honor, because
Why? What are you doing? Are you not wasting this much of time? Had you come earlier,
Allah,
by giving a short time, court would have.
Allah, 3/6/2006. This month, last month only order has been passed.
How many days it takes for an order copy?
Allah, certified copy they have obtained on. They have given on 22/7, my lord.
When did you apply?
21/7 they have applied. The trial court.
The order is passed in the month of June. You apply on 21/7. They will give it only on 27.
To some
no,
my lord, because permanent injunction, because there is a inconsistent order.
Whatever it is, we will see notice to the respondents. Petition is permitted to take out handsome.
Allah, because inconsistent order.
Yes,
my lord, in this because declaration. Yeah,
I will not stay the suit. Yes.
Cell number 25. Badrinath for petitioner.
I pay for petition. I had filed a suit for declaration cancellation of the sale deed, sale agreement and GPA. I had filed during the pendency of the I had filed an application for amendment of line. My amendment application came to be rejected on the ground that may kindly look into Annexure A, page number 21. The court comes to conclusion that first para, page number 21. The application filed by the plaintiff under Article 6 Rule 17 seeking for amendment of plaint along with the application of weight is filed, stating that the suit is filed for declaration, declared that the agreement of sale dated so and so, GPA dated so and so, sale deed dated so cancellation, and also for granting a permanent injunction. Now the case is intended to be amended as per the application filed since they are necessary. Contention of the defendant. Objections filed by the defendant.
Come to the IA.
Annexure D, page number 42. There is a declaration prayer in earlier plaint itself. Now
You're as if you're filing a new plaint.
Not new plaint, suit itself is for a declaration. Before
I
now,
understand. What is this amendment? 4 pages of amendment you want to?
kindly look into plaint. Page number 29. 28 it is. Not a issues has been till today has been not been framed. The nature of the suit changes does not arise. Already the prayer for a declaration is there.
What is your affidavit says? Why you are seeking all this amendment?
Where now as on date of entering into sale deed, the property comes under the Greater Bengaluru Development Authority limits. And the sale price consideration is where lesser price. That was not notified me earlier as on date of the sale deed. For that I am seeking for the cancellation of the sale agreement. Sale agreement, GPA and the sale deed. Where the amount paid by the respondent herein is a lesser price and the price which has been not till it is due is to me under the sale consideration in the sale deed.
No court will allow these kind of amendments. With the amendment would be a short and sweet, not like filing another plaint.
Court only the
By
conclusion.
way of this, you wanted almost another plaint to be added. That won't be called amendment.
Where the prayer for declaration is there. Now I added prayer is only for the declaration to declare me I am the owner of the property. In addition to that, I am starting earlier prayers.
Counsel for the petitioner submits that it's a pre-trial amendment. Court has failed to consider the same. And by virtue of this amendment, the nature of the suit is not changed. Considering the same, they shall be served all further proceedings notice and summons.
Cell number 26.
Start
KV
for the
Narasimhan.
interim order. Interim order.
Okay. Cell number 26. KV Narasimhan.
Some urgency, my lord, had arisen owing to the fact that the defendant specifically sent me a WhatsApp message and said that they will cultivate the land by force. Hence, my lord, I filed an injunction suit. What I have come before my lordship is notice has been issued, my lord, without considering my ex parte identity. Please, my lord.
Where is that?
My lord, page number 62, my lord, is the impugned order. My lord, revenue entry stands in my name. It is concerning the coffee plantation.
In counsel for the petitioner, the presented petition is filed. Agreed with the order dated 22/7/2026 by the Principal Civil Judge and JMFC Bellour, whereby the court has issued sue summons on I number 1, filed under order 39 rule 1 and 2, read to section 151. No, it has dismissed.
My lord, that's not wrong, erroneous. That is where, my lord, I have said this. The second portion, my lord, it is said issue emergent notice on IA number 1. It appears to be a typography.
Happening to them. Then this order has to be corrected.
No, the difficult. No, that's right.
Is agreed with the order whereby the court in the operative portion at I number 1, it says that I number 1 filed under order 39 rule 1 and 2 read with the section 151 CPC is dismissed. Then in the next line, the court says issue emergent notice on I number 1 to defendant defendants and sue summons to the defendant number 1 to 4 returnable by 31/8/2026. When counsel appearing for the petitioner submits that when they have expressed the urgency and also by placing all the documents as sought for an injunction, the court ought not to have issued emergent notice. It is submitted that the order that I number 1 is dismissed is a typographical mistake, as in the preceding paragraph, the court has observed that peruse the plaint I number 1 and accompanying affidavit and the documents produced with the plaintiff in support of the case. On perusal of the same, this court is of the opinion that defendants needs to be heard before passing any order, since it is agricultural property. Land counsel submits that. That's a typographical error. When an application is filed seeking ad interim injunction, court has to consider the same on the merits of the matter and pass appropriate orders instead of issuing suit summons. In that view of the matter, the order dated 22/7/2026. I have to set aside this order in the light of this. Order dated 22/7/2026 is set aside, and the trial court shall hear I number 1 on the merits of the matter within a period of 1 week from the date of receipt of the copy of the order.
Number 27, Ramesh KR.
This matter, I am appealing for the petitioner. Defendant petition. The petitioner challenging the impugned order 11/3/2026. They are sued for bare injunction earlier.
What is it order?
The amendment application was allowed. The defendant challenging the present writ petition.
Yes.
The earlier the suit for bare injunction.
Of the year 2020. What is the stage of the suit?
Evidence, plaintiff evidence.
Is it not at commenced?
Plaintiff evidence is commenced. In 9 earlier they have filed a suit for bare injunction. The expected decree was passed. Then I will challenge this.
Let us see the IA that is filed.
IA Annexure C is in Kannada portion. They have mentioned.
Come to the order. Come to the reasoning part.
Reasoning part, they page number 29. They have stated, in the year 2023, the petition.
Please read para 8.
It is pertinent to note that this suit was filed by the plaintiff against the defendant for the relief of partition and separate possession. It is wrong, my lord. In the paragraph number 7, it is mentioned wrong in respect of suited properties. Paragraph number. The present suit has been filed in the year 2020. That is, my lord, 20/0/2020. Presently, the stage of the plaintiff is plaintiff evidence. The contention of the defendant is that if the amendment is allowed, the nature of the suit will be changed. It will be changed the cause of action and will introduce the all other new case and would take away from the right of accords of the defendants. Further, it is also contended the defendants is that the present case already trial has been commenced and the plaintiff has not given any reason as to due diligence.
Are you objecting for this?
My lord, the property was not in existence. When my lord earlier filed a bare injunction suit, my lord, the expected decree was passed. Then my lord, I will challenge the same before the RA. My lord, the matter was remanded. When remanded, my lord, I have filed an application. I filed my written statement. When I filed a written statement, my lord, they have filed my lord, application stating that my lord, the defendants herein encroach the property belongs to the scheduled property. They have constructed the shed. From last 18 years, 17 to 18 years, might have been.
What is the relief now?
Lord,
if it's changed now,
Lord,
what is the relief sought now?
my lord, they have sought for relief. My lord, the impleading, my lord, the declaration suit. Earlier, my lord, they filed an injunction. Now, my lord, they change the, my lord, all.
It doesn't amount to changing. Now, when you're denying his title, he has to necessarily seek declaration.
My lord, as per the application filed by the, my lord, they have not reason of due diligence. They are not mentioned. My lord, they have stated as in the application also. My lord, they have stated.
That's the court has imposed cost.
My lord, 2023, my lord, they have stated in the application the plaintiff and the defendant for encroaching the petitioner's property belongs to the plaintiff. But my lord, they filed an application in the year 2025. Last 2 years, they have not filed an application.
At best, will increase that cost.
My lord, if my lord, we are in possession of the property, we are absolute owners.
What if he is saying that he is the owner? He will prove it. But you can't deny him that.
Due diligence and the nature of the cause of action, and it is not mentioned.
You can't say that in this particular case because when you're denying his title to the property, he has to seek necessarily the declaration. Maybe what all you can plead is there is a delay. For the delay, I'm saying we'll grant cause for that. For that, he has to come. And I'm not. I will. I have to. I will confirm this order. So because I want to confirm this order, I will not grant any stay. Notice to the respondents. Petition.
I leave it to this court. Huh? I leave it to this court.
Notice to the respondents. Petition is permitted to take out hand summons and shall file a memo to that effect. If the memo is filed by 24th of August, list it on 25th.
Apply.
Number 28. K. Vijaya Kumar.
Appearing for the petitioner, my lord. Petitioner is an impleading applicant in a suit for partition. The 1 Rule 10 application came to be filed by the impleading applicant because she acquired the property from the.
Come to the order. It is dismissed.
Dismissed.
Come to that.
Page 18, my lord, findings, paras number 6.1. It is not in dispute the alleged transfer has taken place after institution of the suit. Such transfer is therefore governed by doctrine of lease pendency under section 52.
Why this has become a standard pattern?
Courts partition suit. That is a property is not at all.
You purchase.
In a gift deed under 2021, Millard.
Please come. Land Council for
27/7/22.
an application filed under Order 1 Rule 10 by a subsequent transferee.
Some guidelines of Supreme Court clearly held, Millard, to who is necessary, who has not. It has not at all considered.
Give that.
Yes, Millard.
Give that.
That judgment may draw an attention to some guidelines by Supreme Court in
That
this case.
it is submitted that is it a subsequent transferee of one of the scheduled properties. He has filed an application under Order 1 Rule 10 to implead him, and the court has dismissed the application on the ground that it is governed by lease pendency. It is governed by Section 52 of the Transfer of Property Act. Land Council for the petitioner submits that the Honorable Apex Court in case of Mumbai International Airport Private Limited versus Regency Convention Center and Hotels Private Limited and others reported in 2010 7 SCC 417 has laid guidelines.
24.12344 is applied to my 24.5.
Starts from 20?
24.4. 24 in the all.
A court has discussed till from 24.1 to 24.4 who are the necessary who can be pleaded in the suit and the scope of Order 1 Rule 10 to CPC extracted. Considering the submission, they shall be seen. Notice hand summons.
I am filing memo for dispensation to respondent number 2 to 4. They are the other dependents.
2 to 4 dispensed with. Yes. And what are the other? Who are the other?
Only one plaintiff. Only notice has to go.
Yes.
R1. He is the plaintiff. Great.
Number 29.
I appear for the petitioner in this matter.
Yes.
This matter was listed yesterday as well. It's a writ of
Will not again carry it. We'll decide it today.
I have only one submission.
Yes.
It's posted for orders today before the trial court at 5 p.m. From yesterday, it has gone to today. If orders are passed today,
it will do it.
If orders are passed today, then my prayer doesn't survive. Then I will withdraw it tomorrow itself. But if orders are not passed, because I've also sought for interim prayers. In terms of what has happened in this matter is it's a final decree proceeding. Shares were allotted.
Can't add one more matter to my list.
All I'm asking for is 1 day.
If you want,
if orders are not passed,
it will be out of list. But I'll not keep it tomorrow.
If orders
or you
are
want
not
me
passed,
to pass orders on the merits of the matter, I'll pass.
If orders are not passed today, there is some difficulty, which is why all I'm seeking for is.
Another 2 matters were added to the list today.
That's the
come to the order. Come to the relief order.
The relief is at page 27.
I'll ask the court to decide it.
The matter is posted for orders today. It's specifically posted at 5 p.m. for orders. My only limited request, is it maybe had
this matter in the month of August, September.
I request, it maybe had tomorrow.
Yes, next 30.
Cell number 30.
It maybe had at least on Monday,
Yes, 30.
K. Kumar.
Yes.
Defendants filed this repetition, Millard, in a suit for declaration and mandatory after commencement of trial, Millard, when the matter set down for cross-examination of DW1. At this stage, an amendment application to insert C schedule property, new C schedule property, has filed. But admissions are there. I narrated in my writ petition, Millard, the ground number 18.
We will see the reasoning of the court.
Reason of the court, Millard, is para number 9. May kindly look at, Millard. No doubt, evidence of, may read page 20, Millard, para number 8.
Yes.
No doubt, evidence of PW1 and DW1 is over. However, plaintiff contends that he has recently discovered the mistake and vagueness in the pleadings and regarding the description of encroachment. Thus, it is clear plaintiff could not with due diligence has raised the proposed amendment before commencement of trial. Even there is a bar to amendment of pleadings after commencement of trial. The bar under the provisions of 6 Rule 17 is not totally complete, but this is error, my lord, apparently. And on the other hand, if the plaintiff show he could not with the due diligence raise the proposed amendment before commencement of trial, that the court can allow such amendment even after commencement of trial, even though additional relief is claimed under new schedule inserted by way of proposed amendment. Proposed amendment is only clarification in the nature. It does not introduce new cause of action, new case. It is only
What is the
elaborate
original suit for?
suit for declaration, my lord, and mandatory injunction, my lord. Now, inserting with regard to encroachment of C-schedule property, but it is what will happen in the cross-examination. He clearly admitted what he admitted the PW1 Millard is that defendant is in possession of her property and there is no boundaries, there is no dispute with regard to boundaries and encroachment. That is an admission. I have narrated at ground number 18 Millard, and even cross-examination portion also I have extracted.
Then counsel, the petitioner submits that the court has allowed the amendment at the stage of evidence. And by virtue of this amendment, the petitioner is introducing a new plea, and that would change the nature of the suit. And still the same, they shall be stayed. Notice to the respondents. Yes, next.
Cell number 31,
Right.
Rupesh B.
Plaintiff petition, suit for declaration and possession. Only the 4 defendants were there. Now the present applicants sought to implead themselves in the suit. There is already a separate suit filed by them against me, and I have also filed separate suit against
What
them.
is the present suit?
Suit for declaration and possession in respect of defendant number 1 to 4 only. I am not claiming any right to the proposed defendant. Though there is another suit.
According to him, what is his right?
Well,
According to him, how is he interested in this?
they say site was allotted. In respect of that site, which is other portion of the land, I have filed the suit. Kindly come to page number 58, their suit.
Not the suit, come to the order.
133 reasoning part. In my suit, they are not necessary. I have stated.
We'll read it.
Page number 133. At the outset, it should be noted that the present suit is for declaration, title, and recovery of possession, and consequently injunction in respect of C and D scheduled properties, which are alleged to be the portion of encroached by defendant number 3 and 4, out of the larger extent of claimed by the plaintiff. Thus, is very foundation of the suit revolves on the identification of the property and its original possession. The application has specifically asserted that the very same land 211 and 246(3) have been acquired by the BDA, and thereafter sites have been formed and allotted in their favor under the registered sale deed. They further contend that the properties claimed by the plaintiffs overlaps with the sites allotted to them. Therefore, prima facie, there is existence of a direct substantial dispute as to identity of the possession of the very same property. In such circumstances, scope of the order 1 rule 10 to assumes in principle so that the party is necessary party if there is already a separate suit filed by them. We are agitating that suit. Kindly come to annexure D, page number 58. There, though they have entered the witness box, they did not present for the cross-examination. Their cross-examination is closed. I have lead my examination chief. They did not lead their cross-examine me in their suit. Kindly annexure D, page number 58, in that suit.
No, in respect of the very same property.
No, that is wrong, I have filed my statement of objection stating that this is a separate part of land and that is a separate part of land. And I have filed separate suit also.
What is the suit number?
Annexure D, page number 58, it is their suit. And another suit filed by me, annexure F, page number 92. There are separate suits against them also. There they have to agitate their rights. Page number 92, my suit.
OS number 1238.
OS number 1238, filed by me.
What is the relief that you
Their
sought?
suit for permanent injunction restraining the defendants and their agents, servants, anybody.
The prayer. Page number?
99, it is my suit. Interfering with the peaceful possession and enjoyment of the other property. Kindly come to page number 58, their suit. OS number 3055, bar 2017.
Schedule A property and Schedule B property.
Annexure D.
Now please show in OS number 5751 of 2019, what is the schedule of the property?
I'll page number 31. Old Kata number 324. That is A schedule property. B schedule property, which is I am claiming possession from the defendants. Annexure B schedule property. B and C schedule property, madam.
Same number.
My property, kindly come to their suit, annexure
Oh,
D.
forget about there and you, just suit page 31. Page 31 is whose pro.
That is entire property. I'm not claiming right in respect of entire property. Only I've sought for possession of B and C schedule properties.
Page number 31 is what?
The
Filed
31
against
entire property. Annexure,
whom you have filed the page 31?
31
Against whom you have filed the suit?
this suit is for the different number 1 to 4. Different number 1 to 4 in respect of B schedule property. I have sought for possession of B schedule property. I sought declaration of A schedule
I
property.
will look at it. No.
And
In this, no, let us see. There are two scheduled properties at page number 31. That is in OS number 1238 of 2017, which you have filed against the present implead applicants.
Yes, madam.
So
And they have also filed suit, annexure D.
Let's not confuse the facts. No, coming to page 31, old Kata number 324, present number 54, ward number 88. Same thing is this in page number.
Kindly come to prayer, I only sought for the suit C and D schedule property. In this, I have only sought relief against C and D schedule property. C and D schedule properties are not the properties in
Plaintiffs are the sole and absolute owners of the suit schedule C and D
C and D
property.
properties.
Now what are those property?
Next page, madam.
Correct. Same property.
C kindly see 1500 square feet is there. B 900 square feet is there. In this another suit 6250 square feet and 5625 square feet. And kindly come to their suit, annexure D, page number 58.
You have sought for a larger extent here, 5625.
Yes, madam.
Which is that part of it, which is not? How will
That-
anybody understand?
Therefore, that is described in that suit, It is separate suit, described, and all the suits are clubbed.
There is no,
All the suits are clubbed by the Sanva court only. You are leading evidence in common. There is no necessity to implead here, madam.
how are you bothered about even if he is a party to the proceedings, what is going to happen?
Since I only sought for declaration of possession.
Unless and until there are some extraneous reasons. Why not he be a party?
Therefore, they have also filed annexure D, page number 58, their suit. They have also filed suit against me.
Oh, you are showing a larger extent, you are
Yes,
showing
ma'am.
a smaller extent, nothing has boundaries.
Sorry, number 211 is there.
People are in between. So they have sought for it. They want to be pleaded.
The Honorable Apex Court in AR 2026 Supreme Court 300 has held. Plaintiff is the dominant elitist. I can implead, if I want, they can implead. And apart from that, in their suit.
Honorable Apex Court also said that the court can
This is
implead.
recent judgment. Supreme Court has said.
That is in the Supreme Court cannot say there won't be any
No.
judgment of the Supreme Court like
Same
that.
facts are there. Similar facts are there.
Facts of the case, it's all about interpretation. So there won't be any judgment like that.
Here, separate suit filed by respondent number 5 to 7. Kindly come to annexure D, page number 58. There in their suit, though they have led the evidence, they are not present for cross-examination. I have led my evidence. They have not cross-examination.
Two options.
Therefore,
Either notice or dismissal.
notice.
You want.
Notice.
Notice
I
to
have not sought
respondents.
for, my lord, stay of entire proceedings. I only sought for, my lord.
Notice to the respondents, petition from paper time submitted.
Siddhappa
Till
BM.
then, my lord, amendment may be, only making amendment may be deferred, my lord.
The
Notice to respondent number, my lord, 1 to 4 may be dismissed with,
1
my
to 4
lord.
dispensed with. And who are the other respondents?
5, 6, 7 only.
5, 6, 7, same council. If the memo is filed by 9th of September, list it on 10th. Yes, ma'am.
Date.
10th of
I'm appearing for the petition.
32.
My lord, suit is for declaration and permanent injunction, my lord.
Yes.
The plaint is annexure A is the plaint, my lords. Annexure B is that we have filed application under 151 of CPC, my lords, while filing the return statement. Lapse of 120 days, my lords.
It's a commercial suit or a normal suit?
Normal suit, my lords. Declaration.
Then counsel, the petition submits that the court has failed to take into consideration, or the court has refused to take the written statement on record as it is filed beyond so and so, same order like in that. Yes.
Number 33. Naga Reddy B.
The petitioner in this matter. A compromise petition is placed before the trial court that was rejected. Rejected on the ground, some future events has been stated in the compromise petition. The impugned order, annexure A, my lord. The relevant portion starts from page number 16. Para 4. Para 6 in page number 17. Thus, the compromise petition is not confined to the subject matter of the suit, namely 35 guntas in survey number 73, but also in
Where do you get that?
page 17, ink page number 17 in the order sheet, para 6. Thus, the compromise petition is not confined to the subject matter of the suit, namely 35 guntas in survey number 73, but also incorporate a future promise relating to an uncertain event, namely correction of survey record and enhancement of extent of the property by the revenue authorities. By taking this and read that it is a contingent, so that it has been, it is not maintainable. In fact, my lord, the having of the agreement itself, as per annexure.
Where is the compromise?
D, my lord.
Where is it?
Compromise is at ink page number 37. In that para 17, page number 41 even. Para 70.
Para 7.
Para 70. Because the land was granted and the grant is in respect of 1 acre 30 guntas. Having of agreement is also with respect of 1 acre 30 guntas.
What is the suit for?
Suit for specific performance of the agreement.
In respect to what is the extent?
Extent scheduled in the suit is 35 guntas. But the documents, because some mistake was.
How can there be a compromise beyond the prayer of the suit?
My lord, it is an optional thing has been written in the body of the compromise. Decree, even if it is drawn only with respect of the 35 guntas. I am not even mentioned with respect in the schedule at 45, page number 45 in the compromise, it is with respect of the very same scheduled property. And as a matter of option, I made a representation with the revenue authorities for correction. If suppose if that has been allowed, I will get the deed with respect of the correct extent. That is what I stated. It is not illegal, even if suppose.
Why should you make it so complicated? You can file a fresh joint memo, deleting all this. Court has already given left it open to you.
My lord, I was not even given an opportunity even before.
That's so in the order.
In the last.
However, it is needless to observe that the rejection of the present compromise petition shall not preclude the parties from entering into a fresh lawful compromise. Parties are at liberty to file a fresh petition confined to the amended.
That observation is only with respect of the scheduled property. If suppose if I confine to that,
without making its enforcement dependent upon any future or contingent event.
My lord, contingency in the sense, if suppose if it is illegal, I has been supported with the documentary proof before the trial court. There is a grant register with respect of the 1 acre 30 guntas. running of revenue entries were also takes place with respect of 1 acre 30 guntas.
So by way of a compromise memo, the disputes between the parties should be finally decided. or
My lord, a
compromised.
reading of this para 7, it is not that I am seeking court help to get the sale deed with respect of the larger extent.
Let us see that, come to that.
Para 7 of the compromise at page number 41 here.
What it says.
The plaintiff and defendants have joined, I will read that. Admitted and accepted that at the time of affecting survey and PODI as given above, the survey authorities of Nelamangala has unfortunately or by oversight or wrongly did a survey mistake, is preparing the survey sketch and thereby failure to incorporate the correct extent of the suit scheduled property. That is the property measuring to an extent of 1 acre 30 guntas of so and so village, 35 guntas in survey number 73 of so and so village. The incorporation, the 1 acre 30 guntas.
The court was right.
My lord, in furtherance, my lord, in page number 42. Because I am not seeking.
No, you say that the agreement of sale is for 30 guntas, but factually.
1 acre 30 guntas. I am having the agreement with respect of 1 acre 30 guntas. Because my right of getting document with respect of 1 acre 30 guntas, if I has been confined to the 35 guntas based on that revenue entry, I will, the parties will be.
Suit is filed for 35 guntas.
That has been subsequently amended, but provided I am having GPA from these dependents. They have also taken the part consideration balance on their part. Now the entire consideration they have received.
On behalf of all the parties, you filed the writ petition.
My lord?
On behalf of all the parties, you have filed the writ petition.
No, madam, only
Then they have to come.
petitioners.
Then see, let them come.
A date may be fixed, my lord. I will get the wakalat from them also.
When?
Next Monday, my lord.
Yes, not Monday. Listed on Tuesday. Yes.
Much
Number 34. Nagaya for petitioner.
Sir, two applications were filed to recall and reopen the stage for cross of DW1 minutes. Was rejected by the court saying that the witness is not present before the court. Either the opportunity was given to the other side to say at least they have an objection or not to allow the application.
Come to the.
Please, minutes. It's at page number 40 minutes, 40. At the last para minutes. Both parties are absent. Both parties are absent. Counsel for D1 files an application under section 151 of CPC. Application under 18 rule 17 read with section 151 of CPC to recall and reopen the evidence of DW1. But the defendant counsel files application without presenting DW1 before the court. On perusal of the order sheet, it is noticed that the stage has been closed.
Is it mandatory to present the witness seeking this application?
It's not mandatory, my lords. Once the application is allowed, then he'll be presented before the court for cross-examination.
What is the procedure followed in the court? Trial courts. That's the procedure. When you want the witness to be recalled, he should be there.
There has been some mistake, my lords. Yes, I agree.
And counsel for the petitioner submits that. That when an application is filed under audit or 18 rule 17, that is on 51 CPC, to recall and reopen the evidence of BW1 without even giving an opportunity to file the objections to that. And straight away on the ground that on the said day that if an evidence witness is not present, court has dismissed the application. Unless the is recalled and the evidence of DW1 is reopened, it would cause a lot of hardship. Considering they say there shall be stay of all such proceedings, notice and some. Yes.
Number 35.
Please, notes.
T. MN Raghunath MD.
Respondent. Petitioner is a tenant under the respondent. Petitioner filed a ejectment suit. My contention is I have handed over the position long back on 11/5/2020.
7/5?
11/5/2020 itself I have handed over the position.
Hmm.
My lords may kindly see annexure.
It is listed in the first list.
My lord, sorry.
24 matter.
The matter is posted for evidence in before.
No, it is posted for defendant's arguments on main. I think they have moved the matter before this.
I have moved.
Without arguing the matter before the trial court. I have completed my argument.
Only
The impugned order is stayed, please, my lord, as regards payment of arrears of rent. Lord, the trial went on. I have cross-examined DW1, I have argued the matter, and
When is the matter coming up?
it was
Day
today.
after
They have
tomorrow.
taken a date
Day after
day after by filing some frivolous applications.
Only point remains is from.
They wanted to
pay the
mark
arrears
the
of rent.
interim order
Arrears
passed by this honorable court as evidence before the trial court, so that they have filed an application. This is the conduct of the defendant.
Only point remains is arrears of rent because position is handed over. And from when?
Come to the impugned order.
Not for
My lord.
that, before my learned friend can start, issues were recasted on 20th June 2026. That is recently. Two additional issues were framed. One is, the issue reads like this: whether plaintiff proves that defendant has delivered possession of the scheduled property on 12/8/25. Second additional issue, whether defendant proves that he has surrendered possession on 11/6/2020. So therefore, court has casted burden on each of us. So it is a matter of.
Let this be decided.
That's all.
Along with the main.
Absolutely.
Without influencing the order of this honorable court.
There is
That's
nothing in this order. The only order the court says is
Come to
keeping
the-
open arrears.
Where is the order?
On 16/6/2025.
Page number.
Annexure R 91. mein. Impugned.
$95, my lord, may take. Para 11.
So now point remains is whether I have to pay the arrears of rent up to 2020 or.
The suit of which year?
Suit of
24, ma'am.
2024. Not commercial suit, please, my lord. It has to be disposed of as early as possible within 6 months. They have dragged on for almost 2 years.
My lords may
Now
kindly
the
see the
arrears of
order
rent
sheet
will
of
be
this
1
honorable
crore, please,
court.
my lord.
On 16/6/2025.
They are not going into all that now.
Only point remains that's that's why I moved my matter. Only they will mark the documents pursuant to the order of this
So
honorable
now,
court.
what I say is,
Please.
I'll set aside this order. And ask the court to decide as already issues are framed. By adducing evidence, both the parties shall.
But instead of setting aside the order, my lord can observe, this will be decided on merits, please.
What will happen to this order?
Lord,
It will remain.
Ultimately, though you're feeling that their petition is allowed, either ways, that would be the same.
True, Lord, but there is arrears. My lord,
No, I will not express anything.
absolutely, absolutely. What will Lord
Please come. Agreed with the order stated. Orders passed on I number 1 and 2 in commercial OS 10 of 2024, dated 23/4/2024, whereby by the so and so court, whereby the court directed the defendant to deposit the admitted rent of rupees 1,42,819 per month from the date of the suit till the date of disposal of the suit. And the court also observed that any amount deposited by the defendant shall be adjusted to damages, mean profits, which may be ultimately awarded in the suit. The defendant is directed to deposit the amount from the date of suit till up to date within a period of 4 weeks from the date, and to continue to deposit the amount during the pendency of the suit. The defendant has come before the court questioning the said order and a coordinate bench of this court on which date?
Stay was passed on.
9/8/2024.
9/8/2024, as state operation of the order.
Please, ma'am.
Please.
As state the operation of the order. Today, when the matter came up for hearing, learned counsel appearing for the respondent submits that on 12th June 2026, 2 additional issues.
20, please. 20th June.
20th June, 2 additional issues are framed. As per the same, an issue is whether plaintiff proves that.
I have received possession.
What is the issue?
Whether plaintiff proves that defendant has delivered possession on 12/8/25 or defendant proves on 11/6/20.
and already the issues are framed. In the light of the fact that with respect to the very same contention that are raised by the parties here, already an issue is framed before the court. This court deems it, without going into the merits of the matter or expressing anything on the legality or otherwise of this order, this court deems it appropriate to set aside this order. Accordingly, the court is passing the following order. Order dated so and so is set aside. The matter, set aside, the writ petition is allowed. This court, number 2, has not expressed any opinion on the merits of the matter. Only this order is set aside on the ground that the issues are already framed in this regard.
Without influencing the order of this honor.
And that is already said. Will not may I make
The order
one
is
more,
set aside. Where is the influence?
may I make one more request? Since it is day after tomorrow, they should not drag on the matter.
The petition, the court, the defendant shall not the petitioner shall proceed with the matter and he shall not seek unnecessary adjournment. The trial court shall dispose of the matter as expeditiously as possible.
Within 1 month.
Yes. Yes.
Obliged.
Call the next.
36.
36 Millards, and for the caveat, the respondent may seek for.
Papers are not served. Papers are not served.
They are served.
Copies served, Your Honor.
But you can't seek for adjournment because it says it's coming up. He has it's seeking an interim. Yes.
Your Honor, the petitioner is seeking to set aside the order dated 7/8/2025 against the application.
7/8/2025.
Please.
Yes, Your Honor. 7/8/2025.
Then why they are in the first list? 2025 matter.
It's coming up for the first time.
It was coming for the
Coming up
first
for the
time.
first time.
Yes, this matter in the month of September. It's 37.
Then number 37, Hitesh CS. 37, Hitesh CS, Anand Ram K.
And for the petitioner in the matter, Your Lordships, in challenging the order passed by the trial court at Annexure A, Your Lordships, the defendant,
What is the suit for?
the suit is for the permanent injunction and the partition, Your Lordships.
This is IA.
IA is for the deletion of the names of defendant number 12, 13, and 18, Your Lordship, respondent, and also to strike out the pleadings in the plaint, Your Lordships. Both the IS have been allowed, Your Lordship. That is at page number 27. That is the order
Suit is of which year?
of 25, Your Lordships.
24, Mala.
24.
Come to the order. Where is it? Page
27 is an order being passed, Your Lordships, and it begins from page number 15, Your Lordships.
Let's read from the reasoning part.
Yes, Your Lordships. The page number 23, Your Lordships, para 8, the defendant number
from 22.
20. Yes, Your Lordships. Since the
Keep the judgments ready.
there was one partition held, Your Lordships, that is also being disputed by the petitioner here.
Article 59 and 68. 65.
Yes.
Your Lordships, even the sale date which has been executed by in 2004, that is a fraud, Your Lordships, because I should also get the necessary share in the said property, because that property had belonged to my mother, Your Lordships. So I am legally.
Mother has executed the sale deed.
Yes, Your Lordships. Even then, it was
her property.
Even then, I was not being party to the said sale deed, Your Lordship.
Why is it necessary? That's her self-acquired property. She purchased the property. She can
Yes.
sell it to anyone.
Yes, Your
Not that there
Lordships.
is no the concept of joint family there.
Yes, Your Lordships. But there was one partition being executed, Your Lordships. I'm not able to fetch the copy of the same, Your Lordships. I seek for a short accommodation.
Just to add to this particular thing, my lord, the plaintiff herself is a party to that particular sale.
That's what the court has observed.
Yes, my lord. Kindly see,
I've seen, I've read
he is
the
a signatory as a witness to this particular sale deed, along with her sister. So, my lord, these are the facts which are not narrated in the plaint itself. They completely separate these particular facts. And my lord, kindly appreciate 2004 is the sale deed. When their party, they say in the plaint that they are not aware of anything. And my lord, the suit was filed in 2024, and it is also hit by my lord Delimitation Act also with respect to the challenge which they have made, Article 68. All these things have been considered by the honorable trial court.
Nation, I'll dictate the order.
Grateful.
There is a-
ಆ 230 ಇದು ಮೂವ್ ಮಾಡಿದ್ದು ಎಷ್ಟು ಮೆಮೋಸ್ ಸರ್? ಎರಡಾ ಮೂರಾ? ಆ ಫೈಲೇ ತರ್ಲಿಲ್ಲ ಅವರು.
All the rest.
Your Lordship, kind leave, my lord. One matter, my lord, filed application of vacating stay in the month of December 25. Matter has been listed for 7 times. It has not been reached. Now it has been posted in the second list. My only request is, my lord, it may be directly be posted in the first list, my lord.
We'll see. Please understand, if you start mentioning it now, everybody will come.
No, morning I thought, my lord, there's a direction to
Take the memo, we'll see. I've seen the memos and allotted. You should have also given the memo. Take the memo. Just call the list.
That's 118. Reporting for settlements.
Take that.
Those 4 matters have been listed before Lok Adalat. My lordship has spotted those matters.
Claim.
Appearing for the claimants.
1 minute.
118.
100 and?
118, my lord. It is connected with 118.1. Company appeal, my lord, 118. That, my lord, 14 lakhs with 6% interest. 14 lakhs plus 6% interest, my lord, as against 16 lakhs 55,000 with 9% interest.
MFA 1007 of 2021 is filed by the company and other write the numbers
906 of
0.1 to 0.4 or filed by the claimants. Why so many independent?
Other connected matters only claimants appeal, my lord. Only these two cases
arising out of the same
accident, arising out of same.
So the then counsel appearing for the insurance company submits that before the legal services before the Lok Adalat, they've entered into the matter is referred to the legal services authority and they have agreed, the appellant has agreed to pay some more rupees 14 lakhs with 6% interest as against 16 lakh 55,000 with 9% interest awarded by the tribunal. And the insurance company has agreed to deposit the said amount before the tribunal within 6 weeks from the date of preparation of the award, failing which the amount shall carry interest at 9% per annum from the date of default till the date of deposit. And the parties are not entitled for any cost in view of the said settlement. The connected, all the MFAs may be disposed of.
Second one, my lord, 996 of 21.
Which one?
996 of 21. That's
So,
different. 996 of 21.
1007.
Lump sum 2
MFA
lakh.
number 906 of 2021. Next.
996, my lord, 2 lakh lump sum in addition to what has been.
Give that.
And
A memo is filed before the court stating that. Where is that memo?
Yes, ma'am. There is a memo. 996 of 21.
That's 118.2. Stating that a joint memo is filed that the company has agreed to pay lump sum of rupees 2 lakhs in addition to what has been awarded by the tribunal in full and final settlement of the claim. And they agree to deposit the amount within 6 weeks from the date of preparation of the award, failing which the amount shall carry interest at 9% per annum from the date of default till the date of deposit. Considering in the light of the joint memo filed by this court, the MFA is disposed of. In all these matters, the joint memo shall be part of this order. And the amount in deposit,
In first case.
in the first case, amount in deposit shall be forthwith transferred. Yes, 118,
Another one 3367 of 21.
3367.
67. Next case, 1 lakh addition.
In addition to what has been awarded.
Yes, Miller.
Same, the parties have filed a joint memo stating that the insurance company is ready to, has agreed to pay an amount of rupees 3367.
3367.
Has agreed to pay an amount of rupees,
1 lakh.
a lump sum amount of rupees 1 lakh in addition to what has been awarded by the tribunal in full and final settlement of the claim. The next clause same, 9% so and so. In the light of the joint memo, the MFA is disposed of.
Next one,
Next.
3370 of 21.
This is
3370 of 21. 3 lakh, Miller.
3 lakhs in addition to what has been awarded
Please.
by the tribunal in full and final settlement. Same, that 9%. Yes.
Obligation.
Much over.
Cell number 37. Which one, cell number 37?
No, about these maintainability cases, 114.
Cell number 114. No? 114.
Barely permitted to furnish the Supreme Court judgment, 2009.
Take that.
Did not.
So why are you lying on this judgment? What is the order of the court?
Executive, non-bailable warranty.
Huh?
Non-bailable, NBW is. NBW permit your lordship turn to page number 31, 31 and 34. Even depositing after depositing the amount, after handing over the non-bailable warranties issued.
What was the office objection?
But
What is the office objection?
page number 31, your lordship.
This is against
Again,
Consumer Disputes Redressal Commission.
No, that was earlier. The review was, they have sent a direction to file an application for recall of the double. That also they have not considered. Again, even after deposit.
Come to the impugned order. Come to the impugned order.
31 minutes, 31 and 30, 34 minutes. 31, your lordship here. Last, page number 31, last minute. Both party called of the advocate for this so amount is either the left side there is a DD number.
Against the order passed by the State Consumer Disputes Redressal Commission.
Yes.
Now the writ petition is filed.
No, not against that. They have directed the consumer forum to consider the application if the recall application is filed. That was parameter lordship turn to the page number order.
Which is the impugned order, page number?
Order my lord 32 and 34 my lord. Warrant is issued. 32 my lord. There is a lordship to kindly put. He has deposited 1,22,000. That is acknowledged by the decree order. Still warrant is issued. Issue non-bail warrant against the through Commissioner of Police, Bangalore City.
No, this is by the Consumer Forum.
No, but still then even because it is a revision, my lord, 115, Supreme Court has said that if there is an execution period, the court can permit a large for 22 51 of the CPC, 51 of the CPC. How the process is to be, warrant is to be issued, money suit, 51 may kindly taken. Section
Where is
50.
the money suit?
It is a money suit only. It is money suit only. Amount is deposited, warrant has been reissued again, warrant has been issued. Even after accepting the DD, warrant has been issued.
Who has issued?
Consumer Forum. Executing court.
Consumer Forum executing
Yes.
court. I'm not convinced.
No, it is executing.
Please arise, please show me a
Paramount
judgment.
to the
Please
execution.
show me a judgment
32,
arising
madam, 33.
out of these proceedings, Mr. Counsel.
33, page number 33.
Yes,
This is execution petition, man.
yes,
107 but 2022.
yes,
On this, it is an order sheet.
yes.
It is an order sheet.
Hmm.
Then warrant has been given after accepting the DD. Now we will also return to section 54, 51, my lord. How the executing court has to follow the procedure while issuing the non-bailable warrant.
I'm still not able to understand that the writ petition will lie to this court.
Pardon?
I'm still not able to understand how the writ petition will lie to this court.
Madam, the question there raised in the Paramount will also return to 115. 115 revision petition. What is the ratio is laid out? High Court may call for records of any case which has been decided by any court subordinate to High Court and in which no appeal lies thereto. If such subordinate court appears to have exercised jurisdiction not vested under law, he failed to exercise jurisdiction or vested or to have acted excess jurisdiction illegally.
Let me look at it. Let's just start it tomorrow.
Pardon me?
2:30.
Tomorrow.
Yes,
Cell number 114 to 17.
yes, all matters. That continuation.
Cell number 37. One cell number 37.
Lordships, one humble submission. Even in the latest sale deed which has been executed, that is at page number 1 or 2, Your Lordship, the running page number of the petition, the first para, they say that it was as per the partition only they have got the property, Your Lordships. The mother of the plaintiff has got as per the partition, which itself means that it was one of the ancestral property itself, Your Lordships.
Where is this concept of joint family partition
Your Lordships.
under the Mohammedan law? That's the crux of the issue. Please come.
Yes, Your Lordships.
Agreed with the order dated. Order passed on I number 3 and 4. Notice number 818 of 2024, dated 29 January 2026 by the third additional senior civil judge in JMFC at Devanhalli. The petition of plaintiff is before this court. The respondent herein has filed. Respondent, who is the defendant number 18, filed an application under Order 1, Rule 10. And also
Order 6.
an application under Order 6, Rule 16, read with Section 151 CPC, bring to delete the defendant number 18, and strike out item number 4 of the suit scheduled properties. The court by order impugned had allowed the applications. The court has observed that it is item number 4 of the suit scheduled property was purchased by the plaintiff's mother through a registered sale deed dated 6/7/1972 from one Sri Chikkamuniappa, and Sri Munishammappa. The said fact has been clearly stated in the registered sale deed dated 15/9/2004, which executed by Srimati Alima B in favor of defendant number 12/113. When item number 4 of the scheduled property was purchased by the mother of the plaintiff, and she herself executed sale deed of the item number 4 of the scheduled property to defendant number 12/113. The contention of the plaintiff that the said property is also joint and ancestral property of the plaintiff and defendant number 1 to 11 is not correct. There is no concept called joint family or ancestral property for the Mohammedans. Being the Mohammedan, she cannot plead that she has birthright in the property which purchased by her mother. Moreover, when the plaintiff's mother purchased item number 4 of the scheduled property, the plaintiff was minor. The minor cannot contend that she contributed funds to purchase item number 4 of the property. Therefore, on this ground alone, the plaintiff has failed to show that she has right in the item number 4 of the properties. The suit of the plaintiff with respect to item number 4 of the properties is barred by law of limitation. Moreover, the plaintiff has not made out cause of action with respect to item number 4 of the suit scheduled property. The defendant number 18 purchased item number 4 through a registered sale deed dated 3/5/2025 from defendant number 12/113 and their family members. Further, the court has also observed that the plaintiff women say that the execution of sale deed on 15/9/2004 by the mother of the plaintiff in favor of the defendant number 12/113. The said document is not produced by the plaintiff. Since there is a reference in the plaintiff, the defendant number 18 can rely on the sale deed dated 15/9/2004 by producing the same. The defendant number 18 has produced the said sale deed. On careful perusal of the same, the mother of the plaintiff as well as the plaintiff and her elder sister, namely Srimati Farida Khanum, put their signatures as witness to the said document. Therefore, contention of the plaintiff that the plaintiff does not know the execution of the sale deed and the defendants have not intimated her is not correct because she witnessed the registered sale deed dated 15/9/2004. When she herself witnessed the sale deed, the time starts from the date of execution of the sale deed. The contention of the plaintiff that the plaintiff does not know about the sale deed is also not incorrect. On all these facts, considering all these aspects, the court has allowed the application and directed the plaintiffs to strike out item number 4 of the suit scheduled property and delete defendant number 12, 13 and 18 from the case. And plaintiff is further directed to file amended plate and carry out the amendment as per the orders. Next, Land counsel appearing for the petitioner plaintiff submits that the court has failed to appreciate the facts of the case. It is submitted that the property, even as per the document, they have got this property by way of a partition. In that case, the court ought not to have allowed the application. It is submitted that whether the application, it is barred by limitation, whether the plea is barred by limitation or not, can be decided by the court only after a full-fledged trial. But the court cannot dismiss the application. They cannot allow the application without there being unnecessary material. It is submitted that the order impugned needs to be set aside. And counsel appearing for the respondent submits that the court has rightly considered all the aspects and rightly allowed the application, and there are no reasons to interfere with the well-considered order passed by the court. Having got the counsels on either side, the perusal material on record, an application is filed under Order 6, Rule 16 of the CPC to strike out the pleadings. The provision empowers the court to strike out any part of the pleading at any stage if it appears that any matter is scandalous, frivolous, or vexatious, or which may prejudice, embarrass, or delay the fair trial of the suit, or which is otherwise abuse of the process of the court. In this case, the plaintiffs are questioning the sale deeds that are executed by executed in favor of defendants or the defendant number
12 and
12
13.
to 13, and in turn 12 to 13 to 18. The sale deed is executed in favor of defendant number 12 in the year 2004.
Yes, ma'am.
2004. In the plaint, it is stated that they are not aware of the said document, and as such, the suit is filed in the year 2024. After the defendants entered appearance and after filing this application, they placed before the court the document dated 15/9/2004. The court from the document has found that the mother as well as the plaintiff are the signatories to the same. Further, the property is, the court has observed that the property is purchased way back in the year 1972. And at that time, the defendant is a minor, and it cannot be said that she has contributed. Court also has appreciated about the concept of joint family or ancestral family. There is no concept of called joint family or ancestral family from the Mohammedans. And considering all these aspects, the court has rightly dismissed the application, allowed the application, and directed to strike out item number 4 of the scheduled properties and delete the defendants number 12, 13, 18 from the case. And this court do not find any reasons to appeal. Accordingly dismissed.
Case number 38.
Much up.
Sworn in Raju P for petitioner. Shivkumar B.
Case of divergent findings, my lord, my apologies. I need a day's accommodation. There was some difficulty. My colleague had a setback in reaching the files to me. Divergent findings. 1 day's accommodation. That's all I'm asking.
Appear for 38.1.
One matter there's an order, the other matter there's no.
That matter, there's an order of status quo. My lord, will not survive given that the construction has been completed.
They put up the construction after the order. Whatever it is, my lord.
Look at it, interim order earlier granted is extended. This is matter on 23rd of July.
Please, Milan. I'm sorry, my lord, for inconveniencing.
Yes. So 20th of August.
Case number 39 urgent 40. GV Dayananda.
I'm challenging the order passed by the City Civil Court, Bangalore. The annexure D, order dated 34/2026 at page number 37. This order came because of I have filed IN number 2 of 25. As I am having the Xerox copy of the annexure A, the original document annexure A is with the plaintiff. Plaintiff is the elder brother of the defendants, and all the brothers have got the Xerox copy of the same. The findings of the court, lower court is, I have already filed earlier similar application. Said application has been dismissed by this honorable court also, but it is not so. In the said IA, which was order passed on IA number 8, dated 13/8/2000, 10/4/2019, I sought for 5 documents. That application is available, IA number 8 under order 11, rule 14/16, page number 41 to 42. There I have sought there are 4 documents, page number 42. Lordship got the page number 41. I have sought the 4 documents. One, original mutual settlement, the present which has been dismissed, and the retirement deed.
And what is the documents you are seeking from?
Now, I am seeking the document annexure A. That is the putty has been prepared by all the brothers.
Where is it? Page number?
Page number 16. Page number 16. It is signed by all the brothers. Accordingly, it has been acted upon. Even typed copy also produced. 17 is a typed copy. 19 is 20 is typed copy. In the said IA8, I sought to produce. They said, I am not having a copy. I am not having.
What is the present stage?
Now the cross-examination of the defendant. Because either now, if I fail to produce this,
So you will, in a phased manner, you will be asking for the documents one after the other.
see, there are 4 pages are there. All the
This-
brothers
no,
have
no.
signed,
You have earlier filed an application under the similar provision seeking some other document.
some other document.
That
And
is,
there, no,
one
nimsha.
minute, 1 minute, that is on 1/4/2019.
Yes.
That is rejected, it is over.
Rejected.
Now, why
This
you-
honorable, no, this honorable court also held the law, the annexure O. Kindly peruse the annexure O, the page,
You want this step-by-step applications for the same relief.
no, in the writ petition, this court has been held. I have not sought for the production of Xerox copies. You sought the direction to the plaintiff to produce the original.
When is the order of this court?
I'll, the annexure O at page number 82 to 93. There the court has been clearly held, 92 to 93.
This order is on 18th June 2025.
Yes.
Hmm.
Your lordship kindly come to the page number 92 of para 8.
Anyhow, this order is unconnected with all that. What, no, now you
No,
are
no,
asking is a
one
different
minute.
document.
I will convince. Para 8. Considering the aspects on the stand of the respondent, the trial court has rightly come to the conclusion that they cannot give any direction to the respondent to produce document. I do not find any error in the observation of the trial court in rejecting the application, calling for interference in the present petition. In so far as the contention of the petitioner that they intend to produce the Xerox copy of the document sought for production under the aforesaid application is concerned, same cannot be gone into the present proceedings, and the same is not subject matter of the case. For the aforesaid reasons, I proceed for following order. There I have not sought, I am having Xerox copy, I am going to produce. There I have sought for direct the plaintiff to produce the original. He says I am not having original. Therefore, this court said when he is not having a
What I
original.
am asking, why are you doing it on a step-by-step basis?
No, step-
One, you will ask this, sometimes you will ask this. Every time, why you want
No,
this kind of
no,
application?
no, your lordship, don't mistake. There I am having a pakka proof, he is having a original document. What that document is required is all the properties divided
Yes, what
according
do
to
you
the
say?
annexure A.
Yes.
Annexure A, my lord. Now he is not seeking the court below permission.
Use the mic, I am not able to hear you. Yes.
Now this document, before the trial court, he has produced this document, Xerox copy. This is rather some entries in the notebook. It's not a document, any agreement, my lord.
Page number?
Let page number, annexure A only.
16
Annexure A will have a page number.
16 to 20.
16.
16 to 24.
What is this?
No, I don't know, but the document, I am no way concerned, I am not signatory, I don't know about this this document.
All are signatory.
What is this document?
Please
What are the
kindly,
signatures?
peruse the last one. See, all 4 brothers have been signed.
What is this? What is the nature of this
See,
document?
when my father was alive, he said, you take this property, you take this property. According to that, we have been divided the property, we are enjoying.
The document does not say.
All the brothers have taken the property, enjoying the same. Only the plaintiff father, after the demise of plaintiff father, the plaintiff has filed a suit for partition of the 1/4 share in the scheduled properties. This 1/4 share has to go to the plaintiff number 4, defendant number 4, as per this division of properties. Including all gold jewelries, silver articles, vacant site, fixed deposits. In all the pages, all the brothers have been signed. So kindly peruse the exhibit.
What
Annexure A.
What are his objections to your application?
Object.
What objections are filed by him to
This
your
objection is that I'm not aware of it. I don't know anything.
Come to that objections.
The objection is that
He has filed common objection to there are
Annexure
3
C.
IAs are there.
Annexure C,
Page number?
30.
30.
Three IAs he filed.
Para 2, there is objection to this IA. It is submitted that earlier the defendant number 4 had filed IA number 8 under Order 11 Rule 14 Section 1 CPC seeking direction to the plaintiff to produce the document joint family settlement between the father of the plaintiff and uncles, between the brothers of the plaintiff father, their brothers, G.P. Muddukrishna Shetty, Pandurang Shetty, G.P. Srinivasa Shetty, and G.P. Rajan. All are parties in this suit. All are defendants. All have been filed the return statement. In 2010 itself, the continuation was taken by all the defendants. There was a partition among the document was executed. All the brothers have been signed. The original is with the plaintiff father and Xerox copies are with the brothers. All the brothers have been acted upon.
No, at page number 31.
31, my lord.
Last 3-4 lines, you say that it is the very same document which he has sought in I number 8, but it is not correct.
Lord, election order, your lordship may kindly see the order of the annexure O. The very same document at Lord, para number 5 of the order of this honorable court. 31, Lord, the
Page number.
page number, Lord, 84. Annexure O.
The order of the High Court.
This honorable court order, earlier writ petition.
Hmm.
That the pleading and material available on record indicate that the respondent filed OS number 6740 of 2008 seeking for parties to separate possession of 1/4.
Mr. Counsel, he has already shown the IA. Earlier IA, what are the documents?
Lord,
This is
earlier
not
IA
the part of the document.
Lord, documents your lordship may kindly see has produced annexure E. My lord, your lordship may kindly see. Annexure E. Order 11, Rule 14. That for the first document, mutual settlement dated 31/9/1995. This is the document, my lord, now. Again, my lord, he sought for to produce the document. IA number 8.
This is dated 31/9/95.
The year is my lord, wrong in the IA 85.
31/9/1985.
85.
Please come to this document now. Let's see. Is it pertaining to the same date?
But that it
Yes.
will not say.
Let's see that.
This document.
Where do you get that? 31 years on the top of it.
No.
Like interest
It is
up
in the
to
bottom.
interest up to 31/1998.
95. Up to that date, the matter has been settled and division has been made.
Both of you are completely confusing the court, not sticking to the
No, one
submissions.
minute.
He is saying that the document in the earlier IA and this IA is one and the same.
Yes.
First, you have to first convince the court whether it is correct or not.
Not all the document. Only one document have been sought in this application.
In the earlier order, it is also
Yes.
one of the.
But in the first, your submission was it is not.
No. Yeah, in the earlier IA, this document was also there. There are 4 documents I have sought.
This is also part of it.
Yes, part of that. This court has held, you have not sought for the production of Xerox copies.
Court has never said like that.
Your lordship kindly
I've seen
exhibit
that order.
para 8.
Court has not expressed anything. It said when you made a submission, court said that insofar as the contention of the petitioner that they intend to produce a
That the
Xerox
intent to
copy.
produce Xerox copies document sought for the production of under the aforesaid application is concerned. Same cannot be gone into the present proceedings, as the same is not subject matter of the case.
So it is
There
an
I have
order
not
according
sought, I am having a copy, I am going to produce. There I have been sought direct the plaintiff to produce it.
No, he says he doesn't have.
Yes. So I am having Xerox copies, I may be permitted to produce. It is all signed by the parties.
Please come to the impugned order. Now I understood the contention. Come to the impugned order. Page number.
In this present application, IA2, may I read your lordship?
Yes.
Page number 26, IA. That for the reasons unto in accompanying affidavit, the 4th defendant prays that this honorable court may please to pass order to permit DW1 to produce Xerox copy along with typed copy for legible reading of description of settlement of assets and liabilities dated 31/9/1995, entered between G.P. Muddukrishna Shetty, G.P. Pandurang Shetty, G.P. Srinivasa Shetty, G.P. Rajanna on 31/9/1995, signed by all the above persons, agreed for the same in the interest of justice
Third
and
reserved. Yes, next.
Sale number 41.
Lords, I undertake to file wakalat for respondent number 1.
Yes.
Then number 41.
Lord, I appear for the petition.
Lords, I undertake to file wakalat for R1.
Yes.
Lord, the petitioner is plaintiff in a suit for injunction. Petitioner is put in possession of the property by virtue of a lease, sublease by the defendant number 2. Defendant number 2 and defendant number 1 have a rental agreement. Defendant number 1 is the landowner.
No, before stating all that,
Please.
suit and the IA will be suffice.
Suit for
Go to the order. then you
suit
tell
for
me.
injunction. Lord, the relevant
What is
portion of the
IA?
order,
What is the IA?
Lord, the IA is seeking for in the written statement. Lord, they make a counterclaim for my eviction, and Lord, the IA is filed on the ground that there is an admitted rent, and there be a direction to deposit that admitted rent.
Yes.
Lord, the relevant portion, Lord, of the order is at page 35. Para 24 of the order. May I read? Here at present, on perusal of the pleadings of both the parties and the documents placed on record, it is forthcoming that initially the lease agreement between defendant number 1 and 2 was for a period of 3 years, with a condition to renew the same, if desired after 3 years, and on condition of enhancement of rent for 5,000 on completion of every 11 months. Further, it is forthcoming that sublease agreement was executed between the plaintiff and defendant number 2 on 28/6/22 for a period of 2 years, with security deposit of 20 lakhs. The sublease agreement between plaintiff and defendant expires on August 24. Here, no doubt, there is no direct agreement or contract between plaintiff and defendant number 1. And the present plaintiff are sublessee under defendant number 2, who is the leaseholder of defendant number 1. However, only on the ground that there is no direct contact between plaintiff and defendant number 1, plaintiffs cannot remain in possession of the suit schedule property after lapse of lease period without paying any rentals to the owner of the property, that is defendant number 1. The contention taken by the plaintiffs that defendants have not made any prayer in the counterclaim regarding arrears of rent and that they cannot seek said relief as interim relief when they have not sought the main relief is not sustainable. Admittedly, the
Court has
sublease,
granted 2 lakhs.
2 lakhs they have directed me to pay. Now my case is only this, Lord, that there is no admitted rent between
Then how
the
are you in possession of the
plaintiff,
property?
between the plaintiff and the defendant. In fact, Lord,
How are you residing in that?
Lord, in fact, both the plaintiff and defendant number 1 are victims of a fraud. What has happened is defendant number 2 is a company. Defendant number 2 takes defendant number 1. Likewise, many such properties in Bangalore, he takes it on rent. Then he subleases it for a bulk amount. And then he goes missing with the entire amount. In fact, there are criminal cases going on against him. Now, what has happened is there is provision for sublease in the agreement between defendant number 1 and defendant number 2. By virtue of that, I have entered into a sublease and I'm in the property. All I'm saying, Lord, is that there is no admitted rent or there is no admitted rental relationship, rental amount that is due to the plaintiff by me. What is due is by the defendant number 2, who has now gone missing. If I am,
So according to you, defendant number 1 has let out the property, sublet the property to you.
defendant number 2 has sublet the property to me. To me.
Your defendant number?
I am the plaintiff. Defendant number 1 is the landowner.
Mm.
Defendant number 1 is
What
the
is the
landowner.
suit filed by you?
Suit for injunction, Lord. Where injunction? Not to dispossess me without following due process of law. That is my suit.
So you are in possession of the property.
I am in possession of the
Neither
property.
you pay the rent to D1 nor D2.
Sorry, Lord.
Neither you pay the rent to D1 or nor D2.
I have paid 20 lakhs as a one-time lease amount to D2.
For how many years?
Who is now missing for 3 years. That has not been renewed. All I'm saying, Lord, is that if the court were to arrive at any conclusion that the plaintiff, that the defendant number 1, that is landowner, is entitled to some sums, there should have been an inquiry as to what is the rental amount, either what is the market rental value and what is the rental amount that I have to pay, or at least, or in a better case, the plaintiff, the defendant number 1 would be entitled to damages against me for unauthorized occupation. For that also, there has to be an inquiry. What has happened here is, my lord, there is no inquiry. The court arrives at a conclusion that this is admitted rent and says that I have to pay 2 lakhs. 2 lakhs also how the court has arrived at, there is no reasoning, my lord, in the entire order. Simply the
Lord,
court
if
says.
I may intervene, my lords.
Property,
Sorry, my lord.
rented property, what is the extent of it?
My lord, it's a house property, my lord.
Admeasuring?
Lord, it's a 4 BHK house, my lord.
My lord, 2000 square feet, my lord,
Hmm.
is the
Located at which place?
located, my lord, in Baraswadi. Now, I am not saying, Lord, that the landowner should not receive any amounts. That is not my case at all. I am also a victim of this fraud. And all I'm saying is, if the court has
How
to
you paid
determine,
it, how you paid it to him, 20 lakhs? What is the
20.
mode of payment?
Lord, in 3 tranches, the amounts have been paid all in white. There is no cash transaction. They're all online transactions.
Yes, what do you say?
Lords, I undertake to file wakalat for R1 and I also seek some instruction from the counsel appearing in the trial court.
Then
It may
transfer
be,
the without any inquiry. Court has directed the petitioner to pay an amount of rupees 2 lakhs.
Lords,
It is submitted that before 1 minute before arriving at such a conclusion, the court ought to have conducted a minimum inquiry. Considering the same, there shall be stay of operation of the order dated so and so till the next date of hearing. Learned counsel so and so.
Lords, I may be heard before passing any order, my lord.
But
Because
in
I have been losing the rents for the past 3-4 years.
if you're ready, I can pass a final order itself.
Or
That's why
my lord, the next date is on 20th of August. It may be posted any day before that. I'll be ready with the my submissions.
This is a matter on 3rd of 7th of 1st of August, September.
Deeply obliged.
Yes.
Cell number 42. Cell number 42, Vivek, yes.
I appear for the respondents. But that copy received now that from
tomorrow morning.
Because we have not given him
a
copy.
copy now.
We should have done it. No, unnecessarily one more time, one more matter has to come tomorrow. Tomorrow. First list.
Cell number 43. Poonamesh Patil.
Petition.
Phone number 3, my lords.
Defendant's writ petition. Application lots filed seeking framing of an issue on limitation and treating it as a preliminary issue has been rejected. Lots. Impugned order is at annexure C, page 37. Lots. Its operative portion, your lordships will find at page 43 minutes.
Yes.
Please. Lots reasons notes at the bottom notes, para 8.
Yes. According to you, what is that issue of limitation?
Milords, whether that the suit is barred by limitation, and Milords, because it is a partition suit, Milords, filed in the year 2021. Milords, brief facts are, Milords, that the property was alienated in my favor by the father of the plaintiff way back in 1961 under a registered deed, Milords, registered sale deed. That, Milords, there are multiple reference in the plaint. Milords, how it's drafted, Milords, they admit that yes, the sale deed was executed in 1961, but my father did not have a right. They had a knowledge of that, Milords, yet they filed a suit after 60 long years, Milords, from 1961 in 2021, Milords.
According to them, when did they have the knowledge?
Milords, Milords, when they were leading evidence, Milords, they filed the sale deed. That certified copy of that was procured in the year 1993, annexure P, Milords, exhibit P1, Milords. Therefore, Milords, if your lordships may kindly see, Milords, at page 175, Milords. It's 174, my lords.
Evidence is required.
My lords, these documents are marked when the plaintiff starts his evidence. This is Exhibit P1, the sale deed in my favor, dated, my lords, 23/9/1961. 174 is a translated typed copy of the relevant.
According to it's only a question of fact.
My lords,
I mean, a question of law alone.
yes, my lords, it's only a limitation. And my lords, I have, my lords, even with
That no evidence is required.
it's not required, my lords, in view of the fact of the admitted fact, my lords, where, my lords, they themselves have produced a certified copy of the sale deed, which is procured by them in the year 1993. And suit is filed in 2021, my lords. Nothing but abusive process of law.
Who is the plaintiff? What is the age of the plaintiff?
Lords, plaintiff, my lords, is the plaintiff number 1 is the daughter of the propositor, my lords.
What's her age?
Yes, but plaint is at annexures J, my lords, page 115. She was 19-year-old, my lords, when the alienation had happened, my lords. Major, my lords. 115, my lords.
What do you say?
Lords, I'll just take notes, two facts notes. Firstly, there are three properties notes. 42/1, 42/2, and 42/3 minutes. He said three properties were divided amongst three brothers, Mariappa, Nanjappa, and Billappa minutes. Survey number 42/1 fell to the share of Biliappa, 42/3 minutes to Nanjappa. 42/2 fell to the share of Mariappa, which is 3 acre 5 guntas. In the year 1958, there is a partition among these brothers, and thereafter, my lords, in the 1961, April 1961, preliminary notification was issued by CITB for acquisition of these lands, three lands. And my lords, in the September 1961, my lords, the predecessors of the defendants fraudulently got executed sale deed with respect to survey number 42/2 only, my lords. And in December 1961, final notification was issued by CITB acquiring the lands. After my lords these acquisition proceedings, in the year 1964, Mariappa, my lords, was shareholder of survey number 42/2, applied for regrant of land.
They're not on the merits of the matter. The point is 1996 or 93.
93.
93, you have obtained the said sale deed in the year 1993. You have filed the suit when in
Revenue records,
2021. In
Revenue
2021, your own document. In that case, how can you say that you are aware of this document? You are not aware of it till 2021 or within the limitation? That's the only issue to be decided. Why can't the court decide it?
But even otherwise, my lords, limitation question can be framed, but it cannot be treated as a preliminary
Why
issue
should
because
no. Particularly in every case differs upon the facts and circumstances of the case. In this case, you have sought cancellation of a sale deed of the year 1966,
61.
No,
61.
No, not in entirety, because my lords, the land in survey 42/2 measures 3 acres 5 guntas.
Is sale deed you have sought for cancellation?
20 guntas is their sale deed.
Hmm.
The land my lords applied for regrant was 2 acres of
They
land.
are only concerned with their sale deed.
Lords, only with respect to the regrant land of Mariappa to extent of 2 acres, we are seeking partition.
No, my lords. Let me kindly see scheduled property. Scheduled property at page 122. It's the entire extent, my lords. That's a wrong submission.
Even otherwise,
it's 122, my lords.
Regarding the acquisition proceedings, my lords, the writ petition is pending before the coordinate bench. My lords, as my lords, the sale deed is executed after preliminary notification. The said sale is null and void, my lords, is our contention. And with respect to that, my lords, a writ petition is pending before the coordinate bench. And my lords, after these acquisition proceedings, in the year 1973, my lord, defendants obtained a property card by merging survey number 42/1, 42/2, and 42/3 illegally. And my lords, that fraud, my lords, was only found in the year 2016 when we filed a complaint before the Joint Director of Land Records.
You have come to know in the year 2016.
17.
17. When did you file the suit?
2021, my lords. We have challenged the property card obtained by defendants, my lords, in the 2017. And my lords, the learned JDLR was pleased to condone.
Let the court decide it. Let the court decide it as a preliminary issue. Please come. Agreed with the orders passed in I number 13, invoice number 638 of 2021 by so and so, dated 25/4/2026. the defendant number 7, 8, 10, and 11 are before the court. The defendants have filed, defendant number 7, 8, the petitioners herein have filed I number 13 under order 14, rule 2D and 22B and rule 5, read with section 151 CPC, seeking to frame an additional issue and try the same as a preliminary issue. The issue is whether the suit is barred by law of limitation. It is a specific case of the petitioners that the property was purchased by 10 different purchases on 23/9/1961 under various sale deeds. The sale transaction in respect of scheduled properties are completed as early as in the year 1961. And they cannot file a suit in the year 2021 seeking cancellation of the sale deeds. Further, it is a case that the plaintiffs themselves have placed the documents Exhibit P21 to P24. These documents are obtained by the plaintiff number 2 in the year 1993. It is a case that they know about the said transactions way back in the year 1993 and the suit is filed in the year 2021. It is submitted that 2021 as such they have come up with this application. The court had dismissed the same, observing that the plaintiffs have filed the suit against defendants seeking relief of partition and separate portion of 2/3 share of the suit scheduled property, and the defendants have filed their written statement. After framing of issues, plaintiff number 3 is examined as PW1 and got marked Exhibit P1 to Exhibit P40. Thereafter, case is posted for cross of PW1. In the meantime, this application is filed. The court observed that it is well settled that limitation is a mixed question of law and fact. The plaintiffs have contended that this application is filed to protract the proceedings. The principle laid down in the decision relied on by the defendants are not applicable to the facts and circumstances of the case and accordingly dismiss the petition. Plain counsel for the petitioner submits that without deducing any of the evidence, with the documents that are admitted documents as marked by the plaintiff, that is exhibit
It's P1 to P40. P1 to P40 minutes.
Exhibit P1 to P40, wherein the sale deeds are in their knowledge way back in the year 1993, and they have filed the suit in the year 2021. On the face of it, the suit is barred by limitation, and this the observation of the court that it's a question of fact and law. For fact and law cannot be sustained, it is submitted that the court ought to have decided the said issue. And with said issue, next part, then counsel appearing for the respondent submits that the in respect of the properties, after the preliminary notification is issued for acquisition, the sale deeds are executed, and those sale deeds are barred in law. In that regard, a suit is the litigation is pending before this court. It is submitted that in the year 1990, in the year 2000, what is that? 1997. 1997, when they came to know about the
Property card.
2017.
Property card.
2017.
2017, when they came to know about the property card, then they came to know about all these issues and filed a suit in the year 2021. The court has rightly held that it's a question of fact and law, and that cannot be decided as a preliminary issue, and rightly dismissed the application. Next paragraph. Having got the counsels on either side, there is a material on record. The defendants before this court are not the members of the joint family, but they are the purchasers. They have purchased the property
23/9/1961.
By way of registered document on 23/9/1961. The suit is filed in the year 2021. The sale deeds which are in favor of these defendants were marked as Exhibit P
One.
2,
There are a couple of other property documents, but sale deed is exhibit P1. P1 to
P21
P40 Milords.
21 to 24, I think.
No, Milords. P1 is a sale deed. Let's
At page number 40. Bottom, just look at from the bottom.
page 40 Milords, 40.
From the bottom, about 5 lines.
Yes, Milords.
As
The
P20
documents marked by the plaintiff, exhibit P21, P24, but P1 was a sale deed, Milords. These were the other property related documents.
The document is marked, the sale deed is marked by them, which they have obtained in the year 1993. And the suit is filed in the year 2021. In the peculiar facts and circumstances of this case, the court ought to have decided the decided the said issue as a preliminary issue in that view of the matter. The order impugned dated so and so is set aside, and the trial court shall consider the issue that whether the suit is barred by limitation or not as a preliminary issue.
Chair number 44.
Grateful.
Chair C. Ullal. 44.
Appearing for the petition, madam.
Yes.
By mistakenly, we served copy to another counsel.
By
Copy has not,
mistakenly?
Served copy to another Prashant Pandit.
Yes.
I have not
What are
received,
your instructions?
I have not received copy.
Give it to him tomorrow. Take instructions
I'll get.
tomorrow in the same, in the first list.
Chair number
Yes.
45. Girish B. Baldare.
My lordship. You give it a respond number 1.
Papers are served.
Petitioner.
There are other 2 respondents, my lord.
No, I said papers are served on you.
That's all.
Yes.
Please.
The suit filed by the plaintiff with the petitioner herein for this, only for specific performance of contract. Initially, my lordship, the duty and penalty was imposed by the trial court, and that was challenged before the Disarm Court, and the Disarm Court remitted the matter to send the document instrument to the district registrar. And after, instead of sending the very alone say, agreement of sale, along with the agreement of sale, development agreement also sent to the district registrar. That order was again challenged before the Disarm Court. The Disarm Court confirmed the order passed by trial court with the reserving liberty to approach the authorities failed to pass any appropriate order, against which they are accepting the report submitted by the registrar by the trial court before this lordship, before your lordship, which is in page number 146, my lordship.
What is earlier order? We'll see at page number 60.
Earlier order. Earlier operative portion of the earlier order, which is in page number 83, my lordship. Earlier order, the trial court sent both the documents,
It's an undisputed
agreement of
petition
sale as well as the development agreement.
So, but the petition also produced joint development.
That order was confirmed, and with the liberty reserved for the petitioner approach the court once again if the
Or not rely upon it. I am of the considered opinion that in the light of the provisions and the principles under petition bench Gunawati's case supra, the trial court will be fully justified in directing both the documents, that is agreement dated 12/3/2018 and joint development agreement dated for calculation determination of deficit stamp duty and penalty. So it is held that the deficit stamp duty and penalty.
regard to the
has
sending of the document for determination of the stamp duty. Thereafter, the liberty reserved to the petitioner in the event agreed by the calculation of stamp duty by the authorities concerned.
So because liberty is given, you want to question it?
No, my lordship. The development agreement, which is in page number 101, my lordship.
Come to the order. Page number 101.
Page number 146, my lordship. The detailed order by accepting the report submitted by the registrar. Though I have raised the several objections, it is under Article 5F. There is no convey of any right through the joint development agreement, and it is only the further transaction between the parties. Can I go through that order, my lord?
Order was passed on 27/1/2026.
Yes, my lord.
At page
Thereafter,
number 149.
thereafter,
But the said petition, but till
order was
today,
passed on 11/6/2026, my lord.
no, come to page 149, from bottom 4 lines.
49.
But till today, if the plaintiff has not paid deficit stamp duty and penalty, but he has come up with this memo seeking rejection of the report of the, when is the report of the district registrar?
The report of the district registrar on 14/5/2025, my lord.
What are you doing from then?
I'm raising the objection. I filed an objection to the said report. That was on 4/4/2026, my lord.
Your suit will go on with this stamp duty objections for the next 2 years. When did you file the suit? 2020.
98, page number 98, my lord. Filed an objection, detailed objection on 4/4/2026.
No, 2020 suit, 2026 still with the objection.
Because I am not supposed to pay the different stamp duty and penalty on the development agreement. It is only a service agreement between the parties. I take your lordship to the agreement. Whatever the contents forthcoming in the sale deed.
Page 143, will please, not 143, 150.
140.
150, 150.
150, that is the order accepting the report furnished by the district.
This is the impugned order.
Yes, my lord.
We'll read that.
I will take you to lordship to the section 5, article 5E.
Let me understand the facts of the case. Why the provision? Let's read the order, how the court has come to that conclusion.
The plaintiff society has filed the suit against the defendant seeking relief for specific performance of contract dated 8/6/2017. The plaintiff is mainly relying upon the sale agreement dated 12/3/2018 as well as the development agreement 14/6/2017. Both the deeds are unregistered documents. This court on 8/11/2024 directed the plaintiff to pay necessary deficit stamp duty and penalty of rupees 5,71,615 on unregistered sale agreement dated 12/3/2018 as per Article 5E2
The
of
court
Karnataka
simply
Stamp
said,
Act.
when you are aggrieved by the said order, you have to approach the High Court. You can't file a memo. That is what is the only reason given by the court.
No, my lordship, they have submitting the report to the court as per the order, previous order passed by this
Come to page
court.
150, that is what the court said. Here in this case,
This court
from
is
bottom,
not, hence the memo filed by the plaintiff for the court is not maintained. Accordingly, memo filed by the plaintiff whereby rejected.
page number 150 from bottom 5 about.
Yes, my lords, that's the.
Here in this case, the registrar of stamps and registration has submitted report to pay 30,98,200.
Really, if at all, if the plaintiff aggrieved by the said order, he has to approach the Honorable Court of Karnataka as ordered, and hence the memo filed by the plaintiff is not maintainable. Accordingly, memo filed by the
No.
plaintiff.
Why the court cannot look into it?
My lord, it has looked into. If your lordship kindly peruse the previous page, my lord. My lord, the last 4 lines, my lord, may I read, my
In
lord?
that,
Though the said order was passed on 27/1/2000, but till today the plaintiff has not paid deficit stamp duty and penalty. But he has come up with this memo seeking rejection of the report of the district.
understand. Now, when
But the plaintiff
document-
has not made any. May I read only one line?
I have
Please.
read it. Now, when the registrar has determined a particular value
Please.
and it has come up before the court, if the calculation is not properly done, he has every right to question it.
My lords,
Court has to deal with it. But why the court says that you have,
My lord, it
why
has
would you
come
go
to-
straight away to the?
no, my
against-
lords, it is an additional reason, my lord, which is assigned by the trial court. My lord, the first line may I read, my lord. In the memo, my lords, they had objected, my lord, to the report of the district registrar. But however, my lord, the courts, upon considering their objections, my lord, has come to the conclusion, if your lordship may I read, my lord, the first line. But the plaintiff has not made out any ground to reject the report of the district registrar of stamps and registration.
That is, it should be supported by reason.
Reasoning.
My lords,
It can't just say one line. He has placed his objections before the court. Court has to say why his objections cannot be considered.
Lord, in his objections also, my lord, he says, my lord, that the calculation is wrong. Except that, my lord, he does not say how, my lords, it
How
is.
the calculation is right, the court has to say.
It is only, my lords, in addition to holding, my lord, that the.
But this is not the order. Court ought to have given reasons. No, even for this court also to say, if had the calculation been here,
It is here, my lord. It is, my lord, they have produced, my
how
lord.
the court has discussed. If the court discusses and says that this is right, wrong, on what basis, then the court will be able to decide it. No, I will not look at it and I'll not, this court under 226 will not do the text. Please come. How many other respondents are there?
There are two other respondents, my lord. In fact, I had appeared, my lord, in the previous round of litigation.
You will appear for them
My lords,
also.
my lords, I have not filed wakalat as of today, my
Shall I
lord.
say that you
My lords, I undertake, my lord, to file.
undertake to file?
Lordship may direct the learned trial judge, my lord, to reconsider. My lord.
Within 1 week, I'll say.
Please.
Agreed with the orders passed on objection memo filed with the plaintiff against the report of the district register of stamps and registration dated 11/6/2026. The petitioner plaintiff is before this court. When the suit agreement of sale and joint development agreement.
Please.
Joint development agreement was sent to the registrar.
I make one submission. Joint development agreement is nothing but the further transaction of the agreement.
I'm not saying anything. For calculating the deficit stamp duty, that the registrar has given a report that the petitioner has to pay an amount of 30,98,200 towards stamp duty and penalty.
So it is, I'm sorry, it is 34 lakhs.
34 lakhs. Thereafter it has been
20 rupees.
corrected.
Total amount is 34 lakhs.
The order everywhere it is
My
mentioned.
lord, it is again, my lords, modified. There is a separate order by the learned trial.
34 lakhs.
34 lakhs, 8,020. 20 rupees.
34 lakh 8,020. 20. Then the petitioner has filed a memo objecting to that the no rights that the document styled as memorandum of understanding, the stamp duty is not payable at that, and he has raised certain objections. The court by order impugned has rejected the applications, observing that one, that plaintiff has not made out grounds to reject the report of the district registrar of stamps and registration. And second, when the calculation is placed before the court, when the calculation is placed by the registrar, the petitioner ought to have approached the High Court under 227, but he couldn't have filed a application. Couldn't have filed a memo disputing the calculation and accordingly dismissed. Land counsel appearing for the petitioner submits that the joint development agreement is not chargeable as calculated by the registrar, and on that he has made several objections by the way of this memo, and the court has failed to consider the same, and without any reasons had rejected the memo. Next paragraph. And the order same, then the order impugned needs to be set aside. Land counsel appearing for the respondent. Land counsel who has filed the caveat on behalf of respondent number 1 submits that he has instructions to file wakalat to appear on behalf of 2 and 3.
Please.
2 and 3.
Please.
On behalf of 2 and 3. It is submitted that the court has rightly considered and in fact recorded the reasons why the memo is rejected. It is submitted that there are several rounds of litigation on the stamp duty, and the petitioner is trying to protract the proceedings. It is submitted that there is no infirmity with the order passed by the court. Hence, the writ petition is liable to be dismissed, having heard the counsels on either side. There is a material not recorded. The documents or the agreement of sale and the joint development agreement. The registrar has stated that, has calculated it and stated that the penalty and the stamp duty is so and so in the preceding paragraph. It is there. 34 lakhs is so and so. The plaintiff has filed his objections. It is a bounden duty of the court to consider those objections and pass a reasoned order why those objections cannot be sustained and how the calculation arrived at by the registrar is correct. But unfortunately, in this case, the learned judge has not done any such exercise except observing that the petitioner ought to have approached the High Court questioning the calculation, questioning the amount that is arrived at by the registrar. In the considered opinion of the court, the order impugned is bereft of reasons. Accordingly, the order is set aside and the trial court is directed to, accordingly, this court is passing the following order. The writ petition is, the order dated so and so is set aside. The matter is remanded back to the court. Number 2, the trial court shall consider the objections within a period of 1 week and shall pass appropriate orders.
Then
Make Make
number
a submission,
46.
ma'am. Liberty is to raise any more objections.
We will not grant. Yes.
Cell number 46, Devaraju HV for petitioner.
This case I appear for the petitioner. That this, where the intention was drawn in the year 1984-85. Not that claimants, not the land was purchased in the year 1994. 1994. The entire extent of land 1 acre 5 guntas. Of rupees consideration 1,50,000 rupees. That the till 2016 they are not come forward to claim any compensation. 16 they have come forward to claim compensation. That we are rejected. Their approach before the district judge under 16(3) that the district judge that passes an order to pay 90% of the prevailing market value, including solatium, 9% interest. That order which has been passed. That as per their purchased land, before that we have line was utilized. According to us, that line drawn is a 5 guntas. That is a access. There is no tower erected.
So you have not paid compensation to anyone.
Even that at this stage, that calculation as per that their purchased land is concerned, per gunta comes 3,330. According to their claim, the 10 guntas we have utilized. It comes that 33,300. Even interest calculate that the entire that they are entitled up to 1 lakh. That will deposit subject to that outcome of the.
How much is granted by the court?
The court has not determined this much of the amount. May kindly operative portion may kindly. Prevailing the operative portion page 194. The respondent directed to pay compensation to the petitioners. 60 line at 90% prevailing market value, together with solution 30%, with interest 9%.
Prevailing market value means.
And the present rate.
It is accepted, my lord. Paragraph 48, page 191.
Huh?
Page 191, my lord. 9,000 square feet, my lord. It is
That they are claiming.
It is not disputed, therefore it was. Paragraph 48, my lord. Page 191. The valuation of the affected land of rupees 9,000 per square feet by the petitioners has not been rebutted by any cogent evidence from the respondents. The onus of proof shifted to the respondents once the petitioners discharged their mutual burden.
Have you contested this matter?
That the respondents have not served.
Further, my lord, this type of endorsement.
Why you have not contested?
That we have contested, we have filed objections, we have denied everything. You have taken a limitation ground also.
That is one. Then.
That even that value also we have taken that market value that we have purchased 1,50,000 rupees. That is the entire land is concerned. Even according to sale deed.
Further, my lord, paragraph 50, 51.
Why can't the authority make the calculation? While passing the order, the court should make a calculation basing on what is admitted market value, whatever it is. So no, it is left to the parties. Is calculation something and the respondent calculation something?
Further, my lord, paragraph 51. Same similar endorsement has been quashed by this honorable court, my lord.
That we are not disputing. That quash and remitted they have approached before district. By calculating that.
Rejection order runs contrary to the High Court's order in WP number 9912 of 2000. What is that?
That petition rejection endorsement has been
quashed. Show the court what is that order when the court specifically records it.
That endorsement I that order I
the endorsement is also extracted.
That is where that pay compensation, even that it is in concern.
That matter also Devaraj on there.
That I have not. At annexure. Annexure J, page 83, I have produced.
No, there is no dispute on this because it's right to property. all delay in claiming the compensation and all cannot be a ground. Now the issue is with regard to how they are liable to pay as per the market value when the order is passed. That's the only question. How much it comes?
Let that, if 10 guntas according to measurement says that per each gunta 3,300.
Have you placed any evidence? What is land?
Their sale deed itself has been marked. The entire land which has been purchased, their sale deed itself is marked. That is 1,50,000 rupees per acre. Per entire land, 1 acre 5 guntas they have purchased. Their sale deed itself.
Please come. In council appearing for the petitioner submits that the electricity lines were drawn when 2000?
That land was purchased in the year 1994.
In the year 1994. And you have drawn the lines?
1984-85.
1984-85.
85.
1984 and 85. Now the court has passed an order directing them to pay the compensation as per the market value at 90% of the market value, together with solatium at 70% and interest at 9% per annum from 2012-2016. It is submitted that the court has failed to consider the market value as on the date the lines were drawn, but to consider the prevailing market value as on the date of passing of the order. Considering the same, there shall be stay of all further proceeding on the condition pursuant to the order dated so and so. Same to deposit 2 lakhs.
Much.
We'll see.
Private respondents also there, Mother.
You appear for?
I have taken already last occasion, Mother, I have taken notice.
Notice
Respondent
to
number
the-
3 to 5 are private respondents.
Notice to 3 to 5. Yes, next.
Number 47, Subramanya Bhatt, M for petitioner.
I appear for the respond. Back billing order, my lord, no doubt, my lord, there is an appeal provision under section 127. But my lord, still I have filed this writ petition, my lord, for this reason. But in the year 2013, an identical back billing charge was imposed against me, my lord, on the ground that, my lord, there is an appeal provision under 127, my lords.
Take that.
Okay. In fact, your lordship's order, my lord, I do concede. But my lord, the distinguishing feature here is that, my lord, in the year 2013, an identical back billing charge was my lord, issued against me, imposing, my lord, at that point of time about 93,000 rupees. Then, my lord, the then assessing officer, he reviewed his own order and, my lord, set aside the back billing charges on the ground that, my lord, this petitioner charitable.
It was.
Beg your lordship.
When was it? When was it?
My lord, that is in the year 2013, in respect to the very same installations.
Now we are in 2026.
That is true, my lord. My lord, at that relevant point of time, my lord, the back billing charge was set aside on the ground that this petitioner charitable trust having been exempted, my lord, under the Income Tax Act, my lord, domestic tariff is leviable. Now, my lord, after 13 years, my lord, the very same assessing officer, my lord, takes a U-turn and says that, my lord, now I am liable to pay it. Please see, my lord, the previous order I have produced at page 26,
Where is the
annexure
present
C.
order?
My lord, this is dated 13/9/2013. Kindly have a look at page 26, annexure C.
Where is the present order?
Lord, the present order is at page 66, annexure K. Lord, the installation RR numbers is found at page 67. Same, previously, Lord, there were 2 meters.
No,
Now,
this order is dated page 66.
66, my lord, is dated 11/5/2026.
22/8/2025.
No, this 74 is the date of the order, my lord. Page 74, dated 11/5/2026. This is under challenge in the present writ petition.
Oh, how can this court can deal with all what is happening from 13 to this?
My lord, this exemption certificate, my lord, still it was in currency. My lord, as on the date of the back billing, which was imposed in the year 2018, which has been affirmed now.
How it has been, how the authorities have dealt with it? Please
Yes,
come to
ma'am.
the order.
Yes, my lord. Please turn to page 73. Conclusion. The respondent has submitted the trust deed, IT exemption copy so and so of the Income Tax Act 1962 and trust registration copy of Mr. Sashraya Udyoga Seva Samiti pertaining to address at number 47/1 Model House Street, Basavanagudi, Bangalore, which cannot be considered for address number 19/33 Sannidhi Road, Basavanagudi. Lord, this is another unit of the same establishment, same trust. Now, my lord, unfortunately, the assessing officer says the exemption, my lord, is relatable only to the other center and not to this unit.
Where he says that?
My lord, page 73. 72. Conclusion part.
Yes.
The respondent has submitted the trust deed, IT exemption copy, 12A Income Tax Act 1962 and trust registration copy, ATG of Mr. So and so, pertaining to address number 47/1 Model House Street, Basavanagudi, Bangalore, which cannot be considered for the address number 19/33 Sannidhi Road, Basavanagudi, Bangalore, in which the backbilling charges have been raised for misuse of tariff. Also, AWE Vigilance, who was a part of the hearing conducted on so and so, opined the same. This is the ultimate conclusion.
So last one, kindly see minutes, page 72. Grounds for
So
rejection.
you're giving, building becomes a charitable or that,
If there are running say 5 units, 10 units, each unit needs to be exempted by the income tax department. Then it becomes a domestic. Otherwise, it's a misuse of tariff.
No, earlier it was done by the.
There are 2 units. There are 2. One is Ashraya Udyoga Samiti. At
Do you have that exemption under the Income Tax Act?
Yes,
they have for this. For the other one, which is now back billing is made for Sannidhi Road. They don't have that.
Organization is one and the same. That
Kindly
organization is.
Kindly see page 73.
Is it your case that it will be given to each and every?
Page 73 item 4. Page 73 serial number 4. The name and address mentioned in the rental agreement. This is what they submit. In the event that the rental agreement executed during January 2017 is accepted as genuine, then the back bill has to be restricted from the date to the date of change of tariff affected. The name and address mentioned in the rental agreement is between CS Mahalakshmi and Avinash. Nowhere trust name is mentioned in the agreement. This is the agreement for the building, which the trust is. There is no the trust name is not mentioned at all. They are running a PG center.
What do you say?
Lord,
based on these documents.
Lord, I'll just compare two documents. Kindly turn to page 26 for a moment, Lord. Page 26. Lord, preamble, first paragraph itself, Lord, they mention the RR numbers. There are 2 RR numbers at page 26. Last line of first paragraph. In premises bearing with RR number so and so 2812 and 9434. These are the 2 installations. Now kindly turn to page 67. My lord, there are 3 RR numbers here. At item number 1.
You please consider their case.
Let it file an appeal. There is an appeal provision.
If it is an appeal, they have to pay the amount, isn't it?
Yes, madam.
It's a charitable organization. Please consider their case.
Lashmi, can you remind this matter again?
Please come. petitioner.
Then produce my lords any document showing my lords the exemption is also for this.
In accordance with law, you
Yes.
please, you take all the documents from him. Where is the exemption given by the income tax department or whatever it is? Take all the documents. If they don't produce, then give a reasoned order for that.
Please.
The petitioner is before this, the writ petition is filed, seeking the following order. Then counsel appearing for the petitioner submits that. The petitioner is registered under the Karnataka Societies Registration Act 1960. The trust was formed and registered with several objects such as establishment and maintenance of hostel and boarding houses for the needy people, especially for women, irrespective of caste and creed. On 17/4/2012, the Director of Income Tax, within bracket exemptions, Bangalore granted the exemption to the trust under Section 80G of the Income Tax Act 1961. The headquarters of the trust is located at 47/1 Model House Street, Baswannagudi, Bangalore. The petitioner's trust started a women's hostel at house number 33/1 Meghalaya, Sannidhi Street, Baswannagudi, Bangalore. Earlier, when, that is by proceedings dated 3/9/2013, when the assistant executive engineer had imposed back billing of charges of rupees 75,123 and rupees 56,273 initially, then thereafter, after being satisfied that the petitioner trust is a charitable institution, he reversed and set aside the back billing charges. The BESCOM arranged power supply to the said premises by one more installation through meter bearing number W2P1540 under LT2R tariff, duly taking note of the exemption granted by the Income Tax Department. On 15/7/2017, BESCOM vigilance team inspected the premises and levied back billing charges of rupees 14,70,564 for 3 years from July 2014 to May 2017 in relation to 3 installations alleging misuse of tariff. When an order was passed on 29/7/2017, the petition has approached the Consumer Grievance Redressal Forum. Then on 31/1/2018, the matter was remanded to the assessing officer, directing him to consider the objections filed with the petitioner against the provisional assessment. On 26/2/2018, again the assessing officer passed the order confirming the back billing charges. Petitioner again approached the CGRF challenging the order dated 26/2/2018, which dismissed the complaint of the petitioner by order dated 27/7/2019. The petitioner has approached the ombudsman and challenged the order passed by the CGRF. On 17/12/2019, the orders were set aside. The assessing officer has filed WP number 1678 of 2022 before this court and challenged the order dated 17/12/2019. And the writ petition was allowed and quashed the order dated 29/7/2017. On 6/10/2025, petitioner has filed a detailed representation before the assessing officer how he is entitled for the exemption. By order dated 11/5/2026, the assessing officer passed an order upholding the back billing charges imposed on the petitioner by order dated 26/2 has affirmed the order dated 26/2/2018 with a direction to the pager same within 30 days. Land counsel appearing for the petitioner submits that when the petitioner is having a exemption and wherever and it is not restricted to one premises, wherever the set wherever the petitioner society is running the institutions, they're all exempt. They all have the exemption under the provisions of the Income Tax Act. All these aspects, in spite of bringing it to the notice of the respondents have failed to consider the same. Land counsel appearing for the respondent submits that the petitioner have an appropriate remedy before the appellate authority under section 127 of the Electricity Act. As such, the present writ petition is not maintainable. Secondly, the premises for which the back building charges are levied, the agreement is not in favor of the petitioner society. It is submitted that considering all this has rightly passed an order and no interference is called for next for having heard so and so. There is no dispute about the fact that there is an appellate and the petitioner has a right of appeal under section 127 of the Electricity Act. As far as the facts of the present case are concerned, according to the petitioner, it is a charitable institution. And they already had, they have the exemption and the income tax, and even the respondents have also granted exemption earlier. Now, it is a case that they have taken a U-turn and refusing to grant the exemption, and they have raised these back billing charges. It is amounting to an amount of rupees 14 lakhs. If the petitioner has to file an appeal, he has to pay 50% of the amount. In those circumstances, considering that petitioner is a charitable institution, this court has this court is inclined to consider the matter on the merits of it. The reasoning that is given by the respondents that in respect of one premises they will grant, and they were granted earlier in respect of a premises, and respect of the other premises they will not grant. That reasoning this court is not able to understand. The exemption is to the institution or to the charitable institution, but not to a particular premises. And the second contention that is raised is that the said premises, as per the lease agreement, the charitable institution is not a party to the said agreement. If that objection, as stated by the respondent, appears to be this court finds force in the said submission. In those circumstances, balancing the interest of both the parties, this court is passing the following order. The order impugned dated so and so is set aside, and the matter is remanded back to the which respondent?
Second respondent.
Back to the second respondent. The petitioner shall appear before the second respondent on 18th of August with all the relevant documents pertaining to the lease and the exemption that is granted by the income tax, and basing on the said documents, after hearing the petitioner, the respondent shall pass appropriate orders. Till such time, no coercive steps shall be taken.
Great. Please.
We'll see. 4:30. Till 4:30 you continue this.
To appear on behalf of
Till number 48.
to appear on behalf of the petitioner counsel. My lord, this is the defendant's writ petition, my lord.
for
the
responding.
plaintiff
Senior counsel
respondent
is
before your lordships had
if
filed a
court
suit for
again,
declaration.
tomorrow may be taken up, my lord.
My lord, this every time they're doing that, my lord, this matter has come up before your
This is the
lordships
first
on
time
3
it is
occasions
listed.
earlier, my lords. If your lordships would recall, my lord, twice and then on the previous occasion. My lord, this is a matter of court fee in a suit for declaration, my lord. We have filed an application under
No,
section 11.
later only you are entitled for a hearing, not that you will seek adjournment.
No.
I will give you time. I will hear him and if necessary, I'll pass orders and then leisurely you can come. Yes.
My lord,
Yes.
so this is, my lord, the defendant's writ petition. Plaintiff respondent before your lordships have filed a suit for declaration. In that, my lord, we have filed an application under section 11(2) of the Karnataka Court Fees and Suit Valuation Act. My lord, now this 4 acres of land, my lord, now falls under earlier BBMP limits and now under the Greater Bangalore Authority. My lord, now the full bench judgment of our Honorable High Court, my lord, has held that once it comes under the municipal corporation limits, then my lord, it has to be on the market value of the land and that has to be taken and not agricultural. My lord, we have the judgment of the Honorable full bench, my lord. My learned friend would produce it before your lordships.
I've seen that yesterday.
Yes,
I've
yes,
seen that.
yes. Now the question is this, my lord. In fact, the office itself, if your lordships were to see impugned order at Annexure A, even prior to us filing an application, if your lordship turns to page 19 of the order sheet, my lord, office note, my lord, the office has raised this objection. My lord's got it, my lord.
When the matter is coming up,
My lord, it was listed today for framing of issues. It is not yet done, my lord. There is no status on the next date.
when is it posted now?
Today it is not yet updated.
Please come. Senior counsel representative comes for the petition. Submits that. The court has failed to, court had dismissed the application that I have filed, that's I number 2, without considering the fact that the suit scheduled property is situated within the municipal corporation limits.
May I make small submission, my lord? In this suit, my lord, there is no order against them. The tribunal held that the issue regarding the court fee will be taken up after framing of issues as a preliminary issues. This is the tribunal kindly directed to consider it as a preliminary issue.
Yes, Mr. Senior Counsel, the matter, it is not concluded.
No, my lord, here what has happened is their suit is for declaration. My lord, the Honorable Division Bench says, as and when a contention is taken with regard to court fee, that has to be considered first. What the trial court does, my lord, is that if your lordship sees the impugned order, my lords, in the end, that is only the order sheet. The impugned order, if your lordship sees, they say that after the issues are framed, after the evidence is recorded, then the court will consider what will be the court fee. My lord, but the division bench ruling may just produce a copy of the order, my lord. So this, my lord, should be tried even before at the very first instance itself. It has to be tried.
Listen, heard the senior counsel at the request of learned counsel for the respondent. This is a matter on 18th of August. Yes, next.
My lord, interim order we are seeking, my lord. Because
who interim order in this? What is going to?
They'll produce with framing of issues and evidence.
They can frame the issues. What will happen? Court fees anyhow, what they have to pay, they will pay. If not today, tomorrow.
No, my only submission. May I just make this? If your lordship just for a moment looks into the division bench ruling of this honorable court, which says, my lord, very clearly. May I just?
If the order is bad, that we will set aside. For that, it has no connection with the suit to be proceeded.
No, what I'm submitting is this, my lord. What your lordships are saying, my lord, I'm in the complete agreement. My lord, what the trial court, if your lordship sees, they say that, my lord, that this will be considered after the, my lord, virtually after the trial.
That's why I have not dismissed your case. They're asking time. I've given a date. That day we will decide it.
My lord, but then now.
But we'll not grant stay. It's not a case for stay. Yes.
Till number 49. Ensure the record.
For the respondents.
Before the petitioner. 34 petition before the civil court, my lord, side filed an application for additional evidence. My lord said yesterday posed a question on whether how a writ would be maintainable. My lords, may kindly have 34 for a moment. My lords, I'll explain as to why, my lords, I have no other option but to file a writ under 227. Because, my lords, 34, what happens, my lords? I can only challenge the order of the final order of the 34 court, my lords, under 37. That will come up.
That is what precisely you said, and I've also asked you. So when the provision says you cannot file any, there is no other remedy, then you have to come under 227.
No, my lords, what happens here?
The same analogy has to be applied. It applies to all the.
No, not all. My lords, in 34, as I was saying yesterday, my lords, only two things I can file in a 34.
Take that.
My lords, ideally, my lords, I can only file an application under 36 of the Arbitration Act in the 34 proceedings asking for stay of the arbitral award, so that execution doesn't go on. My lords may also have this. My lords, what happened, my lords, in FISA developers, this honorable court first said, my lords, in a 34 petition, I can file additional evidence in exceptional circumstances. My lords, that was taken in a writ petition. This honorable court said it is permissible, went to Supreme Court, it was affirmed. Then, my lords, 34 came to be amended. My lords, unamended 34 said that while furnishing proof, I can say, my lords, it's patently illegal. 2019 amendment happened. There, my lords, it was
Arbitration Act.
Please, miss. So I'll just explain, my lords, why I have no other option but, my lords, to approach this honorable court.
First, we will see what the act says.
Please, my lords. My lords may have 34.
It's arising out of
a section 34 proceedings, my lords, under the Arbitration Act. This may I read, my lords.
Yes, please read.
I'm sorry.
Yes.
My lords, recourse, application for setting aside arbitral award. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. An arbitral award may be set aside by a court only if, my lords, A, the party making the application establishes on the basis of the record of the arbitral tribunal that the party was under some incapacity, or the arbitration agreement is not valid under law to which the parties were subjected to it, failing an indication thereon under the law for the time being in force. My lords, may kindly see what the amendment was substituted for. My lords, the footnote. My lords, it initially was before 2019's amendment. My lords, may I have the footnote then?
It's not there. It's a very.
I'll just pass along my copy. That's where, my lords, the.
Yes, where 2014 edition.
My lords, the crux of the issue, my lords, lies there, and my lords, my humble submission is, my lords, will have to lay down the law there, my lords, on what will have to happen. My lords, the substitution, if my lords look at the footnote. My lords, before 2019, my lords, I could furnish proof that it is patently illegal. After 19, my lords, the law has restricted that, saying that only on the basis of the arbitral record. My lords, I'll take, my lords, of the exceptions in a moment. My lords, may kindly now, my lords, take section 36 and 37 as to what the scope is. My lords, under 36, if my lords may take 36 subclause 2 minutes. I'll read from 1 minute. Where the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with the provisions of CPC in the same manner as if it were a decree of the court. Where an application to set aside the arbitral award has been filed in the court under 34, the filing of such application shall not by itself render the award unenforceable unless the court grants an order of stay of the operational state award in accordance with the provisions of section 3 on a separate application made for that purpose. My lords, the only thing contemplated in the 34 proceeding, my lords, is a 36 application to stay the award. Next, my lords, yes, my lords. Upon filing of such application under subsection 2, for stay of the operation of the arbitral award, the court may, subject to conditions as it deem fit, grant stay of the operation of such award. My lords, that I've already filed. It is accepted. I have deposited that amount also. Now, my lords, what happens after a 34 is filed and an order is passed is contemplated in 37.
Yes.
My lords, 37 reads as under, my lords, appealable orders. Notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders and from no others to the court authorized by law to hear appeals from original decrees of the court passing the orders, namely, A. Refusing to refer the parties to arbitration under Section 8, granting or refusing to grant any measure under Section 9, setting aside or refusing to set aside an arbitral award under Section 34. My lords, only see, my lords, what I can challenge in a 37 is either the allowing of the 34 or the dismissal of the 34, one of the two.
No interlocutory.
My lords,
No interlocutory orders.
no interlocutory orders. My lords, my difficulty is, my lords, if I don't approach this honorable court today, my lords, I'm remedialist because I cannot challenge the rejection of my application in 37.
You can't. That is not the explanation to say that in Section 37.
My lords, 37, my lords, there is no explanation there. My lords, 37C says either the setting aside is appealable.
No, this whatever the case you are stating, that unless and until I question this order, I am helpless. That is the same for everyone under the arbitration proceedings.
No, my lords, the difference is only this. That's what I'm saying, my lords. I am on a very limited ground only for this reason that, my lords, in a 34, I cannot file any other application, my lords. There is no scenario where I can come before this honorable court.
That is what is contemplated under the Act.
Yes, my lords, minimum judicial interference, I understand. But, my lords, time and again, this court as well as Supreme Court has interfered in writ jurisdiction, where, my lords, if I have set up an exceptional case to file additional evidence, my lords, in my case, what has happened? 2 crores, my lords, the arbitrator has said that I have to make the payment. I have already made that payment. The claim was not made before the arbitrator that the 2 crores is payable. But, my lords, on the virtue of the oral arguments made by the claimant, the arbitrator says, yes, you have to make the payment. Now, my lords, the only way I can tell the learned trial court that I've already made that payment, otherwise I'm doubly taxed, is if I show the proof of payment. My lords, the learned arbitrator never had the occasion to call upon me to lead evidence to show that I've made that payment. Without that, the award has been passed. All I'm saying, my lords, is if that evidence is taken on record, the learned trial court can then, my lords, come to a conclusion that this portion of the award, my lords, is not enforceable because I've already made that payment. For that, I filed that application. Only, my lords, that is the only application except Section 36 application I can file in a 34 proceedings, nothing else. My lords, to answer my lords' concerns that this would open a floodgate, I understand where my lords are coming from, that otherwise it would open a floodgate. Any, my lords, order passed by...
For every litigant, that is exceptional case.
No, my lords, I fall specifically under what my lords, Supreme Court has said is an exceptional case.
Where is that?
Please, my lords. My lords, we come to page 46, my lords. I'll just explain, my lords, the first judgment of visa developers, my lords, was before the first amendment to the Arbitration Act. There, my lords, the court said, if there is proof given, then you don't have to frame issues and convert that into a regular trial.
Yes.
Then, my lords, was MK Global Financial. That was, my lords, when the amendment of 2019 was still tabled before the parliament but not passed. My lords, we come to MK Global first at page number 13.
You show something after the amendment.
My lords, after the amendment is, my lords, Alpine at 46.
Yes.
Let's now come to paragraph number 18, my lords, in that. My lords, before that, my lords, may request my lords to take my lords the MK Global judgment, because there, my lords, I'm sorry, my lords, the third judgment of Canara Nidhi at page 30. My lords,
we'll complete this judgment.
Please, my lords, this is pre-amendment. My lords, I was wrong. My lords, Alpine, though the judgment is 23.
Page number.
My lords, page number 33 is my lords Canara Nidhi, that is post-amendment. My lords.
Yes.
My lords, paragraph 18, if my lords were to take my lords at page 42, my lords. Now, so I'll start from page 41, para 17, my lords, because the amendment came about after Justice B. N. Sri Krishna's committee's report.
Yes.
My lords, based upon Justice B. N. Sri Krishna committee's report, Section 34 of the, my lords, got it, my lords?
Yes, yes.
Section 34 of the Principal Act has been amended by the Arbitration and Conciliation Act as under. Amendment to Section 34. In Section 34 of the Principal Act, in substitution of subsection 2, in clause A, for the words furnishes proof that the words establishes on the basis of the record of the arbitral tribunal shall be substituted. After referring to Justice B. N. Sri Krishna Committee report and other judgments and observing that the decision in FISA developers must be read in the light of the amendment made to 34 subclause 5 and 34 subclause 6 of the Act and the amendment to 34 of the Arbitration Act in 1996, in MK Global Financial Services, Girdhar Sondhi, it was held as under. It's relevant. I'll just read those two paragraphs as well. It will thus be seen that speedy resolution of the arbitral disputes has been the reason for enacting the 1996 Act and continues to be the reason for adding amendments to the said Act to strengthen the aforesaid object. Quite obviously, if the issues are to be framed in oral evidence taken in the summary proceedings under 34, this object will be defeated. It is also on the cards that if the bill number 100 of 2018 is passed, that means is the Sri Krishna Committee's bill, then evidence at the stage of section 34 application will be dispensed with altogether. Given the current state of the law, we are of the view that two early Delhi High Court judgments in so and so cited by a Syrian above correctly reflect the position of law in furnishing proof under 34.2. So does the Calcutta High Court judgment in so and so. We may hasten to add if the procedure followed by the Punjab and Haryana High Court in so and so is to be adhered to. The time limit of 1 year would be observed in most cases in the breach. We therefore overrule the said decision. We are constrained to observe that FISA developers was a step in the right direction, as its ultimate ratio is that issues need not be stuck at the stage of hearing of the 34 application, which is a summary procedure. However, this judgment must now be read in the light of the amendment made to subsection 34, 5 and 6. So read, we clarify the legal position by stating that an application for setting aside an arbitral award will not ordinarily require anything beyond the record that was before the arbitrator. However, if there are matters not contained in such record and are relevant to the determination of the issues arising under 34.2a, they may be brought to the notice of the court by way of affidavits filed by both the parties. Cross-examination of the person swearing to the affidavit should not be allowed unless absolutely necessary, as the truth will emerge on the reading of the affidavit filed by both parties. We therefore set aside the judgment in Girdhar Sondhi versus MK Global of the Delhi High Court and reinstate that that the learned additional district judge so and so, the appeal is accordingly allowed with no order as to course. Next. The legal position, this is what the court considers the 2019 amendment and says, the legal position is thus clarified that section 34 application will not ordinarily require anything beyond the record that was before the arbitrator, and that cross-examination of persons swearing into the affidavit should not be allowed unless absolutely necessary. I'm only saying these minutes. If I'm able to demonstrate that what I requested the learned trial court to consider on an additional affidavit is an exceptional circumstance, then it should have been allowed. Because without that,
you're still not, this judgment do not support your case about the your remedy.
Here also writ petition was filed, which was taken all the way to the Supreme Court. Otherwise, the judgment I just passed along on the power under 227, where the Radhesham judgment will come to para 25 minutes.
Unfortunately, no consistency in law.
Yes, in fact, in Radhesham, what had happened was the revision petition amendment had come up in 115. Writs was filed against para number 25 minutes. That's at page 447, the internal page 447. It is true that this court has laid down the technicalities associated with the prerogative writs in England and have no role to play under our constitutional scheme. There is no parallel system of King's Court in India, and all the other courts having limited jurisdiction subject to the supervision of the King's Court. Courts are set up under the Constitution or the law. All the courts in the jurisdiction of the High Court are subordinate to it and are subject to its control and supervision under 227. Writ jurisdiction is constitutionally conferred on all the High Courts. Broad principle of writ jurisdiction followed in England are applicable to India, and the writ of certiorari lies against patently erroneous or without jurisdiction orders of the tribunals or authorities or courts other than judicial courts. There are no precedents in India for the High Courts to issue writs to the subordinate courts. Control of working of the subordinate court in dealing with the judicial order is exercised by way of appellate or revisional power or power of superintendence under Article 227. Orders of the civil court stand on a different footing from the orders of the authorities or tribunals or courts other than judicial or civil courts. While appellate or revisional jurisdiction is regulated by the statutes, power of superintendence under Article 227 is constitutional. The expression inferior court is not referable to the judicial courts, as rightly observed in the referring order number 1 in paragraph 26 and 27. The bench in Suryadev Rai, next parameters. The bench in Suryadev Rai also observed in paragraph 25 of its judgment that distinction between 226 and 227 stood almost obliterated. In paragraph 24 of the said judgment, distinction of the two articles has been noted. In view thereof, observation the scope of 226 and 227 was obliterated was not correct, as rightly observed by the referring bench in paragraph 32. We make it clear that although
Article 227 in the light of the Arbitration Act, not generally.
My lords, there are no judgments where my lords specifically, which my lords, that's why I said my lords will have to lay down the law. Well,
There are judgments when the High Court can interfere under 227.
Malas,
When
that
it
is,
goes to the root of the matter.
Malas, that is,
About the powers of the arbitrator and other things.
no,
But
Malas,
not in every.
that is if I'm challenging the proceedings before the arbitrator. There, Malas, there I understand. If an order is passed by an arbitrator, Malas, unless I show a blatant misuse of jurisdiction or Malas, a non-appreciation of a jurisdictional issue, then Malas, only in those two, the limited circumstance, this honorable court can interfere under 227. Malas, I am not before an arbitrator. I am before a civil court exercising 37's powers. All I am saying, Malas, is rightly or wrongly, the law, Malas, gives me that small leeway of filing an additional application. If, Malas, I show that something that ought to have been considered has not been considered, I filed that application, has come to be rejected. Now, Malas, the only way I can challenge that is under 227. Otherwise, Malas, I don't have any other remedy. And 37, Malas, I can't challenge it because 37 scope is either setting aside or not setting aside.
Yes. Your Lordship, kindly come to 34 minute. There is a judgment covered by this court, Malad.
Yes.
Flood. An arbitral award may be decided by a court only if party making the application establishes on the basis of the record of the arbitral tribunal. Flood. Now, your Lordships will kindly see what is the pleadings in the arbitration petition filed under section 34, Malad. Now he says that he paid 2 crore 80 lakhs. Sufficient opportunity was given to him to produce the document. No document was produced. The learned arbitrator gave a direction. This is the amount payable as the rental payable by him. Now he challenges it. What is the pleadings, your Lordship? I kindly see. There is no proper foundation in the pleading saying that he has paid that 2 crore. No evidence is produced, and he files an application 36(2). He comes before this court. This court gives a direction to dispose of in 3 months. And when the time of 3 months was about to expire, then he files an application to protract this proceeding, saying that I have pleaded 2 crore 8 lakh is paid, and therefore permit me to leave the evidence. But the trial court, Malad, has given reasons. Kindly see the reason given by the court, Malad. Malad, order at Malad is says.
Para 13 is the operative portion
I'll just
of the order.
Yeah, no, I'll read. The court has this. Malad, page 35, Malad. Para 3 onwards, Malad, page 34. The respondent want to have filed objections to the application. The brief averment of the objection as follows. The respondents have contended the application is not maintainable either in law and facts. It is contended that after amendment to section 34(2)(a) of the Arbitration Conciliation Act, the party challenging the award must establish statutory grounds on the basis of the record of the arbitral tribunal. Therefore, the additional evidence cannot be introduced proceeding under section 34 of the Act. The respondent contend that the learned arbitrator considered the statement and calculation furnished by the parties. According to them, petitioner filed memo dated 21/3/2024 stating that ad hoc payment of 16 lakh per month were being made, although minimum guaranteed rent payable under the lease deed was higher. The respondent further contend that sufficient opportunity was given to the petitioner before the arbitral tribunal to produce its records and calculation. The petitioner nevertheless failed to produce the proof of a lease payment. Then your Lordship may kindly refer the pair 3D next, Malad. It is further contended para 62 of the main petition, para 3D, Malad, page 36. The petitioner pleaded that witness had been cross-examined that the petitioner was paying the rent of 16 per month. However, the petitioner has not pleaded the entire amount of 2 crore 1 lakh 60,000 had been already been paid. Malad, on the basis of this, Malad, the issue frame, kindly see the reasons given by the court, Malad. These are all the judgment. Para 9 is the reasoning, page 38, Malad. Section 34(2)(a), page 38. Yes. Your Lordship, yes. Section 32 after amendment specifically requires the party making an application to establish stated grounds on the basis of the record of the arbitral tribunal. The statutory language indicates that the challenge under section 34 is ordinarily required to be decided on the basis of materials forming part. But all the judgments cited by him have been considered. The para 12, Malad, is the reason. The court may, page 39, Malad, court may in genuinely exceptional cases permitted the limited evidence when the grounds raised under section 34 cannot otherwise be established from the arbitral record. However, such power cannot be exercised
to enable the parties to repair the deficiencies in the present case presented before arbitrator, permit the party to produce the document which are available, withheld during the arbitration, introduce materially new pleas, convert section 34 proceedings to retrial, require the court to reconsider the merits underlying the monetary claim. The petitioner seeks to produce, your lordship, this is important, seeks to produce the bank statement obtained on 22/1/2026. Though the statements are stated to have been issued and downloaded on that day, if perpetrator transfer the allegedly made before passing an award on 24/12/2024. The relevant transactions it is actually made.
I've seen the order.
Yes. Therefore, my lord, he wanted to introduce a new ground altogether, produce an additional document is not permissible. My lord, now, for the purpose of, my lord, under 41 Rule 27, my lord, even in the civil suit, there has to be a foundational facts pleaded in the petition. There is no foundational facts pleaded in the petition. A barred statement. Your lordship may kindly see what is the basis for my friend to file. It is at page, my lord. The petition under 34/360 it starts, my lord. Volume 2. Millet is at page 383, Millet, volume 2, Millet.
Yes.
It's not a foundational facts to even supposing if it were to be a civil suit, courts have held, Millet, under 41 Rule 27, there must be a foundational facts, only on the foundational facts in the pleadings in the suit or an appeal that the application can be filed. This is the only bare statement your lordship has page 383 minutes. Yes.
Only minutes, only one minutes. Minutes may kindly take the claims made before the arbitrator. Minutes, the prayer for 2.8 crores was not made before the learned arbitrator. For them to now say that minutes, I should have produced it. Minutes, I cannot anticipate that the learned arbitrator would pass an award minutes without even hearing me on that. Minutes may kindly take the prayer for a moment. Only that minutes after that I'll rest my case.
But this court, Millet, has taken the view such applications are not maintainable, Millet. 2025-4 Karnataka law
That's
journal.
that Justice Suraj Godar's judgment minutes there. It was also minutes on the pre-amendment provisions where minutes the court had said there. In fact, the court said you have to take the evidence on record. Minutes may kindly take page 168. Minutes only the prayer. That prayer was not made. Minutes for the trial court to now say that I withheld it. Minutes how can I withhold something minutes when it is not even an issue before the court? The arbitral tribunal minutes, the claim was not made that pending till 11 months I had not made the rent payment of 2.8 crores. Minutes, the arbitrator records that during oral argument, a complaint is raised by the counsel for the claimant that I have not made the payment, therefore make the payment. Minutes, if it was a claim, issue was framed and evidence was laid, I would have minutes produced the bank statement saying I've made this payment. Minutes, without that, minutes, I cannot place the cart before the horse. Therefore, minutes, the trial court minutes is also hearing the matter. Minutes is again listed today. There is minutes after the deposit order was made, minutes direction has been issued. Minutes, if that minutes is minutes, my only difficulty is that. Therefore, minutes, the reason minutes I did not file the application to protect the proceedings. Minutes. Once minutes the deposit procedure was over, I filed the application.
Because I can understand what you are indicating, but I will not grant any stay because I'm not convinced.
Minutes, I have no other remedy. Minutes. And minutes, my difficulty is the arbitrator minutes had called upon me to lead positive evidence to show that I've made that payment. Minutes, I would have done so. Minutes, without prayer, without pleading, without evidence, without issue. Minutes, the 2 crore liability is fastened upon me. Minutes, I have nowhere way to go.
Several memos were filed. He also filed a memo of total payment.
Minutes, that's a different issue altogether. Minutes, the negotiation proceedings happen.
Reopen the case. He wants to read the evidence, which is virtually.
Minutes, they obtain.
Solve the proceedings of hearing. That is a simple.
Minutes, I have argued on 5 different dates before the trial court. Minutes, my senior may not say that I'm stalling the proceedings.
Wants to take protract the proceedings only that.
So the past 5 days I've been arguing the 34. It's not that minutes have protracted it. I'm only on this limited ground that minutes I should have gotten an opportunity to defend that minutes 2 crores. I can't be made to make the payment twice minutes for the same amounts of months of rent. That's all I'm saying. Please.
Let me mention matter. List number 1, sale number 110.
Great.
Compared for respondent number 1, your lordship. I have no objection to allow the writ petition because what they have sought for putting the initial on the documents which were marked in 2016, the learned judge has not put the initial.
My lordship,
is
I
the order
appear for the
repeated?
respondent number two,
Order
my
is at,
lordship. Even I have no objection
page
regarding
number
the same,
14.
my lordship.
Page number 14.
Appearing for the petitioner, my lordship.
14.
Petition has objection.
No objection,
Page
my
number,
lord.
Where is the order? Page
page
number?
number 14. madam.
Page number 14, I think, is not the order.
Relevant question is at page number 14. Yes, they furnished the same.
45 is the order. Why those documents are not signed by concerned bench clerk at relevant point of time?
Please,
That's the
madam.
order.
Ah,
Please come, the presented petition is filed. Agreed with the order passed in I number 1 of 2026, either number 1 of 2026, dated 29/1/2026. It's number 25593 of 2008 by the 28th additional City Civil Session Judge, Bangalore, CH-29. When the matter came up for hearing, before the trial court by order impugned have disposed of I number 1 of 2020. What this disposed of application, observing that on 30/8/2016, exhibit P1 to P63 were marked in evidence of PW1 inadvertently. Signatures or initials on documents not put. The plaintiff applied for certified copies and certified copies of exhibit P20 and P63 not provided as those exhibits were not signed. It is worth to note that, as stated by plaintiff, these exhibit P20 to P63 marked on 30/8/2016. There is no explanation or office note to say why these documents are not signed and why concerned bench clerk at relevant point of time not obtained signature on exhibits. Only after these explanations and office note by concerned official or concerned branch, initials or signature on exhibits to be considered. What is questioned? I don't understand in this. Yes, counsel for the petitioner.
What the learned judge want to say, my lord?
Huh?
Documents were marked in the year 2016. So the explanation
That's
is.
both of you can tell the court, the trial court. Why should I allow this?
Even I
petition?
mentioned I have no objection to allow the applications. Even then the said order has been passed.
No, what is there to interfere in this? That I'm not able to understand. Why
Yeah.
should I allow it even if you accept?
They have they have.
Yes. Who appears to the petitioner?
Soumya.
Lasya is appearing.
Counsel for the petitioner, my lord.
How are you agreed by this? I'm not able to understand.
Please, my lord.
My lords, the certified copies are not yet given in the lower courts because of this. That is why we approached the bench.
Learned judge has
Only what
observed
they
that
said, only after these office note by the
only after
concerned
explanation,
so and so, in view of the maid's application stands disposed of. When was this filed? On 13/4/2026. By this time, the applications must have been given to you.
Please.
That also you don't even verify. Please, the so and so application stands disposed of. Against that, the present writ petition is filed. This court do not find any reasons. There is no order addressed to the petitioner which needs to be interfered or set aside by this court. This court do not find any reasons. Dismissed.
List number 2, serial number 10. List number 2, serial number 10.
There was a case, Minots, where the suit for partition has been preferred. Now, Minots, genealogy is raking back to 1900s.
What is the urgency in this matter?
Minots, my written statement, Minots, I have not been permitted to file my written statement. I, Minots, have come on record only in the last leg of 2024. And
Please, where is the order?
Annexure A for a moment. Might your lordships come down to page 40, para 10. This is the operative portion.
Your order was set aside on 17/12/2024.
Yes, 17/12/24.
What are you doing from 24 till now?
Notes, I've just, for a moment, notes, if your lordship sees, I've pointed, I have pointed out, notes, this is a suit which predates notes genealogies prior to 1900s. And we needed some documents. And unfortunately, notes, the digitization is going on in the land records office, notes, which there was some problem. That is why, notes, we were not able to file a written statement in time. And very costly properties, notes, I'll have to tender my defense. I don't think, because none of us are related to each other.
No, on these grounds that you have to do something, the procedure, CPC will not give you permission eternally for filing this written statement. Suit of 2011.
Right.
Earlier, you were a set ex parte.
Yes.
17/12/2024 is
Right,
the
notes
order.
have come on.
Even after that also, you don't file the written statement.
Right, notes, there was, notes, if your lordship, I have extracted the order sheet for a moment, within the grounds itself for a moment, page 25. Now, notes, all along the suit is proceeding on a different count where, notes, it is, when I come, notes, it's already a defendant's evidence.
If you set ex parte, that is what will happen.
Correct, notes. I'm not saying, I'm
Can't
not.
stop because it's a suit of 2011.
And there are multiple defendants. Kindly see, notes, there are more than 40.
Tell one good reason, what were you doing from 2024? We'll forget about everything.
Yes.
2024
Illiteracy,
to
old age,
2020.
notes. I have to point out, notes, these are not moneyed litigants who know their knowledge well. Illiteracy, and notes, they required some nudge and assistance. The moment, notes, they have been able to get the record straight, they are before the court with a written statement. I intend to, I can finish all my part of the trial in under 40 days, notes, nothing more than that. Nothing more than 40 days, minutes. 2011 suit, your lordships have rightly pointed out. In under less than 40 days, minutes, my entire course of the case will be presented, and I'll be finishing my.
For doing anything, court has to know what are you doing from the last 2 years.
Minutes from 2025, if I have to say.
Not 2025.
Yes,
it is 2024.
2024.
17/12/2024.
Then, minutes, I think my time would have started by 1/3/25. If your lordship are looking at it, 1/3/25 or 11/3/25. From there. This is, I'm delayed by an year. I'm not saying I'm delayed by an year. What I'm pointing out that I have been belated by 1 year, almost 360 days. Here, I'm trying for the records which are not available, and I have expressed what is the case also. It's a case where 7 families are fighting out, saying that they were the Barabardars appointed under the scheme under the 1908 Act of the Mysore village abolition. Now, these records are not available, and this is this trace which we were trying to make out, the effort what we were making to fetch these records.
They will not be available for the next 10 years. You will not find the
no, but there are certain incidental records which we are able to find, because now they have been digitized. The scanning was going on, the records were not available in the revenue department.
But I don't find any reasons.
It's a valuable right of defense, ultimately.
2011 suit.
I have come on record. If I just let your lordship look at it in this way, if it was a suit for 2024, and once I came on somewhere like this, would your lordships have not permitted me? The suit is of 2011, all wrong addresses, I come to know of this suit because in another suit, which I successfully prosecuted and it went in my favor. There they come and say that there is another suit where this is pending. That is how I come to know, and I have filed my applications. I was ex parte and I was blissfully unaware because it.
Where is the application filed before the trial court explaining the delay?
For ex parte, annexure D for a
not ex parte, for this when you file this IA to take the written statement on
F is the IA 165.
Yes.
Just before that, if your lordship would see, the previous suit which I just pointed out now is at annexure E for a moment. It was during the course of this suit, in the final arguments there, they pointed out that this suit is available. This suit is going on, annexure E.
Asking in support of this IA, where is the affidavit? In support of this IA,
yes,
impugned IA.
Yes, ma'am.
Where is the affidavit?
Your lordships are looking at page 169. I'm sorry, 166. 166.
Yes.
166.
Let's see what are the reasons stated.
Para 3. Para 3. And I have set out the grounds plots at para 29, the
Can't,
reasons.
that is, we have to look at the
I
affidavit
understand,
that is filed.
I understand. Para 29 minutes after.
5 and 6, absolutely nothing. We have filed the above
It's been a bald affidavit. I know what your lordships are saying.
Yes.
And for one moment, if that is why minutes after in the writ, while your lordships could just see page 29. May I persuade your lordships to just see page 29?
No, we are
Page
not-
29,
we
only
are
for
under
one
two-
moment.
We are under 227.
Minutes,
What
I
you say
totally
before
admit
the
I am
court
at your
doesn't
lordship's
matter.
mercy. I am also saying I am at your lordship's mercy.
We can only look at the order and the affidavit
Right,
that is
Minutes, I
filed
am at
before
your
the
lordship's
court.
mercy for a moment.
Not
But
for the, what you have said so
right,
in
Minutes,
this
but
petition.
Minutes,
So we
some
can't
lawyer
improve
makes
the
a
case.
mistake there before the court, Minutes, in not elaborating the facts. And we are trying to not bring the same set of facts in the writ court. Minutes, your lordships are not powerless to take this. That is why Minutes 29 for one moment. I have explained Minutes what is it. Only two grounds if your lordships could have a look at it for one. Could your lordship just go to para 12 for a moment? May I read that for my lordship? It is submitted that it could be seen. The suit in question involves multifarious claims of various families wherein the claims predate 1940s. The family information prior to 1940s is required for the said case. It is submitted that considerable time has been spent only for the purpose of scouting documents, and considerable time was consumed in the process of collecting and compiling the relevant documents. Further, since the exercise of digitization and scanning of records were undertaken between the years 2023 and 2025, substantial number of records were not readily available during the said period. Consequently, there was an inordinate delay in obtaining the required information, particularly in matters involving revenue disputes where records pertaining to periods prior to 1968 were required to be produced before this court. Then it is submitted that in the current case, it could be seen that the genealogy explained by the plaintiff pertains to families of 7 office holders of the office of Toti of the village of Hebal. As per the scheme of enactment, the office holders for the village offices were crystallized by Mysore Village Officers Act 1908 in terms of the list of office holders recognized as recognized in Barabaluti register. The case of the plaintiff runs on the premise that there were 7 office holders and each office holder's family is sought to be narrated, and further it has been clarified that all the said office holders were co-parceners at a previous point of time. In other words, the family tree claim of the plaintiff not only predates 1940s but predates 1900s. This is the crux of the issue. This is the crux of the issue. And if from 1900 the information is mandatorily required at least to place my defense on record. That is why I'm saying, I'm just pointing out, yes, there has been a delay. I'm not saying there has not been a delay, or I would not say I am 100% within my mark, but I'm pointing out for the reasons there, or for such reasons, my right of defense should not be taken away. Ultimately, even if this goes away, in an appeal, it should not lead to multiplicity of proceedings. I may be put on terms, some reasonable cost.
Let other side come, we will see.
The other side has been served, and my only request is, now this matter will be posted for arguments has been complete, almost complete. I'm not saying that all further proceedings should be stayed, but let not the judgment be pronounced. Judgment is not for the stage of judgment, but if left it will be posted for judgment. Then it will become infructuous in this way or that way. That is why let the other side come. I have made my effort of serving the advocate also.
What is the stage of the proceedings now?
Final arguments of the defendants are to be.
At the time of final arguments, what will you do by filing the written statement?
Sir, my defense of what is there, let it come on record. Nothing more than that.
That's what the court also said.
But that my defense of what exactly the case is.
Oh, you filed the written statement. Now what will the court do?
I am just
final argument.
I'll address my argument. Your lordship may take the statement, because I don't have much of an evidence apart from stating my defense. A denial to that effect and exposing what is the true fact. That is all I want, because there are other defendants also who are contesting. tomorrow, my lords, in case they
No, what you're
collude in
submitting is you will file the written statement and you will just, you will not adduce any evidence and you will only adduce arguments.
in the current case on hand, evidence has been adduced by the other defendants. I may not have much there. That is why.
Petition is permitted to take out hands.
It has been done, my lords. That has been
Yes,
done.
sir.
That has been done. That has been done. I have taken that. That exercise has been complete.
Then I'll pass the final order.
Could your lordships have a look, because I'll make one more endeavor to secure the advocate from the trial court if possible. If it is had tomorrow in the first list, I'll request them. Because
But I'm indicating I'm not convinced.
I understand that your lordships are looking at the technicality there, but a larger, I think a beneficial.
Yes.
Tell number 12. Tell number 12. Memo for withdrawal.
Is it tomorrow in the first? Can it be in the first list so that I can intimate?
For the
Yes.
respondent.
And for the petitioner in this matter,
As the
filed the
award
memo
has
for
been set
withdrawal.
aside by my lords 37, during which this honorable court, my lords, they want to withdraw the petition, my lords, I have no difficulty.
No, he says some liberty.
My lords, there
Yes,
was
my
a
lords.
5 crore
So,
deposit.
Dismiss or petition has withdrawn. Registry to refund a sum of rupees. How much it is? 5 crore.
That's,
Deposit
in order
was
to
made
grant an
pursuant
order
to
of
minutes.
interim order, this court had imposed a condition stating that a deposit of
By
rupees
seeking to
5
withdraw the
crores to be
petition, it
made.
is submitted that an amount of rupees 5 lakhs is
5 crore minutes.
5
5
crores,
crores
my
is
lords.
before this court, is deposited before this court by virtue of an interim order granted. And the petitioner wants to withdraw this, may be permitted to withdraw the may be